Doesn't seem like it. I don't think they're hearing us.
We just heard that.
Oh, you did? You did hear us?
I can hear you.
All right, wonderful. We're waiting on Dr. Mitchell. He went to the wrong place on the panel, and as soon as he gets here, we can begin. That's all right.
Fair enough.
Yeah, do we have a copy of the agenda that we put out?
I can take it.
So make sure I'm following it.
Okay.
I know there's a couple more things on there. So. Thank you, ma'am.
You're welcome. Test. 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 Test.
Dr. Mitchell, say how long it would be? One? Wonder where he went, down to Decatur?
They gave me this.
Okay. 335-3857. And I'll be here the whole time. I'll just be somewhere in the building. I'm Jerry.
Jerry, okay, thank you so much, Jerry.
Anything that happens, just call me and I'll
Okay,
30 minutes.
Thank you.
Yeah,
Travel time?
yeah, if everything's okay, it's 30.
Yeah, assuming with COVID traffic, although. Well, 16 on Saturday, and we got stopped like an hour.
Oh, we don't, ready till they headed down.
Yeah,
Yeah.
yeah,
Mhm.
coming out of, or coming into Macon.
Yep.
37. Yeah, I was.
Yeah.
They gonna raise it? No. Stay on. Try to do it if you don't.
Probably better.
Those, state boys, watch the Braves game too, and it's just like, you don't realize how important the crowds are. It's just quiet. Where?
Yeah.
Yeah.
sure it's not work, because it takes a long time. How was it? Let's see. Okay, perfect. That's better. All right, so all you gotta do is open the document. Read. So you notice I can share my full screen, or I can just share it. Share. Share. Okay.
Perfect, thank you.
You're very welcome.
Mr. Mitchell,
Yes,
can you hear me?
can.
Do you want to, while we're waiting, do you want to step outside? I have a 2-minute conversation to have with you that's probably better as a sidebar.
Sure.
I'll just call you on your cell phone if that works.
I'll be fine.
All right, thanks.
Thank you.
We got a bunch of Mitchell. All right, you're gonna be Mitchell one. Mitchell two, Mitchell three. Good.
We're not settled, if that's what you were up.
You- No, we're gonna milk it a while longer out there. Got at least lunch, got free lunch. I'm not cheap, but I can be had.
That's always the thing about mediating and ending, you never wanted to settle your case before lunch.
That's right.
You always had great bread.
Gotta get those cookies, man.
Let me say that.
Oh, you're not
in the
supposed to be listening, whoever that is, just cut it out.
Now, while Veritext is listening, I will note that one of their competitor court reporter services gives away cookies. I don't remember their name, but I know them as the cookie court reporters.
Seemed to me that would be a good marketing ploy, wouldn't it?
I've got my first witness here, I'm gonna let him know what's going on.
I'm gonna call, see if Dr. Mitchell, where he's at.
So while we're waiting, this is the court reporter. Can you hear me?
Yes.
So who are the arbitrators? Where are they at in the room?
Son.
Okay.
Dr. Mitchell, Bob
And-
Woodford. Hey, how far away are you?
So there are, it's a five-person panel.
Uh-huh.
And
Oh,
Can I
I
get your
see.
name?
See you soon, then. Thanks. All right.
Just give the panelists know.
Okay, we're gonna have an introduction in a minute, so one's on the way. Can we just wait till that? Is that okay, or you need it beforehand? Or I can tell
No,
you, can you see this? I guess you can. All right.
No, I can't. I've been-
How's that?
Well,
Dr.
raise your
Charles,
hand.
you want
Go
me to read it to you? Dr.
Yep.
Charles Mitchell, Troy State University, or Troy University. Bob Weatherford, Cobb County. Chairman Charles Glass, Lamar County. Councilman Errol Mitchell from Hampton. Councilman Eric Christ from Peachtree Corners, that is the panelist. And we also have Mr. James Elliott, who is our attorney representing the panel. That's this side of the table.
Dr. Mitchell's not here, right?
Correct, he's
Yeah.
5 minutes away.
There. We've got an update.
All right.
I just called him.
All right, great.
He said he was over all the roads. Right.
Thank you.
Yes, ma'am.
You sent an email yesterday, a letter, that in the binder, the letter outlining counties coming. Oh, all right. That one didn't make it. That was August 24th. Okay. Right, 'cause that's your, that wasn't in response to the motion, that's just your overall case summary, essentially. But I was on the road yesterday, so I didn't have a chance to read that one, so rather than try to read on my phone, I was gonna look in here, but to your point, not in there yet.
There he is. Good morning. Good morning.
Sorry.
This one.
Okay. Buzz here, so we got everybody we need here to start?
Keona's making some copies.
Okay. Good morning, we're gonna get started in just a minute. Can everybody hear me on Zoom?
Yes, sir.
All right, good. First thing I want to do is make sure, I guess, we have all the oaths turned in, and we know that.
She'll be in a moment.
Okay. I didn't know if you were placing her or not.
Take your seat.
Do you have all the oaths, ma'am, from everyone?
Do I have all the?
All the oaths?
Oh, no, I still need oaths from So I got the oath from, of course, Chairman Weatherford and Mr. Charles Mitchell. And that's it. I didn't get anybody.
You didn't get mine.
I don't.
Do you have a form we're gonna vote?
I have a form, yes, I can print out some forms.
So
Yeah,
we,
Ken, I sent
You sent it?
to you on,
Hold on, go back.
yeah, because I thought everyone had sent it in, so maybe got it.
and you, here it is. I sent it to Kiana and copied Bob on
Okay.
July 29th.
We'll go back.
We got three, Councilman Mitchell, did you turn yours in? And you turned it? Yeah. So let's get an extra one and, go ahead and get that
Sign
done.
another one.
I'm happy to sign it again.
Yeah. Yes, we can do that.
All right, if you don't mind, while we're doing that, let's have everyone introduce themselves on the panel, and, I guess we'll start with, Councilman Chris.
Sure. Here at the end of the table, I'm Councilman Eric Christ. I've been on the City Council for City of Peachtree Corners, right to the east here at Roswell, since 2016. Was certified as an annexation panelist a year and a half ago, and well, I've offered to sit on several panels. This is the only one. That's my first one being seated on a panel. So, thank you.
Good.
Well, my name is Errol Mitchell, from the city of Hampton. This is my first time on the panel, and it's excited to be here. My third year is at the City Council of Hampton.
Good.
Hi, I'm Charles Mitchell. I'm with Troy University. I think this is my third session. I've been with Troy University for about 14 years. Prior to that, I was with the United States Equal Employment Opportunity Commission, working in government, and delighted to be here, work with all of you.
Good. Thank you. Chairman?
I'm Charles Glass from Lamar County. I've been on the commission 10 years now. I'm in my third term. This is my first panel to sit on. I've been qualified for a couple of years, I think. This is the first one I've actually been called to attend, so.
Good, thank you. And I'm Bob Weatherford from Cobb County. This will be my sixth hearing, I believe, and I was first certified in 2008 in arbitration panel. Then I was on City Council of Ackworth, and then since moved to Cobb County as a commissioner. So I've done both sides. So I'm pretty familiar with that, but we're happy to be here. And because of the extra motions that have been presented in this case, the parties have decided to hire us outside counsel, and we have Mr. James Elliott here to represent the panel today for anything that we might need, since it certainly goes beyond my knowledge of legal profession. So that's the panel, and then do you think we should introduce everyone, or is everybody else? We've already done that on the Zoom meeting, I think, even though, so.
I'm happy to.
All right, let's do that.
My name is Thomas Mitchell, and I'm outside counsel representing DeKalb County here. I wanted to let you know that the county attorney, Vivian Ernstis, had planned to at least appear this morning, but the DeKalb County Board of Commissioners meets this morning, and she is tied up with them.
Okay.
The Deputy County Attorney, Matt Welch, had also intended to zoom in, but he's having connectivity issues at his location, so they wanted me to send their regards.
Okay.
I'm assisted today by Shelley Romo and John Jones.
This is John.
Yes.
Okay, thank you.
This is Shelley.
Good morning.
All right, Mr. Ash?
Good morning, everybody. I'm Robbie Ash. I'm an attorney with Bondurant, Mixon, Elmore, and I'm here on behalf of the city of Brookhaven. Glad to see you all.
Good morning, everyone.
Yeah.
My name is Jennifer Peterson. I'm also an attorney with the Bondurant firm as outside counsel for the city of Brookhaven.
Perfect.
My name is Chris Balch. I'm the city attorney for Brookhaven.
Thank you. And And then we have Ms. Letts as the court reporter, I'm assuming. And I believe that's it. Good, thank you. All right, we'll get any remaining oaths that we have not gotten, and that'll be done certainly post haste. With that said, I will like to call this hearing to order, and it is the arbitration hearing on 8/25, and we're starting at 9:45 a.m. in Roswell, Georgia. 20 Mansell Court is the location. We're under the authority of Article 7, Chapter 36 of Title 36 of the Georgia Code to hear the matters concerning DeKalb County versus the City of Brookhaven for the Briarcliff annexation. We do have a court reporter that will be taking minutes of everything that is said today, so I'll remind everyone to make sure you use verbal statements as opposed to hand gestures, whatever, so you can record that properly. We've all received plenty of documentation here in front of us, so I don't think we're going to be missing any of that. The role of this panel is to be fair and impartial and neutral. And our job is to deliberate, hear both sides, and to try and make a determination as to a ruling as to what should be the outcome of this arbitration hearing. Because, again, as I mentioned before, that we had other motions that came into play which have been beyond what I've done in the past, we appreciate both parties hiring Mr. Elliott to assist us with that, and so we may consult with him from time to time, and especially if we need to go into executive session to discuss the motions to dismiss. And that's pretty much what I have. Any of the panel want to have anything else before we get started? So. All right, my intention is to follow the agenda. The first item on the agenda is approval of the minutes for July 22nd, 2020. That was a case management meeting we did by Zoom, and all of us have seen that and I think approved. I would entertain a motion from one of the panel members to approve the minutes as presented.
So moved. Charles Glass.
Got a motion from Chairman Glass. Got a second?
Second, Harold Mitchell.
All right. Any discussion? All in favor, say aye.
Aye.
All opposed? Let the record show that the approval of the minutes passed unanimously. The second item on the agenda today is the motions to dismiss, and what Mr. Elliott and myself have come up with is that we will give each side 10 minutes to present their case. We have all had the written documentation sent to us and hopefully have reviewed it at least in some form or another before this meeting. And we'll let each one present for up to 10 minutes. And then I would request, and I'll request a recess to go into executive session to discuss that. Then we'll come back and make our ruling. Depending on the outcome of that ruling, we'll either proceed with the hearing or we will be through with the hearing. So that's where we are. So, Mr. Mitchell, would you like to start on behalf?
Question, Mr. Chair, you talked 10 minutes for Mr. Mitchell present with the city have an opportunity to provide some rebuttal. Similarly, 10 minutes.
Correct. 10 minutes on each side.
On each side for each motion.
Correct.
For the two. Okay.
Sorry. Mr. Mitchell?
Morning, panel. My name is Thomas Mitchell. I'm here on behalf of DeKalb County. I'm going to be arguing the county's motion to dismiss, and then at the appropriate time, we'll be responding to the city's motion to dismiss. And I'm going to be brief. We'd actually thought that there was going to be 10 minutes both motions. So, as the chairman alluded to, the matter's been well briefed. I know that you all have read those. We think that the documents that we filed are sufficient. I want to underscore a couple things, though, and offer myself for questions if you all have them. The statute that we're here under requires that the city to notify the governing authority. And then there is a local act of the state legislature, which is also state law, that establishes the governmental organization of DeKalb County. And it is unusual, it is different than other counties in the state of Georgia. And it has an executive, which is the CEO, which is part of it, which is the governing authority, and it has a legislative branch, which is the BOC, which is also defined in the state law, in the local act, the organizational act, as the governing authority. The CEO is not a member of the Board of Commissioners. He has no authority to direct their activities. Under the organizational act, he has no authority with regard to zoning and land use. Oftentimes, he doesn't attend the meetings unless he's requested to attend the meetings or he's there to present. And that, again, that is the form of government that the legislature established, and we feel that it needs to be respected. And as a result, under the annexation statute, both the entire governing authority of DeKalb County needed to be notified, and that was both the CEO and the BOC, and the BOC did not receive notification. It only went to the CEO. You might understand how that might be problematic under certain circumstances. It ought to be respected. The cases that where a mayor or a chair in other counties is served and that is sufficient, that simply doesn't apply here. The organizational act of DeKalb County, Georgia, says defines the governing authority as CEO and BOC, the Board of Commissioners. The Board of Commissioners the city did not notify the Board of Commissioners. We raised it early. The county raised it early, raised it in January, raised it in February, raised it in March. Here's the thing. The city could have fixed it. Could have fixed it at any point along the way by providing the proper notification, but they did not. And so as a result, the arguments regarding waiver, what have you, it is not true. The county raised it early, the city could have fixed it, and they refused to do so. And that's the sum of the argument. I'm happy to answer any questions that the chair of the panel might have.
Okay. Any panel members have any questions for Mr. Mitchell?
Talk about notifying the governing authority. Is there statutory or case law related to it? How that notification is done? Does it require a face-to-face meeting with each member of the governing authority?
The annexation statute requires it to be served by the notification be given by statutory overnight.
Right, but does it specify that each member of the governing authority receives such notice?
Well, it requires the governing authority to receive the notice, and again, under the local act that sets up the government of DeKalb County, the governing authority is the CEO and it's the BOC, the Board of Commissioners. The Board of Commissioners do not receive statutory overnight delivery of the notice of the annexation.
And is your contention that overnight delivery would require individual overnight deliveries to each member of the Board of Commissioners?
Yes.
And at which address?
Well, their home addresses or the...
Sure. Why did the city attorney ask them to vote on an objection on January 7th if they hadn't been properly notified?
Well, because there's 30 days to file an objection, and in order to not waive any rights that the county may have, they felt the need to authorize that objection. But that doesn't cure the lack of proper notice, simply because DeKalb County responded does not cure the fact that the Board of Commissioners, that part of the governing authority, did not receive notice.
And why request an arbitration if this matter wasn't properly notified?
Well, once the objection was provided to the city, that initiated the arbitration process, and the county raised it with the BCA as well, and again raised it with the city. Could have been cured, but once that objection was provided to the city, that's what initiated this process.
Right. It wasn't a formal request for arbitration. It was the filing of the objection triggered the arbitration process.
Any other questions? I have.
You mentioned about notifying a mayor or a chairman. Is that the normal process?
Well, in civil service, there are certain rules, and sometimes city charters or other county organizational acts may provide for different types of service. But again, we have the annexation statute itself provides how the notice is done, statutory overnight delivery, and provides who needs to receive that notice, and it's the governing authority. And in this particular case, the governing authority of DeKalb County is both the CEO and the Board of Commissioners.
All right, so you stated that, well, I know in Cobb, we don't get it eventually, individually, we get it as a group, and then it's disseminated by staff that we received an annexation request.
Right.
And the county manager, I assume you have a county manager as well as a CEO?
No, there's actually a chief operating officer.
Oh, so he is technically the county manager.
That's not his position, that's not his role. He does other things. I mean, again, it's a unique form of government that was established by the
Yeah,
legislature.
that's right. Isn't it like Atlanta has a strong mayor and independent executive mayor? They have an independent, the only county in the state,
That's what I understand.
Right.
Yeah. So the BOC had to vote on to object to this annexation, did they not?
Under the law, there had to be a vote by the.
And when was that done?
That was done on January 7th.
All right. But your contention is they weren't notified of the annexation, yet they voted on it.
Our contention is that the annexation statute, there's few defenses, if you will, that a county has to annexation. That's just the way the law is set up. One of the things that the law does provide is that the governing authority of the county is to receive proper notice. And in DeKalb County, in this particular circumstances, the governing authority did not receive the statutorily required notice. And
that's not to say they weren't aware of it, they just didn't receive the proper notice.
And in the first filing that I provided to you all, there was a long footnote towards the end of this section that talked about actual, even in the civil service context, actual notice does not cure bad service.
Okay.
Especially if it's raised, and it was raised with the city, raised with the DCA, and again, could have been fixed and they refused.
So,
as I recall reading one of the submissions, your purpose in having us to dismiss this is to start anew. Is that correct? Have them resubmit things such that we can start this panel process again and move forward. Suggesting that someone has been harmed by the process that has occurred so far. What harm has come forth to the county such that you cannot have us proceed as we are now? It seems to me that the county official, the citizens of DeKalb, Brookhaven, none of them are benefiting from having to redo this entire process. So, has some harm been done such that you cannot adequately put forth a objection to this? I don't see the...
Two answers to that. One is that, again, this is a special statutory proceeding, and there is a specific way the notice is to be done. And so, what you're referring to is what lawyers call harmless error doesn't apply here. They didn't, especially in this context, there are rules that need to be followed, and they didn't follow the rules. They didn't give, it's a local act, the city's on notice of what's required, what the governing authority of DeKalb is, and they didn't give notice to the governing authority. Whether or not the city reinstitutes these proceedings or not, or does it in a different form, that's really not the question. But more importantly, there is harm because the city failed to respect what the legislature put into place as the governing authority of DeKalb County, and the Board of Commissioners, by not receiving the notice and then the city not respecting their position, there's harm there.
Can you, Mr. Mitchell, can you give us, I know you've had other annexation requests in the past. Did they follow those procedures? as the city of Atlanta versus the,
Um,
or can you recall?
I was not involved in those, so, all I can do is, I know those went forward, but I do not know. I don't know the answer.
So you don't know of any other annexation requests to the county that did follow these, notices that you're requesting?
As far as I know, and as far as I'm aware, previous annexations have followed the proper rules.
Okay, any other questions, Rick?
Yeah, the county attorney, who hires the county attorney? Who does the county attorney work for? Is it the Board of Commissioners, the CEO?
She reports to both. Is she appointed and confirmed?
Second, she protection laws, the and
I think she reports to both. Who actually makes the decision? I mean, we can look at the.
Yeah, no, yeah, just curious, yeah, is she a part of the Board of Commissioner side of the, because of their strange structure, right? Is she, yeah, or is she in between the two of them?
She represents and answers both.
Right, so she is the chief legal officer for the county. She represents the Board of Commissioners in legal disputes. She also represents the CEO. If somebody sues the CEO in his capacity as CEO, presumably the county attorney.
Or provides counsel.
I can tell you, Chris, from the county, Record counties,
Right.
it doesn't have that structure that the county attorney, the county manager, the court, the
Clerk, or the
clerk,
right?
all report to the VOC.
Right.
Because we had to do their reviews every year.
Yeah.
And there was one other, I'm trying to remember. But at least those three definitely report, and your admin, if you had those.
Right.
So those reported directly to the VOC and were confirmed by the VOC. I'm not certain how that works because the CEO is elected as opposed to being hired or appointed by the
CEO is
VOC.
elected countywide.
So, okay, any other questions?
Question, you mentioned the BOC and the commission. What was the final decision?
Who is the final decision to,
Between the CEO and the Board of Commissioners.
well, they're in the Organizational Act, which is in the books in front of you, there's a list of, I think it's section 9, there's a list of the powers and duties of the Board of Commissioners. And there's another section that lists the powers and duties of the CEO. Basically, the Board of Commissioners enacts ordinances and policies. The CEO, in certain circumstances, has veto power, but when it comes to land use and zoning, or with regard to the operational policies of the Board of Commissioners, he does not have veto power. So it's a true legislative executive branch form of government.
Mr. Ash, are you there?
Good morning, gentlemen. My name is Jennifer Peterson for the county. I'm sorry, for the city, and I'm actually prepared to respond first to the county's motion to dismiss. And
Go ahead.
if I may, I'll respond first before we turn to the city's own motion. I appreciate everyone's insightful questions trying to parse the role and differences among the branches of Dekalb County government, but it actually all misses the point. The point here is that the city's notices to the county substantially complied with the statute's requirements. Substantial compliance is all that is required, and the city has done that at the very least. Furthermore, because this entire proceeding is the county's prerogative to demand, it is our position that the county has waived its objections in this area by waiting until the 11th hour to re-raise it and by proceeding as if it had been properly notified. So substantial compliance, that is the standard here. Lindsay, if you could put up the statute, OCGA 1-3-1C lays this out pretty clearly. Let's see if we have it here. Well, I'll go ahead and read it. It says, a substantial compliance with any statutory retirement, especially on the part of public officers, shall be deemed and held sufficient. And fortunately, we don't have to wonder what substantial compliance means in this context, because elsewhere, Georgia law has been pretty clear on what constitutes substantial compliance, what a statute requires notice to, quote, the governing authority. For decades, the ante-litem notice statute required notice to the governing authority, and Georgia courts consistently held that substantial compliance was the standard, and that substantial compliance was satisfied as long as the notice was addressed to and received by a city or county department or official, as long as the city or county was actually put on notice. This was the standard for decades and decades, notwithstanding any number of local acts that may be on the books that further define what the governing authority is. There's no real dispute here that the county was put on notice about this annexation. As we've discussed, the Board of Commissioners was able to consider and vote on the proposal on January 7th. Let me also add that at least with respect to the city of Brookhaven and the county, notice to the CEO and the county attorney was the prevailing practice for the several past years in past annexations. So to answer that question, that was the customary and accepted practice. This county has never complained before this proceeding that that was insufficient. Moreover, we sent the amended notice on February 20th. You have that in your binder as well, and that cleared up some of the alleged technical difficulties that the county had pointed out with the original submission. We sent that to the county attorney because that too is the accepted practice. It is customary for parties who are represented by counsel to communicate through their counsel. So in our briefing, you'll find other cases and statutes that talk about substantial compliance, what that means, particularly in the context of annexation. But the takeaway here is that the county did have actual notice. It's also important to note that the county has indeed not shown how it's been harmed by any deficient notice. Like I said, we cleared up any arguable ambiguities by sending an amended notice in February. And in that February letter, we actually wrote this. We wrote, "Please advise if this form of transmission is insufficient in your judgment." No reply. Instead, the county's waited until just now to raise this issue. They could have done so before y'all were appointed or before our first meeting. We did recently learn that they tried to raise it with the Department of Community Affairs back in January. And DCA's lawyer said, we'll be in touch about appointing a panel, and they did, and here we are. The county's delay, especially given the actual functional notice here, means that they have waived this objection. So here we all are. This arbitration panel is a creature of statute. It has only the powers and the discretion afforded to it by that statute. And importantly, the statute does not give the panel the option to decide not to hear a case once it's been appointed and duly sworn. The city would respectfully ask you to fulfill your duty here and deny the county's motion to dismiss. Any questions on that?
Oh, yeah.
Sure. If we can't not hear a case, then how can we vote to take any action on the county's motion to dismiss?
It is the city's position that you just don't have the discretion to not hear the case. So it is our suggestion that you would proceed to the next step. And if there is an error of law or fact, the statute provides for an appeal to the Superior Court, who it appears would have the ability to address any kind of errors that the panel may not have had the authority to.
Right, but is it your position that we shouldn't even vote on the motion to dismiss?
We would ask you to vote to deny it and just so that we can move on to the next item on the agenda.
Any other questions? City have anything else? I'm sorry, Chairman.
That sounded like we didn't have authority to vote on it. We had to hear the case, and therefore the whole motion was moot. I don't understand.
Well,
how you get to that argument.
Because it's been placed on the agenda, I do believe that it will require some action by the panel to actually move on to the next agenda meeting item.
Okay.
Well, if there's no other...
Okay, does the city have anything else, or are we ready to go to executive session, I think?
So the city does have our own motion to present, and if there's no further questions on the county's motion, I would like to move on to that.
Right, the city's motion is the motion to dismiss the motion,
No,
correct?
no. You do have a letter in the packet of exhibits that has been sent around, but I'll go ahead and explain it. We have styled it our own motion to dismiss, but we're not asking you to decline to hear the matter the way the county is. We are asking for a threshold determination that the county has not submitted a proper objection to this annexation. That is actually a prerequisite to a decision by this panel about the merits of those objections. So it is an issue, a separate issue that the panel needs to decide today before we can move on.
That's a normal part of, arbitration panels, isn't it?
Yeah, that is a normal process. It is, how many, and it's 7 days or 10 days they have to respond? Is that what it is?
The statute gives them 30 days to object by majority vote of the governing authority. And it is the city's position that that did not properly happen as the statute requires. I'd be happy to explain that. Could we actually start by taking a look at the annexation handbook, if we have that? It's in your binders at tab 30, and the verdict form, I think, lays this out extremely well. This threshold determination that the panel needs to make before it gets really to the merits of the objections. Here we go. We do have that at tab 30 in your binder. This is page 31 of the arbitration handbook, and I've been calling it the verdict form.
Hold a second. My tab 30 is a sewer action plan. So,
You're talking about your handout or the arbitration handbook?
This is in the city's white binder, but if you have a copy of the arbitration handbook.
No, it's in this handbook. Okay.
I only have.
Hold on 1 second, I'm not sure.
It's in our annexation handbook.
Hold on, Jennifer, I don't think they have these binders yet.
I've got that.
Our apologies.
Right. Please let me pause while the binders are passed out. The city did provide a binder for
We
each.
found it. It's in the.
There we go.
Thank you. We
These
were
two bucks are from the county. Okay, all right. That's it. I thought we discussed doing.
The city wasn't here to pass out their book. Wait a minute, I think I got it.
I need one.
Okay.
I was just going to say, for the record, our motion was emailed to the panel on the morning of August 18th.
Yes, sir. I remember all. Well, we have that notice in our handbooks if you want to go ahead and Ms. Peters.
very good. Either way, we can put it up on the screen for you as well.
I'm saying for the benefit of the attorney, I think going forward, we'll need to refer to the exhibits in the white binder, which would be the cities or the black binders, because we have overlapping tab numbers.
Very well.
We have dueling binders.
We'll try to remember that. Thank you. So again, I'd like to look at page 31 of the arbitration handbook, or it's tab 30 in the white binder. This first page of the verdict form is exactly what our motion that we emailed on August 18th concerns. Top of page 31, it reads, the county must assert a proper objection with respect to a proposed annexation. This propriety question here is only about the county's initial assertion of the objection. And in this case, that was back in January of 2020. Because all of that happened in January 2020, it is certainly ripe for review and decision now. So the handbook goes on to explain what it means to assert a proper objection. For the objection to be proper, the decision to object must be made by majority vote of the county governing authority in an open meeting and based on one of the stated grounds for objection. So I'll unpack that a little bit, but let me note that the county has noted in its briefing that it believes that this handbook interpretation of the statute is wrong. And for the record, we disagree with that. ACCG and GMA wrote the statute, wrote the handbook, and we think that this is a textually correct interpretation of the statute. Could we put the statute up? It is OCGA 36-36-113. We have, that is in the handbook as well. The handbook has helpfully excerpted the entire statute governing these proceedings. So let's look at 113A. This is the statute where that requirement comes from. The county governing authority may by majority vote object to the annexation because of a material increase in burden upon the county directly related to any one or more of the following. Legally, it appears that the county would like to put a paragraph break in the middle of the sentence and say, the county governing authority may, by majority vote, object to the annexation, period, full stop, and then move that because clause somewhere else. But when you look at the text of the statute, it is clear that these requirements do apply to the county's actual vote to object. So let's take a minute and talk about that vote. It is the city's position that Dekalb has failed to assert a proper objection here in at least 3 ways. The first 2 are very clear in the video of the January 7th commission meeting, in which the Board of Commissioners discussed and then voted on these objections. The first problem is an open meeting violation. The meeting begins with a motion to amend the agenda to include this item right off the bat. We do have the minutes of that meeting for you at tab 6 in the white binder, so that you can see how that went down. Thank you, Lindsay. Motion was made that this agenda item be to, actually, could we go up to the previous item, Lindsay? Well, if you have this minute in your tab 6, we're on page 3 of tab 6. The previous item here is amending the agenda to add this item. It's number 46 at the top, that this agenda item be approved to add an item. It is the city's position that this last minute addition to the agenda violated the Open Meetings Act. And so this vote is just not binding and not proper. But the second problem is actually the more serious one for why we're here today. Not that the Open Meetings Act is not serious. The second problem is that the vote to object is not based on one of the statutory grounds for objection. It just wasn't. What happened was the commission voted blindly to authorize the county attorney to send the objection letter. No grounds whatsoever. And no grounds even made it into the minutes in hindsight either. Could we have the minutes back up? Well, I think sometimes in hindsight, these things do get cleared up, but you'll see that here is what the minutes actually say about what the County Board of Commissioners voted. Here it is. Motion was made, seconded, that this agenda item be to approve the county attorney to file objections to the annexation petitions in a substance approved by the chief operating officer and in a form acceptable to the county attorney. There's no grounds here. This is a blind blanket authorization, and that is not what this statute requires. If you go ahead and watch the video, I'd be happy to put that up after I'm done with my comments here. If for folks who have not seen it, you'll see that not only was the vote not based on a statutory ground, the Board of Commissioners does not even discuss any of them. If you've seen the video already, you'll remember there's a lot of talk about the evils of annexation generally. There's some talk about effects on tax revenue. Well, neither one of those is a statutory ground that can be brought before this panel. So I said there were three failures to make a proper objection: open meetings, vote not based on grounds. And the third one, if we could pull the handbook back up, I will show you what is required that was not fulfilled here. At page 31 of the verdict form, on the third paragraph, thank you, Lindsay, the county must provide evidence of any financial impact forming the basis of the objection. And the statute is actually a little bit more specific. 113C requires that the county provide evidence of financial impact to the city within 30 days. So in that initial objection letter. Well, you have in your white binder at tab 7, the county's objection letter. That's the only thing that the county sent in that first 30 days. And you'll find that it contains no evidence of financial impact whatsoever. So for all these reasons, it's the city's position that the county cannot get past the first hurdle in this arbitration. Could we pull that verdict form up one more time from the arbitration handbook? Thank you. The last sentence of that third paragraph, if any of these requirements are not met, the objection is not proper. I believe that's where we are. Now, in the briefing you received, the county has come back and said, well, hey, if the city gets to claim substantial compliance with statutory requirements, so do we. Well, that doesn't work here, and here's why. Substantial compliance, like I've talked about, is about meaningful notice. And as I've argued, the city's notice about this annexation did put the county on notice, and it was able to respond. We know that because it voted to and did. By contrast, the county's objection did not substantially comply even because it did not put the city on notice about what we needed to hear and respond to in this arbitration process. Again, you can read the county's actual objection at tab 7. There's nothing in it that lets the city know what kind of zoning or land use conditions that the county might be asking this panel to impose. To be quite honest with you, the city still doesn't know what the county's going to ask for here. So let me finish up. If we could zoom back out to that full verdict form page, Lindsay, and zoom in on this final section. If a county fails to submit a proper objection, the arbitration process should not proceed to the remaining questions regarding the validity and substance of the objection. We believe that's where we are here. We would ask you to find, based on what happened back in January, that the county has failed to submit a proper objection and that this arbitration should proceed no further. I'm happy to answer any questions about the city's motion. I believe we also do have the ability to show you on the screen in there the video from the commission meeting if the panel believes it would be worth the time to view that.
Okay. Thank you. Point of order, we went a little longer then, so we're going to allow the county to have some more time if they need to while we finish this one. That's all right with you. So I have a few questions. Anyone else have any questions? Yeah, go ahead.
Yeah, to clarify, the Board of Commissioners action on January 7th, and I don't see it, was there not a resolution they were approving, or they were simply verbally authorizing the city attorney per the text of what's in the minutes? That's all they were doing, was that motion.
That is correct, Councilman.
Okay. When did the city first raise the issue that there was no financial impact?
The city raised that issue in our response to the county's objection, which we mailed on February 20th, and I believe you have that in your binder at tab 2, your white binder.
And yeah, I don't think
Dr. Mitchell.
When the county made its vote objecting to your submission, can you honestly say that you have provided them sufficient information that they could produce evidence of any financial impact? Some of your documents asked for 60%, some asked for 100%. The parcels were all over the place. They couldn't make anything out of it.
Respectfully.
Sufficient, did you think they had, you submitted sufficient evidence for them to make such a decision about financial impact?
Yes, sir, we did.
Yes, okay.
You think you did?
We think we did. The original annexation packet, though it may have contained some Scrivener's errors with respect to particular addresses and parcel numbers, it contained narrative statements, it contained maps showing exactly what we were proposing. There's really never at any point been any question about what this annexation is actually about.
Chairman?
How is this motion different than the charge to the panel already to start with, considering whether this is a valid objection or not?
Well, for one thing, this is page 1 of your verdict form. This is in its interpretation of the statute, what ACCG and GMA believe is the
Isn't that what I'm
threshold.
asserting? This is part of our normal panel discussion, so what are our duties? Why is it a motion?
You can style it whatever you would like to style it. I do understand from you, Mr. Chairman, that it's not customary to receive motions in these proceedings, but it is an issue that is ripe for determination because it's not based on the evidence that we expect you'll be hearing in the next 2 days. It's all based on what happened back in January, and it is ripe for early decision if the panel decides to do so.
Okay, thank you.
I have a few questions, Ms. Peterson, if you don't mind. First of all, the Open Meetings Act, I know you probably are familiar, but, counties our size, like Cobb and Dekalb and Fulton and Gwinnett and all that, this was fairly common that we add agenda items with majority there in accordance with the county clerk and the county attorney. So I really don't see an issue with that. Also, with counties this size, annexations, all sorts of things, we typically delegate that to our county attorney or our county manager, or in this case, the CEO or whatever, so without a lot of detail. Our process in Cobb was that we received annexation notices to the county commissioner over that district, reviewed it with staff, and then made a recommendation and presented it to the BOC for approval. I'm not sure whether that was followed or not, but to me, that is not as important because they authorized their staff to handle the objection. The third item was financial impact within 30 days. I've done a number of these. I don't recall ever putting other than some verbiage about financial impact. So I went back and I looked at their objection letter, and it does appear that they're objecting on several of the items that we are supposed to rule on, primarily intensity. And that is a primary objection that a county can have for a city to annex, I think. If that's so. Again, I think we're at the same impasse that we were. They say, you say, we say, and then what you have stated to me or to us is that these are the things that would lead us to approve the annexation based on the fact the county did make a proper objection. But that is, as Chairman Glass said, that is part of our decision finding at the end of this hearing, and we will use that as that. So,
yeah, but what I hear the counselor saying is not that we would approve the annexation, but she's saying that because there wasn't a proper objection, that we, on the verdict form, we stop at that point. If we were to decide there wasn't, not that we're then approving the arbitration ends because a proper objection wasn't filed. But yeah, I think we're getting into matters of decision.
That's why we have him.
Right, as opposed to questions for the council.
What I've done in the past ones is we did the hearing and then we filled out the form.
Right.
We probably should have done the objection.
Yeah, it's a little unusual. I think the city is pointing out, hey, just want to let you know that we don't think the first test on the form was met, and just want to raise that now.
And I think if this panel decides that, then we fill that form out, and then we don't have to fill out the rest of it. But I still still think we probably should
Sure.
do that. So,
But we can,
Mr. Mitchell, any other questions for the city? Just one second.
I guess my concern is if we were to rule on that motion and approve it, we would never get to the panel hearing. And I think the panel hearing is where we're charged with citing this very issue.
Yeah, well, that's
So I
what
don't
we're
understand
discussing.
how we could consider this motion, or consider approval of this motion
Yeah.
without negating our entire panel.
Mr. Mitchell, do you have anything else to say since we gave them more time? So,
I'm going to make 2 points about our motion and then Ms. Luna is going to talk about responding to the
thank
city's
you.
motion. With regard to substantial compliance, the cases on anti-litem notice don't apply. That all precedes any kind of lawsuit being filed or anything like that. We're talking about a statutory proceeding, a statutory process that was established by the legislature for how this whole thing starts. And if it wasn't, like I said in one of my submissions, if no one had ever filed an annexation request, we wouldn't be here. If the city didn't give proper notice, we shouldn't be here. And we do think that you all can make that determination in the first instance. So that area of the law, that context is simply when you have a statutory required notice, the terms are defined, and who they need to give notice to, the governing authority, is defined in the local act. That's yes.
but you will, submit that the CEO and the county attorney received the notice, is that correct?
Yeah, they received the letter.
The CEO and the county attorney received the letter of objection. Annexation.
No, it was served on the statutory overnight delivery was given to the CEO. I mean, the county attorney knew about it. The second letter on February 20 only went to the county attorney and the DCA. Or to, not to the DCA, to another department at DeKalb County, GIS.
So it's not the CEO's responsibility to notify the VOC of anything they get to?
Our argument is that there is a governmental structure in DeKalb County. Hopefully everything functions well. It normally has. DeKalb County today is functioning a whole lot better than it has at other times in the past. But there is the state legislature put a governmental organization in place for DeKalb County for a purpose, and we believe it should be.
Okay, thank you.
question, did CEO Michael Thurman personally receive the overnight letter? Did he sign for it?
That is in,
unlikely, but. That's all right, everyone.
I think it was signed by her.
I'm assuming you sent it certified, correct, to the CEO? Peterson?
I'm sorry, I did not hear your question.
The annexation request was sent to the CEO of DeKalb County certified, is that correct?
It was sent via an overnight courier. I do not know whether that was a certified form, but it is a form that the statute allows.
It was sent via FedEx specifically.
Okay.
Which is one of the statutory methods that's permitted.
Perfect, thank you.
Yeah, I guess what I was leading to is, it seems unlikely that CEO Michael Thurman himself answered the door and signed the letter, but the county's not disputing that the CEO was served. The CEO was served through a process. A letter was sent to his office. Someone in that office took possession of the letter, and Michael Thurman might not have, still to this day, might not have seen this letter. Theoretically, right? He signed for it in his office, right?
If there's no more questions, I'd like to make a motion, we go into executive session.
No, the county has an opportunity to respond to the city.
I thought we just did that, I'm sorry.
I believe that was his reply to her response to the county's motion.
Okay, sorry.
I'll first introduce myself. Good morning, my name is Shelley Momo, as you heard earlier. I'm going to attempt to do this standing, but there are a lot of documents, as you can see. I'm having Kiana pass out Jennifer, for your knowledge, she's passing out the two statutes, OCGA 3636-113 and 3636-115. I want to welcome you and thank you for your time, and we really appreciate your thoughtful consideration of all of these matters. We put a lot of effort into this, and I know it's also going to take you a lot of time to be here today and tomorrow. As an initial matter, I'll first provide you with a roadmap as to why the city's motion to dismiss should be, or why the city's motion to dismiss should be denied. First, as I'll tell you, the objection was properly approved by our Board of Commissioners and properly initiated. Second, I'll go into, as Ms. Peterson did, in the order she went for the ease of the panel, I will detail the county's objection and how it included evidence of substantial impact, financial impact. And lastly, as set forth in our brief, any procedural challenges to the validity of the county's actual objection. What was heard in the BOC meeting is not our actual objection. The paper on January 10th, the letter sent by the county attorney, is our actual objection. And any challenges to that objection are not right for consideration until this panel hears evidence and argument by the parties. First, I will make a quick note of what I passed out to you. These are the two statutes that we are proceeding under today and which are relevant to our discussion right now. And I'm going to ask Kiana to share her screen. Is that not working? There we go. And just as Mrs. Peterson has used the arbitration handbook, and which is partially in your notebook, I'm going to refer to it too really quickly. I've given you the statutes because that is what the authority is here today. We need to look at the express and plain language of the statute, not what the handbook says. And while I respectfully, I respect the GMA, the ACCG, they've definitely helped me through my career in providing guidance. You'll see in the introduction page at the bottom, it specifically says in the last paragraph, none of this information is intended to be as legal advice, legally binding in any regard. And it also states that it was simply provided to provide informal guidance. So with that in mind, I want to direct us to the language of the statute, not the verdict form, not any other guidance. I think we need to look at the true authority here. And the first place I'll point you is OCGA 3636-113A. And that is the discussion of how the county approves an objection. It states that the county governing authority may by a majority vote object to the annexation because of a material increase in burden upon the county directly related to one or more of the following. And then it goes on to give the legal grounds for the objection. We have the plain language of the statute in front of us. Nothing in this statute requires the BOC to first state the express legal grounds before their vote. Nothing in the statute requires them to add it to the minutes. As Ms. Peterson noted, it's not in the minutes, and it's not required to be in the minutes. It wasn't required to be stated prior to their vote, and it's not required to be stated in the resolution, which was signed after they agreed. It wasn't just a vocal agreement or a vocal motion. And as we put in our brief, there are general principles of statutory construction, and one of those, the main one, is that where the language is clear, that's what we should go by. This is how we should interpret the statute. In the alternative, I will tell you that the General Assembly could have said, state this in the meeting before your vote, and they chose not to. There is no language in the statute that indicates that this was their intention. And I think that interjecting this additional requirement of requiring that language to be in a resolution, in minutes, or in their BOC meeting specifically is in direct conflict with the statute. And I know Mrs. Peterson has talked about substantial compliance. While she tries to limit it to, I believe, matters of notice, It's not limited to matters of notice. Substantial compliance applies to county officials. And I'll reread you the statute. Substantial compliance with any statutory requirement, especially on the part of public officers, shall be deemed and held sufficient. That's not in any way limited here, and the city's argument is essentially they don't want us to abide by strict compliance. They want us to go over and beyond what is expressly required and state this in every possible forum that we could, and practically speaking, that's not always possible. And finally, I will say on this issue that although I don't believe the statute requires statement of these legal bases for a vote, we do think that the county attorney was sufficient in providing the legal ground. She noted that there was a zoning issue. And although the BOC did not request more information on this zoning issue, that shouldn't be held against us. The BOC did have a very intense, substantive conversation about the impact of annexations, including financial impact and impact on unincorporated residents in the area. So I think that, you know, if you've gone back and watched the video, and like Ms. Peterson said, we can play it for you here, if you truly see the video and you see the discussion, you can tell that the BOC was not providing County Attorney Ernst with unfettered discretion, as the city will have you believe. They made a very knowledgeable decision as provided by the statute.
Does the district commissioner take the lead on any annexations for their district, and then they present it, or is it ad hoc, everybody does it?
I think Commissioner took the lead on this, Commissioner Rader took the lead on this one. But I'm not, and I think practically speaking it happens, but it's not a rule, I don't believe.
Correct. Okay, thanks.
Right. Yeah, but Commissioner Rader was the presiding officer at the meeting. Is this even in his district?
Yes, it is.
Oh, it is, okay. But he also just coincidentally was the presiding officer at the meeting in which they discussed it. I don't think that was because it was a specially called meeting for another purpose.
Sure.
At which he was the presiding officer.
I think it was his item that he proposed.
Yeah, they had to put it on the agenda, each district commissioner.
Well, the motion was made by, anyway, I don't think that matters, made by Shaw, but okay.
To clarify, I'm sorry, just to answer your question, I think it was his walk-on item. He did the walk-on item, and then Mr. Bradshaw made the motion to pass.
To add it to the agenda.
Okay. And next, I want to briefly discuss the financial impact provided by the county in its objection. And that, if you'll go back to OCGA 36-113, provides you the language, and it simply states that the objection specifically shall provide evidence of any financial impact forming the basis of the objection. And as you'll see in your notebooks, we provided you with the county's objection at Exhibit 1. The county did provide this evidence of financial impact based on the burden of change in zoning and land use, the increase in density, and then the related and subsequent demands on their infrastructure. They mentioned the financial impact of water and stormwater on our water and stormwater systems, and the financial impact of our and burden on the sewer system, which is already subject to strict regulation pursuant to a consent decree. It also discussed the impact on roads within unincorporated Dekalb, namely Briarcliff, which is going to take the brunt of the traffic that's caused by the increased density and intensity. They did mention tax abatements in there, which is also a huge potentially could be a huge financial impact to the city. And if you go back and read the statute see evidence is not defined, and the statute doesn't require any specific type of evidence or an amount of evidence. It simply requires evidence, and within the 30 days that the county had, this is sufficient. And I'll also note, I believe it was that there were issues with the parcels, there were errors in exactly what land would be annexed, which caused issues. And the county also noted in its objection on the last page that they're also having issues determining financial impact due to service delivery. There were no service delivery agreements to specifically address this. And I will, one last comment that was in the brief that I do want to address but not dwell on is that any decision by the city to cast skepticism on when we provide our financial impact, I think is a little unfair because we both agreed in March that we would postpone this hearing and pay attention to our residents and focus on providing services to them during the pandemic, which we have done, but it has also hindered our investigation, and we have continued that investigation and provided that information as we receive it. As a result, I think that, initially before we get into the deeper concepts, the county's objection was properly approved and it contained the proper information that the statute requires. Third, I will try to be brief. I know I'm running long. The last portion of their motion to dismiss is asking you to rule on the validity of the objection without hearing evidence or argument. And I think for two reasons you should deny this. Number one, the statute does not contemplate that you would rule on the validity of the objection this early in the proceedings prior to hearing argument. And number two, practically speaking, I'm not sure that enough information and interpretation of these documents has been given to you to make this decision on validity. And the second statute I handed you, OCGA 3636-115, as you'll read, contemplates the validity of an objection and contemplates that it would be considered after hearing evidence. And if you'll go to subsection A1, it talks about how the panel is appointed and then goes on to say that the panel shall meet after appointment, shall receive evidence and arguments, and then shall by a majority vote render a decision. It then goes on to say the panel shall first determine the validity of the grounds of the objection, and if they determine the objection is valid and has a financial impact, the statute tells the panel how to proceed and how to quantify that impact. The order and construction of this statute is written such that it contemplates the panel hearing evidence and hearing argument and then making this determination after argument and evidence are heard. And then practically speaking, I also just want to touch on the information that we're going to give you today and why it's important to receive that. You're going to hear testimony, if this proceeds, on the DeKalb County zoning plan, the land use comprehensive plan, and how to interpret it, and other impacts on infrastructure. And these are fairly complicated documents. It's a fairly complicated plan that has been constructed by DeKalb County to control its planning, and it can't be summarized in a 2 to 3 page brief by the city, and it can't be summarized by me in a 5-minute argument. So, and I wanted to provide a few examples as to why I think it's even more pertinent, and I think it's even more illustrative as to why you should hear argument. For instance, the city in its brief has said that the zoning has not changed. It's C1 from DeKalb County to C1 to the city of Brookhaven. They're both local commercial. However, what that simplistic notion of our zoning and their zoning doesn't tell you is that our zoning doesn't allow residential use in this capacity in this area. And although the city would classify this as a minimal change, what this means on less than 7 acres here is the addition of almost 400 residential units that would not normally be allowed. And then also, if you look at our land use plan, while it does contemplate residential units, what they're asking for is more than twice the density of what the land use plan would allow. And finally, I want to also use as an example some of the city statements about how changing land use from all commercial to mixed use, I think the exact language is that often results in lower intensity And then he makes presumptions about the traffic from Chick-fil-A versus the traffic from a residence. There are no sites in this. He has provided nothing to tell you why this traffic is this way, nothing to tell you why this change in density would not be better or worse for the city or county. Instead, he's just asking you to rule on these conclusory statements without hearing any additional evidence or argument. The county, instead, is here today to ask you to listen to our witnesses, listen to the people who specialize in zoning, who specialize in land use, and who specialize in our infrastructure, and let them explain to you what exactly our planning is, what it means, what impact it'll have, and how that should be financially quantified. Mr. Ash and his brief are not in a position to explain this to you and are not in the position to truly tell you whether it's valid. If this isn't his expertise, this is why we need witnesses and evidence. And based on that, I know that statutorily speaking, I've provided you with the evidence that we should move forward. It's not contemplated that we would stop here. And even Ms. Peterson said that it's not contemplated in her situation that we stop here. The same goes. There is no statutory scheme that says we would stop here before hearing evidence based on validity objection alone. So I ask that you consider the county's arguments and rule in favor of us and deny their motion to dismiss and let us proceed today.
Well, the first thing we gotta do is rule on your motion to dismiss.
Yes.
So you're asking us not to dismiss and move forward. The first thing you're doing is asking us to dismiss.
It's very complicated.
Somewhat confused here.
Wait, I was thinking that too, Chairman, because you just eloquently presented all the things that you're here to talk about
To
today.
deny your first motion.
But only if we don't vote to dismiss are you here to talk about all those things.
Well, and, you know, obviously our motion to dismiss was filed for a reason. We truly believe we weren't provided notice as required under the statute, and that is our main argument going forward. We do think it should be dismissed on that matter. However, if it moves forward, we are here to provide you with the proper evidence to make your decisions based on validity.
Okay, any other questions?
Couple of
Yes, sir.
I've heard two motions, one to not to dismiss and one to continue. And I'm kind of confused to see.
Well, we're gonna go and discuss this.
Yeah, a question for Momo? Ms.
Yes,
Momo?
yes.
Yeah, sorry. Yeah, so splitting hairs, but this may come back since we will have to, at some point, determine whether a proper objection filed by the county. That is part of the process, right? Your position is that that's part of the overall process, and that is something that we'll do once we've heard all the evidence. So back to that point, we previously talked about that a motion was there was a motion to add an item. They added the item and they authorized the city attorney to file objections to the annexation petitions and substance approved by the chief operating officer, who has nothing to do with this, and in a form acceptable to the county attorney and authorized to the executive has nothing to do with this process. However, in the letter from the county to the city, in accordance with OCGA 3636-113, on January 7th, the DeKalb County Governing Authority by majority vote adopted and approved a resolution objecting to the annexation of all the parcels. Does that resolution exist? And if it does, can we get a copy of it?
There is a resolution. I can provide you with a copy, or we can look it up quickly on here.
We don't need it right now, just because if we determine, so.
We'll go ahead and get that for you.
That's the difference between, was this just a verbal motion authorizing this, or for the county attorney, there was a resolution that they approved on January 7th, objecting to the annexation.
Yes, sir.
Which obviously would go to documenting their grounds to the grounds for objecting. So.
All right, I'd like to make a motion that we go into executive session after we have a potty break. Second.
Sure, second, sure.
All in favor? Aye. All right, we're gonna go in the next room, so all of you can stay here, and we should be back hopefully shortly.
Would you like us to bring a resolution into you?
Yeah, if you have it readily available.
We'll go ahead and print that out for you.
Okay.
I love that, sorry. around.
Oh, I'm sorry, no, we're gonna get you in here.
Shelley, when you get that resolution, will you share it with us too, please?
Yes, I will.
It was on one of your early emails.
I'm gonna go check my computer. Yeah, your internet's very slow.
Yeah, he hooked it up to the,
Yeah, I have downloaded it.
yeah, who to email it to? Yeah.
Just so you guys know you're still sound.
Vote from the city back.
Trash, there they are.
We are.
Oh, good.
Just a court reporter. This is the court reporter. So I'm having a hard time hearing Mr. Glass and people way down on that end, Mr. Mitchell down there. There's a lot of Mr. Mitchells, but the attorney, Mr. Mitchell. Every time you stand up, it's just hard to hear. And there's a lot of shuffling wherever that mic is. So can y'all be aware that it's there?
In the middle, maybe?
Yeah, can we move that starfish phone thing closer to the middle for us?
So you said it's better when I stand or when I sit?
Like,
No,
bring it all the way.
I hear
Someone
music.
just hit the hold music.
Yeah.
Look, wait till the song finishes.
We playing musical chairs?
I still hear music.
Just trying to move the microphone
out.
closer to the rest of the panel.
Is this it?
Please stand by.
Oh, I don't know. Yeah.
And so now that it's there, just be aware of the shuffling, the paper shuffling. Oh, well, that's what I pick up. I don't hear what you're saying. So just be aware of that, that's all.
She said she's having a hard time hearing the people at the other end of the table.
Okay.
Yes, we just moved it, and music was playing for a moment. We thought we'd put ourselves on hold or something, but appears to have stopped.
Okay, great. Everything okay?
All right. Mr. Ash, just everyone back.
Thank you, Adam.
Can they hear?
Okay, thank you. All right, I'd like to make a motion to come out of executive session. Second.
Second.
All in favor?
Aye.
Motion carries unanimously. We're out of executive session. In the matter of the agenda, item number 2, the panel will offer its response to the county's motion to deny as well as the city's motion to deny. On the county's motion to deny, I would like to make a motion that this panel denies the county's motion to dismiss. Correct. Second.
I'll second that motion.
Any discussion? Hearing none. Call the question. All in favor? Aye. All opposed? All right. So the county's motion to dismiss is denied by this panel unanimously. In regards to item number 2, which is the city's motion to dismiss the county's objection. I think I said that right. This panel feels that their argument, as well as the county's rebuttal to that argument, is part of this panel's decision-making process that is to concur at the end of the panel presentation by both parties. And so we want to defer that until we make our ruling whether the city's objection is valid, the county's motion to object. So we're not going to rule one way or the other on that until we've heard everyone and their arguments. So that's the ruling of the panel on those 2 motions for item number 2. Now, it's all right with everybody, we will proceed with presentation of the evidence by the county and the city. The county will go first, and I'd request that, assuming if you have witnesses, that you will swear them in just briefly, as long as swear. And then we'll allow them to present and questions from the panel during that discussion, and then the city will present after that. Is that correct, Ms. Peterson and Mr. Ash?
Yes, sorry. We assumed that the county would go first since they have the burden here.
And then once you start, if you have any witnesses, then you will swear those.
Yes, absolutely. I almost called you Your Honor, but haven't.
Yeah. get promoted. I'm not sure if that's a promotion or not sometimes, so. We will have, first of all, we'll have opening statements by the county, followed by the opening statements by the city, and then we'll have the county proceed with their, presentations and arguments.
Can I ask a question about scheduling? I'm trying
Yes,
to
sir.
schedule witnesses. I understood that today was a day that we could not go late because I believe you have a...
Yeah, I need to be back in Peachtree Corners, which is only 20 minutes away by 7 p.m.
By 7.
That is when my city council meeting starts
Okay.
tonight.
All right.
So,
We're not going that late.
Well, I've got just to kind of for scheduling purposes, about 11, my first witness will probably take an hour and a half to 2 hours on direct. I don't know how long Mr.
You
Ash...
said on the way to get here? Or?
No, he's here. He's
Okay,
here.
yeah.
We'll take probably an hour and a half to 2 hours on direct. I don't know how much cross Mr. Ash will have. My second witness, I anticipate to be about 45 minutes to an hour on direct. I don't know how much cross Mr. Ash will have.
Well, I'm not certain Mr. Ash will get to cross. We get to cross it. We get to ask the questions.
Okay.
And, that's usually the way it proceeds. They present, we ask the questions. So we're not gonna, it's not a criminal trial.
Okay.
And that's correct, Victoria? That's what I heard. Yeah. Yeah.
So there will not be cross-examination of opposing witnesses?
You know, I've never done, well, yeah, I'm sorry, it does say you can do that. I apologize. Okay, never mind, I apologize. I just never done that before. So you're okay with that, Mr. Ash? Cross-examining her if you need to, so.
We are.
Okay, all right. So an hour and a half for the first one and...
An hour and a half to 2 hours.
Okay.
And then it'll be about an hour, 45 minutes to an hour on direct for the second one. And then the third witness, probably the same. So...
4 or 5 o'clock.
They're all prepared to be here. If we're getting to about 4:30 and my second witness is getting done, I frankly would prefer not to put the third witness up until in the morning. But I'll defer to you all on that. Because his testimony will clearly be split unless you all are prepared to go till 6:30.
Okay, and then Mr. Ash, what do you anticipate for your witnesses?
We anticipate, we anticipate 4 witnesses tomorrow, and our assumption had been, particularly given this morning, that we would be doing those tomorrow. I think most of them can occur relatively expeditiously. I mean, again, not knowing how vigorous the cross-examination by Mr. Mitchell will be. Depending, there is some outside chance of a 5th witness, depending on how one of the county's witnesses answers a question on cross-examination. I hope not to have to call that person. But I see no reason why we couldn't, why we wouldn't be able to finish Wednesday.
I definitely see no reason.
I thought we might see eye to eye on that, Chairman.
Yes, sir, yeah. Okay. So, assuming we'll get through today with the county and we may or may not get your last witness. If not, we'll call that witness first thing in the morning, and then the city can do that, and hopefully by mid-afternoon we can finish up and be out of here. That's all right. That's kind of a tentative timeline. So if you'd like to make an opening statement, that would be great.
And I'm going to excuse myself just to allow for a little more space in
Thank
here.
I want to move that chair out of the way here. We need to have that where the Zoom people can see it or not?
It is.
How about on a chair right around here somewhere? If you need to reach it, so.
Oh, yeah. Yeah, that
Yeah,
picture
that's
is
showing. Yes, so maybe we
that's
did it.
in the camera, right? They were.
Yeah, are you able to? Bannock. About what? You know what? So I want to buy a bottle.
Oh, damn right.
Well, maybe, can we ask our host, do you have an easel, perhaps?
Sure. I'm glad you're here.
Must be nice to have all this fancy stuff, we're not used to it.
Oh, yeah.
Mr. Attorney Mitchell, you may want to confirm that the court reporter can hear you.
Can you hear me, Madam Court Reporter, standing here?
Can't hear her.
I'm sorry, I was on mute. Yes, you sound very good right there. Yes.
I think everybody can sit. You want to get started? We'll
Sure.
wait till the easel gets here.
All righty. All right, gentlemen. This is a statutory proceeding designed to offer some protection to the county in the annexation process. DeKalb County has over 750,000 citizens, 54,000 of them which live in the city of Brookhaven. 700,000 of them do not. A few years ago, Brookhaven annexed some valuable commercial property just over 85, between 85 and Briarcliff Road, which is currently the Emory Executive Park development and what has been and will be a new development of Children's Hospital of Atlanta. Brookhaven now seeks to jump Briarcliff and take in another 27 acres of valuable commercial property, which has a Target shopping center, a shopping plaza with restaurants and various neighborhood commercial, fast food, quick trip, including including a Chick-fil-A. Almost invariably, annexed property is going to be rezoned or used at a more intense use than is permitted in the unincorporated county and here in DeKalb County. This fact is going to have an outsized impact on the residents that are south and east of the area. You will see that this area here, south and east of the intersection, are a substantial number of single-family residential, townhomes, detached homes, but a number of residential, it's a substantially residential area. And this statutory proceeding was created by the state legislature as a mechanism by which the citizens of DeKalb, through their elected officials, can have some voice and provide some protection for those citizens as to what this property will be developed as if it's annexed into the city of Brookhaven. Many of these folks drive through this intersection many times a week, and while some of them have gotten notice of this annexation, that once this property is annexed, they are not voters in the city of Brookhaven, and therefore they are not going to have any voice as to what happens on this property once it is city of Brookhaven property. They don't vote in the city of Brookhaven. They are in unincorporated DeKalb County. Most of the panel are here because you're either current or former elected official. You've had a substantial amount of service listening to your citizens and their desires and their needs and attempting to implement what those citizens tell you that they want, especially with regard to land use and provision of services. Your volunteers, for this, and I can speak for myself, the other attorneys, I'm sure, and the DeKalb County employees, that we really appreciate your service. However, the issues before this panel are very important to the city, but they're especially important to the county, because this is the one opportunity that the county has, and the citizens acting through its county representatives have, to have some influence on what may ultimately happen with regard to this property. I know that your agenda states that you all are going to deliberate and perhaps decide this matter tomorrow. As all of you know who've been through the training, you have up to 30 days to make a decision. And I would encourage you that before you make a decision, that you drive over there, drive through this intersection and drive through those neighborhoods that surround or that are to the south and east of that, that intersection. DeKalb County thinks this is so important that we're prepared to hire a bus to take you over there all together. You can take the attorneys or not take the attorneys, you can just go alone. But we think that it's substantially important enough that it is something that ought to be done, that you ought to see that area. Between the witnesses that the county will present and that site view, we think that you will come to the conclusion that there are certain conditions or mitigating measures that we would hope that you would recommend if this property, the annexation, is approved. One of those witnesses you will hear from is Mr. Andrew Baker. He's going to be our first witness. He is the Director of Planning and Sustainability for DeKalb County. He's certified by the American Institute of Certified Planners. He has worked for DeKalb County since 2006. He is, that department is responsible for zoning, short and long range planning, inspections, permitting, that type of thing. And he's having worked there since 2006. He is very, very familiar with the zoning and land use issues in DeKalb County. Years ago, when the professional staff was first looking at this area, and I think you'll hear some of this from the city, they thought that this particular area would have been appropriate for more intense development than is allowed there today. However, after that period of time, there was an application and a grant for a Livable Centers Initiative study. And Livable Centers Initiative studies, some of your cities and counties may have done those, but you give money and there's a study done on a specific area. There's a lot of public participation that goes into those. And then there are conclusions that are drawn about what the citizens believe ought to happen in that area. And that happened here. And what was determined through that LCI, that's the short form of Livable Centers Initiative, through that study, it was determined that it was not appropriate for more intense development in that area. And those conclusions were incorporated into the new comprehensive plan for DeKalb County, the comprehensive plan that's in effect today. Mr. Baker is going to explain all that to you. As a result of the current comprehensive plan, that particular area is what is appropriate for what is its character area is what's called neighborhood centers. And there's two terms you're going to hear a lot of, at least over the next day: neighborhood centers and town centers. What Brookhaven is suggesting, at least the application that's currently before the city, that density in that application by related group is what DeKalb County would call town center type of density. What DeKalb County's documents provide for that area is what is called neighborhood center density, and those are very different. Neighborhood center density has a maximum residential density of 24 dwelling units to the acre, and the vertical heights are somewhere between 2 and 3 stories. You can get more if you get a special land use permit to do that. Town center level density, which is what we see in the proposal from Related, allows up to 60 dwelling units per acre and buildings up to 7 stories in height. And in fact, that's what Related has proposed for just the 6.74 acres of the 27 that are proposed for annexation. For that, over that 6.7 acres, they've asked for 382 apartments. That's 56 dwelling units to the acre. That sounds a lot like, that sounds very close to me anyway, not a mathematician, not an accountant. Sounds very close to 60. Looks like town center level of development. The other thing that is substantially different between the zoning codes in DeKalb and Brookhaven. This was alluded to in Ms. Momo's argument earlier. Is they're saying they're trying to they're telling this panel that it's coming in as C1 Brookhaven and C1 DeKalb. C1 in DeKalb and C1 in Brookhaven are very different. C1 in DeKalb does not allow residential, does not allow multifamily development, and only single-use commercial is allowed. If to do mixed use, you have to get it rezoned. And to get a rezoning, all of you know, you have to go through a public hearing process. The public gets to have input, and then there's a decision made by the elected officials. In Brookhaven, C1 allows residential development and allows a mix of uses, just like the application that we see here. Those are very different, and that's what, and Mr. Baker will explain those differences to you. The comprehensive plan is also very different. Again, it's neighborhood center in DeKalb County. The closest, just across Briarcliff in the Executive Park, CHOA, that's Children's Hospital of Atlanta, they call it CHOA around here. They have a character area called Buford Highway Overlay. And that is an incredibly, top of the map, that's an incredibly dense commercial corridor. Buford Highway Overlay in the city of Brookhaven, in the core, allows up to 100 dwelling units per acre and up to 12 stories. We're not suggesting that's not the application here, but I tell you that to explain to you and to show you the difference between the comprehensive plan character areas from the city of Brookhaven and the DeKalb County. The zoning and land use are substantially different in what they've applied for and what would be allowed at this particular point in time. And again, going back to the LCI process 10 years ago, incorporated into the comprehensive plan, that is not what the citizens of DeKalb County, especially those in that area, either expected or want in that area. And so even at neighborhood centers with entities, he's going to explain to you, as you move towards the residential areas, that density gets even less. So even while the character area itself will allow 24 dwelling units to the acre over the whole thing, as you move to the areas that are adjacent to the single-family residential, here's the subject property. Here's 24 acres, and then this 3 acres here. And there's going to be close-up maps that are going to be introduced to evidence that you all will be able to see. This is the area right here that is the subject of related application. This is the target that you've seen referenced in the various pleadings. The Chick-fil-A is right around here. That's the Quick Trip and the Boston Market right there. The point I was making is as you move towards the residential areas, the densities get even less than the 24. As you move away from the core towards the outer boundaries, the densities ought to drop. So even on this property, because it is adjacent to single-family residential, even though, as he will explain to you, even though it is 24 dwelling units to the acre in that character area, on this particular property, because it is directly adjacent to single-family residential, the densities probably would not get that high. Once this property is annexed into Brookhaven, if that's what happens, those restrictions are no longer going to apply. Brookhaven's going to would zone the whole thing to C1. You've got the application and a site plan for a specific part of it, the 6.74 acres, but the other 20 plus acres will also come into C1 with those other entitlements that are for much denser development than would be allowed under DeKalb County zoning or under its land use planning. So again, this proceeding and what this panel does after hearing all the evidence is the opportunity that those citizens have for any type of control to be placed on, any kind of limitations on development to be placed on that property, any type of mitigating measures that you all may recommend. This is the opportunity that those citizens have to have that implemented. Another witness you're going to hear from is a woman by the name of Michelle Ox. She's a professional engineer. She works for the Department of Watershed Management in the Division of planning. She's responsible for reviewing sewer applications when there's application for new service. As was alluded to earlier, you'll hear a little bit of discussion about this. DeKalb County is operating under a consent decree, a federal consent decree that it's 100 pages long. We're not going to go through it, but the important point about the consent decree is that if there's going to be any volume of sewer effluent added to the system, there's a protocol and a policy that has to be done before that can be done. Some of the, I think DeKalb County has a reputation that its entire sewer system is failing. That's not true. There are some areas that have aging infrastructure, and some pipes, some parts of the system are overloaded. This area actually is one of those areas. You will hear her talk about what's called a dry weather problem. A dry weather problem is that the system is to the point where even in dry weather, without all the I&I, inflow and infiltration from rainwater, the system is at a point where it's more than 85% of the capacity of the pipes. And under the decree and under the protocols, there has to be special conditions put on the addition of any additional sewer effluent going into the system. And so what that requires is that basically a development in that area has to construct a large holding tank and then only release effluent from that site during the time of midnight to 5 o'clock, assuming it's not raining. So in other words, it's a complicated process, and that particular process applies certainly in this area because of that. Even if this property were developed under DeKalb County's zoning ordinances and comprehensive plan, that problem there's going to be more of that. If it develops at the type of densities that this application suggests that Brookhaven is looking at for that 27 acres, there's a mile of pipe on this route that will be at 200% of capacity. It is a substantial overload of that system. It would require almost a mile of that pipe to be upsized, and a lot of that pipe is not lying right away. A lot is on private property, and so that is a definite impact that level of development will have on the county. The last witness that you will hear from is a transportation engineer by the name of Speedy Boutwell. He's also a PE. He has his own firm by the name of Speedy Boutwell. Great name for a transportation engineer. I believe his dad raced cars. I think that's what he told me was where the nickname came from. He was asked to review this site and look at and take into account, and he took into account all the other development that's already proposed or approved in that area. So he basically he took into account what the executive park site is going to add to it. He took into account what the CHOA site will add to it over the next 3 years. And then he was asked to compare, if it were to develop, the site were to develop as DeKalb County would allow it, again, a neighborhood center, 24 dwelling units to the acre, about 1 to 2 story, versus if it developed at what is town center or what Brookhaven appears to be proposing in that area, almost 60 dwelling units to the acre, 6 to 7 story non-residential structures. What are the other improvements to Briarcliff Road that would have to be done? He did not, the focus was Briarcliff Road for about an eighth of a mile up to a place called, I want to say it's Brockton or Cliff Alleyway. I can't remember the cross street. Clearly North Druid Hills Road itself, there's going to have to be things done. This area right here between 85 and Briarcliff, there's already some plans in the works. I think the city of Brookhaven is going to talk about some of the things that they planned for that area or they thought about doing. So Mr. Boutwell was asked to look at just the area from basically the site up Briarcliff Road, and again, take into account the background traffic. To compare the two types of development, what additional transportation improvements would have to be done in order to make the roads or allow that road, Briarcliff Road, to continue to function in the same way. And he, again, perhaps no design work, but based on his background and experience, came up with some concepts as to what would be required, and is prepared to talk to you about what that will cost to implement that. And it's a couple $1 million. That's the difference in what would need to be done to the road to make it function the same between the two developments. And in closing, over the last 10 years, DeKalb County and the residents in this area on a number of occasions, both in the LCI process and the comprehensive planning process, have met together and had input into what type of development, what this area ought to look like into the future. The current comprehensive plan has a horizon through 2035. If this property is taken into the city of Brookhaven, is annexed into the city of Brookhaven, those policies and procedures and ordinances are no longer going to be in effect. And in Brookhaven's C1 zoning, and Brookhaven's Buford Highway overlay will govern what happens. And we know that they're looking at Buford Highway overlay because the application asked for, the zoning that's asked for in the current application, just as 6.74 acres, is C1 Buford Highway overlay. That's why the county understands that ultimately Brookhaven intends to apply that very intense character area to this property that sits right next to single-family residential. And again, and I've said it a couple times, this is the statutory process that the state legislature has put in place for counties, for the citizens of the county through their elected representatives to appeal to a panel like you who's staffed by elected officials and folks with planning experience to put into place, to recommend some conditions and mitigating measures so that all those expectations and all that work that's been done in the public process up to this point doesn't just evaporate once this property is annexed. And so again, that's what the evidence will hopefully give you the basis for that. And again, I would encourage you, and if you all decide that you want that transportation provided by DeKalb and whatever that looks like, let us know and we will arrange for that.
Thanks, sir. Ash? There. Or Mr. Peter, are you going to have to say?
It'll be me. Again, I
Okay,
almost told
good.
you, Your Honor.
Yes. I'm getting ready.
Most county commissioners I know don't think the judges are a promotion from them, but you know, I'll leave that alone, particularly since we got a court reporter present. Good morning, y'all. I am, as you know, Robbie Ash with Bondurant, Mixon, Elmore, here on behalf of the city of Brookhaven. You've already heard from my colleague, Jennifer Peterson, and on our behalf, along with Chris Balch, Brookhaven City Attorney, I want to start by thanking you for accommodating our family's medical conditions. We know that it adds a layer of inconvenience, both for you and for us not to be there in person. But given the immune systems at issue, it just wasn't something we could do, and we appreciate you understanding. My guess is that as long as there has been a thing called annexation, cities and counties have been fighting about it. And so much of this story is already familiar to you. We, of course, believe that annexation is the best thing since sliced bread, and the county believes it's as bad as the second half of the Falcons' last trip to the Super Bowl. As a native Georgian, it's still hard for me to tell that joke. But we're not here to litigate or resolve for all time whether annexation in theory is good or bad, but rather to address a much more narrow question as provided in the statute. This arbitration is by law strictly limited to whether there should be zoning or land use restrictions attached to the annexed territory for up to a year to address proven material financial consequences of infrastructure problems created by the proposed zoning or land use change proposed in connection with the annexation. That is a mouthful, even by lawyer standards. But ultimately, it's pretty simple and really quite narrow. While the county will do its best to convince you over the next day and a half that redevelopment of these parcels would be Armageddon for the area, the truth is different. Once we peel back the rhetoric, the evidence will show you it is not really a fight about whether redevelopment at this intersection is a good idea or not. Since 2007, the county has been on the record in its own planning documents as supporting higher density, mixed use development at this specific intersection. They created a tax allocation district in 2007 precisely to foster, support higher density redevelopment and to capture the revenue from it. And then again in the LCI study that Mr. Mitchell referenced. Indeed, as we sit here today, there are multi-billion-dollar redevelopments that dwarf anything we're talking about occurring immediately adjacent to this parcel. Lindsay, would you pull up slide 2, please? Lindsay, for those of you who don't know, is our incredibly talented and wonderful paralegal who I will ask to take a hat turn at, a hat tip at the end of this. But in the meantime, here is the map of the area. Down in the left-hand corner, all of that blue, that's the Emory University redevelopment of Executive Park. That's 60 acres. It has dozens of medical office buildings, hotels, and thousands of jobs projected on it. The area in peach up above it is the New Children's Healthcare of Atlanta complex. It's 72 acres of hospital towers in surrounding medical buildings. It's 7,500 jobs with a driveway down here on this peach portion on Briarcliff, immediately opposite the annexation site, which is marked in the gray dotted lines. In the piece that has a logo on it at the intersection of North Druid Hills and Briarcliff, but isn't shaded, that's called Brighton Park. That's a vibrant multi-story retail mall with hundreds of thousands of square feet with dozens of shops and restaurants. And even the annexation site itself, as you can see, has lots of successful businesses on it already. The 3 acres on the south side of the intersection has a Quick Trip and a Boston Market. On the annexation itself, at the very corner, there is what I've been told is one of the busiest Chick-fil-A's in the entire Chick-fil-A system that was recently redeveloped to add a second drive-through lane. There is a Taco Bell, there's a Target, there's a Lens Crafters. On the north side of the intersection, not part of the annexation because it's already in Brookhaven, is a Walgreens and several other retail establishments. Indeed, this isn't about whether denser development is coming to this intersection. It's already here and it's already happening, and more is inevitable. And frankly, it's appropriate given where this is, how close it is to the urban core and how close it is to I-85. Lindsay, if you'd take down that slide, please. Instead, in a story that you've all heard before, and I know is familiar to all of you, this is really a fight about tax dollars and control. Whether the district county commissioner gets to personally dictate the zoning conditions and design of the project, or whether the developer and the multiple property owners can work with the city of Brookhaven. What might be different here from the other proceedings you've participated in, some of you have, is that here, there's actual evidence that this objection is retaliation for the annexation. Over the next day and a half, you'll hear evidence that Dekalb officials, particularly the district commissioner, told the developer they were in support of this project and didn't see any problems with it, including the rezoning, up until the county learned the developer and their neighboring property owners wanted to seek annexation, and then the knives came out. For example, Lindsay, would you pull up slide 3, please? The developers, Michelle Otts was mentioned in Mr. Mitchell's opening. This email chain involves Ms. Otts. The developers project engineer, a man named Antonio Sample, has a several months long email chain, and this email, the entirety of it is in your binder, white binder, I should say, with the county's water and sewer person, Ms. Otts, about this project. See, you can see the subject line, we've emailed it, Druid Hills mixed use. On May 1, as you go up in the email chain, you'll see Ms. Otts tells him, I have unbelievable news. I've just received the model run. You are full approved. Woohoo. And then she reiterates the next, later on May 1, saying no holding tank required, full approval, exclamation point, exclamation point, exclamation point. Apparently, the sewer department, as of May 1, hadn't yet gotten the instruction about the new political position the county was taking, since they've sure changed their tune since. Her testimony will not be in accord with this later today. Please take down the slide, Lindsay. And now, instead of full support for rezoning and redevelopment, which is what the district commissioner promised when he was trying to talk the property owners to keep the project into unincorporated Dekalb, now we have a full opposition and a list of demands that frankly are intended to prevent any redevelopment at all. Which, let's be honest, is kind of the point here. This is shock and awe, and it is an attempt to punish the property owners and others like them who might be considering annexation in the future. Because the truth is, why we're here is that the county has not meaningfully invested in this area, either in infrastructure or services, in decades. That's why the new major multi-billion-dollar redevelopments immediately adjacent to this parcel also annexed into the city of Brookhaven, because this area is too close to the urban core and I-85 not to develop. But the area's property owners have reluctantly come to the conclusion that the only way to get infrastructure investment and redevelopment is to annex into Brookhaven. And that's made the county real mad. Dekalb's still not proposing to make actual investments in this area, but rather than permit the redevelopment of the area to continue, albeit in the city rather than unincorporated, they've drawn a line in the sand, they've lawyered up, and so we're here today. But what should really make this relatively easy for you is that there's really not much here to argue about, at least if we stick to the statute's instructions and guidelines for what's at issue in this land use objection arbitration. Lindsay, would you please pull up slide 4? This is an aerial photo of the main portion of the parcel. The Quick Trip and the Boston Market are down off the screen to the bottom left-hand corner. This is page 8 of tab 31 in your binder. I pull this up because I want to make the point that the city is not proposing to take an a pristine greenfield and turn it into a landfill, or to put an industrial warehouse distribution center into a single-family subdivision. As the testimony you'll hear will establish, this 27-acre parcel, at which there are already several successful businesses like one of the busiest Chick-fil-A's in the country and a Target, that's the big white roof towards the top of this parcel that draws traffic from multiple counties, it's long been in the county's plans to encourage redevelopment here. And that need for redevelopment, including multifamily residential to provide workforce housing and new medical office space, increased substantially. Once the multi-billion-dollar projects immediately to the west of the parcel were approved, more than 10,000 jobs will be created immediately to the west of this parcel. The driveway for CHOA is literally across the street from the development. That's the grassy area you can see on the left-hand side, right underneath the blue dialog box. That grass will be replaced by the driveway to the 7,500 job multi-tower hospital complex. Adding 380 apartments and a sit-down restaurant across the street from that billion-dollar hospital complex is, if we're being honest, nothing more than a drop in the bucket. And it actually also makes sense because it gives at least a few of the 10,000 people who are going to be working there every day a place to live that doesn't require a long commute. Lindsay, you can take down this slide, please. I'm sure that the county's witnesses will work hard and do a good job of trying to convince you that their newfound opposition to development on this parcel, but for the same reasons that the district commissioner was in favor of it before he learned that it was being annexed, this is a good project, and a lot of the reasons you'll hear from them just don't apply. Remember, this isn't a procedure to address each and every hypothetical concern that could ever arise from an annexation. The statute makes your charge clear and narrow to determine what, if any, specific land use change is actually proposed, not a hypothetical one, but actually proposed in connection with the annexation, and then to determine whether that specific change creates a material adverse consequence on county infrastructure. Of course, In theory, any annexation creates the possibility of rezoning at some indefinite point into the future. But the statute, 36-117 specifically, makes clear what you're to focus on is what's happening immediately and within the year following the annexation vote. And so ultimately, the evidence and the city's actual request for you today, as opposed to the hyperbole, will make this simpler. Lindsay, would you put slide 4 back up, please? Here's maybe the single most important thing I'll say this morning. While the overall annexation area is 27.25 acres, the only piece proposed for redevelopment is the 6.75 acres that are outlined in yellow and marked with the letter A. What we'll call the related proposal, because it's being redeveloped or under contract to be redeveloped by a company called the Related Group. The remaining 21 acres will stay as they are. And so as to, I mean, that Target isn't tremendously successful. That Chick-fil-A is tremendously successful. The Quick Trip, the Sherwin-Williams, those are all viable ongoing businesses that no one has any desire to shut down and redo anything with. So let me narrow this and let me simplify it. The city will stipulate and consent to the panel entering as a condition to the annexation that the city will apply Dekalb's zoning and land use restrictions to the 21 or so acres outside of the related parcel for the year following the annexation. No change of zoning or land use or overlay at all pursuant to OCGA 36-117. While I love a good fight as much as any lawyer does, this proceeding should just be about what's actually in dispute, and the zoning and land use for 3/4 of this property aren't in dispute. No one's tearing down that Chick-fil-A, that Target, or the Quick Trip anytime soon. They're not relevant to this procedure. We'll also stipulate to something we've told the county repeatedly, including in the response letter we sent last winter that you've already gotten a copy of, the February letter we already talked about this morning, which is that the city will not apply the Buford Highway Corridor overlay to any portion of this parcel, either the related piece or anything else. And so once we focus on what's really at issue here, the 7.75 acre related tract using the actual development plan for that site, rather than spinning our wheels talking about a purely hypothetical and not going to happen redevelopment of the entire 27 acres, I submit to you this task becomes much more manageable. The evidence will show you that the related proposal doesn't cause infrastructure problems, either traffic or sewer, and is consistent with both what the county has long said should be here and with what the current development in the area justifies. For traffic, for instance, this is a busy shopping center as we sit here today. This is not a farm or a forest that's being turned into a new subdivision. This is a redevelopment of an existing active regional destination shopping center. So it is not fair or accurate to just ask what the traffic will be once the project is complete. We also need to ask what the existing traffic is. It's also not fair or accurate to hold the developer, the property owners, and the city to account for hypothetical developments that aren't proposed and won't occur, like turning the whole 27 acres into a cluster of drive-through fast food restaurants. We're not going to do that. And so you shouldn't let someone tell you and scare you with the consequences of what would happen if that absurd hypothetical occurred. The sewer issue is even more of a red herring. Even setting aside the fact that there are multiple restaurants and a car wash on the current site that won't exist anymore once the redevelopment occurs, they will come off the grid. But you don't even need to get into the weeds of that. Annexation doesn't change whether the county has the power to review any of these properties for sewer capacity, nor does it restrict their ability to impose conditions if the science actually merits those conditions. Because pursuant to Dekalb's service delivery strategy agreement, Dekalb County handles the water and sewer for all of the portions of the county that are on Dekalb's system, including Brookhaven. And annexation won't change that. It does not change the county's authority one iota. So sewer issues aren't actually at issue in this case, because they could still put a stop to a development if that were necessary because of sewer issues, even after it gets annexed. The other way this dispute gets more manageable is if we remember that the statutory procedure is about the net land use change in connection with the annexation, not a comparison between what Related proposes and no development at all, just the existing status quo. The statute 3636-113 specifically says that the material increase in burden upon the county that the county has the burden to show you must be, quote, directly related, close quote, to the proposed change in zoning and land use in order to be relevant. So what you're asked to do is evaluate the net consequence and the net change. And while there are differences between the city's C1 and the county's C1, they're not as great as the county would have you believe. More to the point, tomorrow, you will hear that the county's existing zoning and land use plan for the parcel, the entire 27 acres, and the 6.75, would permit more intensive, higher impact developments today than what Related proposes to do. And that's the actual legally accurate and necessary comparison, not between Related and no redevelopment, but between what the city would permit and what the county would permit. DeKalb County is not entitled to ask you for relief from the new development if the new development does not create an impact in excess of what the county's own current zoning and land use would permit. Let me leave you with 3 things to keep in mind as we go through today and tomorrow. First, the proper focus for this procedure isn't about what might happen or what hypothetically ever could happen. It's about what is actually proposed and what's actually on the table. And given our stipulations to preserve their restrictions for the statutorily permitted maximum time of a year, that's the only zoning change for the entire site, for the 6.75 acres. The other 21 acres are not on the table. And there's no Buford Highway overlay on any portion of it at all. Second, this procedure calls for you to carefully examine net changes and consequences, not the false comparisons between Related's proposal and no development at all, or by using unrealistic assumptions about what the county will or will not do regarding infrastructure in the area. Please pay attention as you listen to these witnesses for their methodology and assumptions. What you'll see, I believe, is that the county's objections do not accurately describe what we've proposed, the 6.7 acre redevelopment. And that's because talking about the whole 27 acres and a hypothetical redevelopment of it as something that's never been proposed by any living human being is the best way for them to try and scare you. And third, we ask that you take the county's evidence with a grain or 2 of salt. The evidence, the testimony you'll hear tomorrow is that no less than the commissioner who chairs the DeKalb County Commission was supportive and enthusiastic about rezoning and facilitating this project up until he learned that Related and the owners of parcels B and C and elsewhere on the annexation area were seeking annexation. And then the story changed. The evidence you'll hear is that the county's concerns are exaggerated. The evidence will also show you that the truth of the project hasn't changed. It's appropriate for the area, particularly in light of the immediately adjacent, much larger projects, and it won't have adverse infrastructure consequences. And that's ultimately what we will ask you to rule tomorrow afternoon, that the annexation should proceed without further impediment, aside, of course, from the stipulations we've offered. Thank you, and I'm done unless you have any questions for me.
All right, thank you, sir.
Thank you.
Mr. Chair.
Yeah.
Just one quick question, Mr. Ash, because he listed them as stipulations. When you listed the first stipulation, you clearly stated for 1 year. When you listed your second stipulation related to the Buford Highway overlay, you didn't use the phrase 1 year. I just wanted to make sure that was applied.
Yeah, 36. Yeah, 36. I appreciate the question. 3636-117 says that the stipulations or the conditions that the panel may approve last for a year. And so the stipulation is for a year.
Thank you.
All right, it is, a little after 12. It's all right, everybody, we will break for lunch and then convene after that. We got time to get your witness in, and we'll start with the counties.
My witness has been here, pardon me, my first witness has been here since 9, so,
Oh.
I mean, he's here, he's ready.
Is it okay if we take a break for lunch?
Oh, yeah, sure.
30 minutes?
30, 45 minutes,
30?
Motion recess.
Let's be back at 12:45 and we'll do that. All right? Okay?
Thank you all very much. Yeah, did you say 45 minutes?
12:45.
12:45, got it. Thank you.
Donna?
Yep.
Ready?
I understand, his two sentences, he didn't say it exactly, and I just want to make sure there wasn't any.
For what it's worth, the panel is still, the mic in the room is still on.
Fair point.
Not that I'm not curious what you're saying, but so that you know.
Mr. Ash, you guys ready?
We are, sir.
Okay. Okay, we're officially back in session. Mr. Mitchell, I think, has gone to the previous witness. Oh, okay, yes, so. Everybody's ready, we'll start. Mr. Mitchell, the floor is yours, sir.
Ready? And let me explain. I'm a low talker, so y'all are not gonna be able to hear me if I
Half the time. I'm hanging on here like Mike does.
I'm gonna use the notebooks rather than try to post all the exhibits screen.
Perfect.
If everybody's okay with that. I think, because a lot of them are maps and some light print on some of the stuff.
We're in the black binders, right?
You're in the black binders, volume 1 and 2. I put those volumes in front of the witness on either side, so he ought to be able to flip pretty easily, in those documents.
And I also want to thank Miss Woodbury while I have the chance for driving to my house last night in the rain to deliver my copy of those binders. Y'all are kind to have done that.
Frankly, we weren't sure what the technology was going to look like, and I prefer paper still, so. Baker, will you raise your right hand? You swear or affirm the testimony you give before this panel be the truth, the whole truth, and nothing but the truth, so help you God. All right. If you would introduce yourself to the panel.
Good afternoon. My name is Andrew Baker. I'm the Director for the Planning and Sustainability Department for Dekalb County.
And what is your educational background, Mr. Baker?
I have a bachelor's degree from Marvel College in Business Administration and a master's degree from the University of Tennessee, Go Vols, in Knoxville.
And what is your master's?
Excuse me. I can't hear the witness very well. Y'all need to move closer together and move that mic closer to him.
Let me move.
All right.
We can move it closer to the witness. Just,
Okay.
Yeah,
he'll be talking.
yeah, be careful, it's touchy.
You want me to come down here or you good?
Probably.
Yeah, I guess we better.
A lot of trees.
All right. What is your master's degree in?
My master's degree is in urban and regional planning, and it is from the University of Tennessee.
And tell us a little bit about your professional background.
Upon receiving my master's degree, I actually went to Florida, where I worked in the public sector for the Hillsborough County City County Planning Commission. After working there and for a few years, I ended up working at a landscape design firm, followed by an engineering firm for some time. So I got some experience in the private sector as well as the public sector. I then actually created my own firm, A. Baker and Associates, which I operated for 15 years while I was in Tampa, Florida. I actually ended up with contracts such as being a zoning hearing master for Hillsborough County. So in other words, rather than the Board of Commissioners hearing all the zoning cases, they would have or hire a hearing officer. And so I would hear all the zoning cases for that board and make those recommendations to the Board of County Commissioners. After that, I ended up in DeKalb County.
How long have you been at DeKalb County?
14 years.
Do you remember when you started?
June 2006.
And what roles have you done or performed while you've worked at DeKalb County?
When I first came to DeKalb, I actually was the assistant director and over the planning area, which meant that I dealt with the long-range planning as well as the current planning, which would be the comprehensive plan, as well as all the zoning activities, the Zoning Board of Appeals with the variances, the Historic Preservation Commission, and our community councils, as well as our Planning Commission for sketch plan.
And tell us about kind of your progress as director.
So at that particular time, I had a staff probably in the planning section of about 25. After that point, an agency came for the director of the department. So I think it may have been May of 2015 that I became or applied for the director position. By becoming the director of the department, I'm responsible not only for the planning or current planning section, but also the long-range section, but also it includes the development services. And as you're aware, development services deal with everything from plan reviews to inspections and land disturbance permits and all of those activities. Over the course of time, the administration has had code enforcement or code compliance as part of the department. And currently business license as relates to all alcohol and business license are in the department.
Right. Is zoning also under your purview now?
It is.
Right. So fair to say that when it comes to zoning and land use, you're kind of at the top of the pyramid in DeKalb County.
When I first came, one of the primary emphasis of why they wanted me to hurry up and get here was because of the comprehensive plan. The first iteration was due. And yes, all the zoning, which has to comply with the comprehensive plan, is in my shop.
All right. Now, do you have any licenses or certifications that are professional in nature that pertain to what you do?
I am, one of the big issues, especially in Florida, was making sure you had your certification. So I did take the exam, and I am AICP certified. And that
Tell us what that acronym means.
American Institute of Certified Planners. And it also means that you have to continue your education. So you have to continue to take classes to maintain your certification. As a result of that, I have actually secured opportunities to review conference proposals for the National Association of APA, and I'm also a member of the Georgia APA, and I've actually spoke at numerous conferences on the national level.
All right. Tell us what the APA is.
American Planning Association.
All right. And when you've spoken, does that mean do you teach folks that are being certified also?
What you have to do actually in that case is different subjects. You have to submit a proposal or a session topic, and you have to have either a panel or the type of format that you're going to present to educate members from the national level on topics.
How often do you do that?
The national conference is once a year, and I probably have presented in 4 of the last 5.
Right. I would tender Mr. Baker as an expert witness with regard to planning, zoning, land use, generally and in DeKalb County specifically.
So noted, so stipulated.
Thank you. All right. If you will, in volume 1 of the exhibit books, turn over to tab 9. In the record, I'd be saying I'm handing you what we previously marked as exhibit number 9. What is exhibit number 9? Can you identify that for us?
Sure. Exhibit number 9 is the current zoning ordinance for DeKalb County.
All right. And what is are you familiar with the subject property that it's all about?
Yes.
And where is it located?
Located primarily at the intersection of North Druid Hills and Briarcliff.
All right. How is that property currently zoned in DeKalb County?
Current zoning is C1, which is our general commercial classification.
All right. If you would, help us in the zoning ordinance that's marked as exhibit number 9, is there a list of uses, or is there information in there that tells us how you can use property that's zoned C1 in DeKalb County?
Yeah, what we tried to do with the zoning code, and I was there actually, we hired the firm to do it, and that was to update the zoning code to make it more user-friendly.
What
So,
page are we looking
if
at?
you go to page 3, there's a permitted use table that looks like this. Yes. And so what we tried to do was to help people to really be able to use the code. So if you're curious about a particular use and whether or not it's allowed, we listed the uses on the left-hand side, and then across the top, we listed the zoning districts so that you would know whether or not that particular use is allowed in which zoning district.
Now, in DeKalb County, on property that's zoned C1, on a particular parcel, can you do multiple commercial uses on that property?
Actually, DeKalb's code is a little bit unique, but you can do different uses. For instance, you can do professional office, or you can do a restaurant, or you can do the general commercial type uses.
Can you do both a restaurant and an office on the same parcel under C1?
Under our code, you'd have to look and see what the specific zoning is, and for us, primarily, it would allow the commercial retail use.
Okay. If you wanted to put a mixture of uses on property, what would you have to do in DeKalb County?
DeKalb County, for instance, if you wanted to do residential, you could actually just look on the first page and you see where it's grouped under residential, and it would tell you the zoning districts across the top that allow the residential uses. Under DeKalb County's code, C1 does not allow for apartments and residential uses.
Okay. If you wanted to put, let me do it this way. Were you involved in the creation of the DeKalb, what we marked as exhibit number 9?
Yes, I was.
Is what's in the notebook, if you look, keep your finger there, but look at the first page, is it a certified copy?
Yes, it is.
All right, I would tender exhibit number 9.
No objection.
All right. Now, if you were going to put a number of uses on a C1 piece of property, a restaurant, an apartment complex, and an office, could you do that on the same parcel if it were zoned C1?
No, you could not.
If you were going to do that type of thing under DeKalb County zoning ordinance, what would you have to do?
The commissioners would require that you rezone the parcel. So our C1 actually allows, for instance, the retail uses. If you want to add retail and residential, you would have to rezone it from C1 to one of our mixed-use zoning districts.
In the rezoning process in DeKalb County, from the time someone comes in and submits a rezoning application or maybe meets with staff, walk us through the process so that we understand what's involved in DeKalb and rezoning a piece of property.
Sure. For DeKalb County, even though the state laws require ZPL, zoning planning laws require you to have a planning commission meeting and then a board of commissioners public meeting. In DeKalb County, the commissioners feel that public involvement is of the utmost importance. So before a person could rezone from C1 to a mixed-use district, they would have to have a meeting with the surrounding residents or that neighborhood association prior to even beginning the formal process for rezoning the property to a mixed-use classification. After they've met with the neighborhood and we have posted the property in terms of that a rezoning is coming up, and we mail the notifications to the surrounding property owners within 250 feet, that applicant would then have to go before our community council. So not only do you have a pre-submittal meeting with the community, you have to have a meeting with our community council. After that, you'd have to have another public or community meeting in front of the planning commission. After you have that meeting, you have to have a public and community involvement meeting with the board of commissioners, and it's the board of commissioners that makes the determination.
Community councils, is that a single body, or are they like the city of Atlanta where you've got different councils in different parts of the county.
In DeKalb County, we have 5 different community councils, one of the commission districts.
Okay. And the citizens, how many citizens sit on a community council?
15.
And
I'm sorry,
15.
15 or 50?
15.
Okay.
Sorry about that. and those are appointed by the district commissioner and the super district.
That's an interesting question, because that's a little different in DeKalb County too.
Oh, yeah.
Explain to the panel, because we may hear about district commissioner and super district commissioner. Explain to the panel, if you would, that arrangement in DeKalb County.
Yeah. DeKalb County has 5 commission districts that are specific. And from that, they also have 2 elected officials that represent one, the east half of the county, super district, and the other commissioner represents the other half of the county as a super district.
Who is the district commissioner for the area where the subject property sits?
Commissioner Jeff Rader.
And who is the super district commissioner for this area?
Commissioner Kathy.
And, okay. And so you were telling us how these community councils were created. They're appointed by the district commissioner and the super district. Are they approved by anybody?
The process is that my team actually trains them to help them to understand zoning and the comprehensive plan and all of that. And they're nominated by the so many are nominated by the district commissioner and so many are nominated by the super district commissioner. And it goes before the board of commissioners to get approval.
Do they have to be residents of the area?
Yes.
And is that process set out in the zoning ordinance?
It is.
Okay. We've already started using some terminology without defining that terminology. And C1 can mean different things in different jurisdictions. What is the name that DeKalb County gives the C1 classification?
General commercial.
Okay. Are there other commercial classifications?
Yes.
And if you will, turn to exhibit tab number 10.
Before you do that, can I ask a quick question?
Sure.
You said they have to be rezoned to mixed use. What is the category for mixed use? I don't see one.
The very end of the call table, the MU1, the MU2, 3, 4, and 5. Those are the mixed use. And the level of intensity is based on the higher number.
Is that per acre or something like that, the 2, or not just nothing?
I'm sorry if I could. The MU categories, though, must correspond to the comprehensive plan, so you couldn't do a MU5 in a category like a neighborhood commercial and do that.
Comprehensive plan is not codified, though.
Ours is. It's adopted. The comprehensive plan is adopted and this is codified. Zoning code.
Correct, but the comprehensive plan is a roadmap, not a legal document.
DeKalb County considers it a legal document because it is adopted by the Board of Commissioners, and it is the roadmap for future development.
Correct, that's what I said, but it's not illegal. I mean, well,
it's adopted like an ordinance.
I'm very familiar with that.
If you will, I'm sorry.
But it is a roadmap, not a legal document.
And I should have told you the panel members may have questions for you as we move on. It's not like a jury trial where
yeah, we get that every now and then.
Take a look if you, what?
To be clear, you mentioned it earlier that you select people to be trained. Then the commissioner and the super commissioner get picked from that pile, right?
No, it's the opposite way. The commissioners nominate, and then if the board approves those individuals to be on the community council, once they're ratified by the board of commissioners, then we actually train them.
Okay, if it's all right, nobody breathes or sneezes, take your mask off when you ask a question, maybe we can hear better. Sorry, thank you.
All right. If you would, take a look at behind tab number 10.
And there's actually 2 pages behind tab number 10. All right, you're looking at the document that, identify the what's the name on the bottom of the map you're looking at?
The map that I'm looking at is the zoning map.
Okay, what's the label on the bottom in the big black letters?
Sorry, Briarcliff Road and North Druid Hills Road are zoning.
Okay, so can you identify where this document, is this the entire zoning map for DeKalb County?
No, it is not.
Tell us how this relates to the entire zoning map for DeKalb County.
This is just one segment, which actually zooms into basically North Druid Hills and 85 and Briarcliff, just so that you can see the parcels and the underlying zonings of those parcels.
Is this part of the the adopted zoning map of for DeKalb County?
It is.
And is this a map that's maintained in or by your office?
It is.
I would tender, let me identify the other one too. If you'll turn to the other map that's behind tab number 10. What's the label on the bottom of that one?
Actually, in my handout, it's actually still the zoning map.
So it's the same thing?
Yeah, okay, not the land use.
All right.
It just seems to be a slightly different area, shifted.
Okay.
Probably that one's the end and this labeled wrong, maybe.
Yeah, we can use this one. Just hold this one up to the screen so that the other side can see it.
Yep, this is it.
Turn it around so that it's on the screen. There you go.
Okay, so this particular map is the Briarcliff, at the bottom it says Briarcliff Road and North Druid Hills land use. And this is the,
Tab 12?
It's also behind tab 12.
so it is the future land use.
Yeah.
So, yeah. Okay. Okay, so the land use map is behind tab number 12. Is that the entire land use map for DeKalb County?
No, it's not.
Right. Tell us how that relates to the entire land use map for DeKalb County.
This particular is just a zoom in of the overall land use map or adopted future comprehensive plan for DeKalb County that focuses in on the Briarcliff and the North Druid Hills area.
Were you involved in the process that led to the creation of that particular land use map?
Yes, I was.
And is that land use map maintained in your office?
It is.
I would tender both exhibits 10 and 12, the zoning map and the land use map for the area at issue.
No objection.
All right. Looking back on tab number 10, looking at the zoning map.
The areas in white on the map are not part of unincorporated Gwinnett, is that correct?
Yeah, DeKalb, yes.
Right.
On exhibit number 10, Councilmember Chris asked about the white areas on that map. What is the white area that's on that map?
Sure. For DeKalb County, we only put zoning and land use character areas on the unincorporated county. So the other areas beyond that would be in a municipality. That's Brookhaven specifically.
On the map, right.
And there's a legend on this map. Do the areas have both a color and a letter associated with them that shows the zoning?
That is correct.
I'm identifying that in case this is a black and white document someday, so that we understand what is shown. All right, let's go to tab number 12.
I'm sorry, what's the difference in these two maps? I mean, I'm trying to look at one's upside down. I mean, it's the same area, correct?
To me, it looks like that's just two copies of the tighter.
It's shifted slightly to the north. The second one shows a little bit different.
So really, we
We've got the same area.
it's the same area. I believe,
It's
so-
the same area, maybe a little bit different perspective.
All right.
Tab number 12. Mr. Baker, go to tab number 12. All right. Now, this has there's some letters and colors. Tell us what these, if you will identify the color and the letter, and then tell us a little bit about what those various legend materials mean.
Sure. The Briarcliff Road and North Druid Hills land use map is actually showing you the character areas that were adopted in the comprehensive plan. The brown areas are showing you the neighborhood center. And based on the CAB's plan, the neighborhood centers are actually, the intent is to serve a smaller group of neighborhoods. One of the things about the DeKalb County plan is that we had the activity centers concept. And so we put in a smaller circle, which is the brown one, for a neighborhood center, which allows up to 24 dwelling units per acre. The next size circle is a town center, which we allow up to 60 dwelling units to the acre. And then we also had regional centers, which allows over 100 dwelling units to the acre. So what you see here in this subset actually is the neighborhood center, which allows for 24 dwelling units to the acre. The sub is actually suburban character area in the comprehensive plan. That is a predominantly single-family residential district. It allows up to 8 dwelling units to the acre. And the OP was our office professional district, which, so the intent of that, again, is primarily office types of land uses. One of the things about the CAB's plan is that it has the range. And so even the neighborhood center allows up to, and the suburban allows up to 8. But with DeKalb County, you always start with the base density. But the base density, for instance, in the suburban is 4. If you want to maximize the character area and get to 8, the county is looking for you to give something back in terms of your development proposal.
Just white sub, is that an island?
Yeah.
I'm looking on that, I see a white.
It should be actually, I don't know why it's an island actually, but I would think if it has sub on it, then it is the suburban character area.
So it's really unincorporated?
I believe so.
What's the OP stand for?
Office professional.
Right, and then the INS?
Institutional.
What's the base density for neighborhood center?
The base, I think it is about 12.
So if that's the base density in that area, what do you have to do in order to increase the density allowed for development?
The county would be looking for whether it is, I'm going to say, some sustainability principles. If you're doing residential and you're using Earthcraft, LEED certified type of buildings, you have enhanced open space, you're doing things, art in public places, you're giving the county some amenities back that the overall community can benefit from, rather than just maximizing the site at 24 dwelling units a day.
Is that administratively approved, or is that a public hearing process?
Again, if you are in C1 and you're changing to the mixed-use designation, you're going to have to go through the public hearing process to rezone it. If you already had the mixed-use designation, then we will be looking at and analyzing the percentage of open space, working with you as a developer on the type of public art that you're putting, and also reviewing your LEED certified buildings as part of the development process.
Okay. All right, take a look, if you would, at...
Let me ask you a quick question. Mr. Mitchell mentioned earlier before you were here, that you had NC and TC. Can you tell me what a TC is?
TC is the town center, which was...
There's none on this?
No.
Okay.
But the overall principles of the comp plan was based on those size circles, and that have density caps based on which one they were.
If you don't mind, are you familiar with ours in Cobb at all?
No.
We have NACs and RACs, which is Neighborhood Activity Center and Regional. Is that pretty much correlated to your? I'm just trying to get it in my mind.
Sure.
I'm sorry, I don't mean to try to make you.
And I appreciate the question. From our standpoint, the neighborhood centers, again, are the smaller sales.
Right.
You know, and they should just focus on the people for their quick items that
Right.
they need. And for us, our regional center originally was Dunwoody, North Lake Mall, and Stonecrest Mall.
Yes.
So that's where the county thought the highest density should go.
Okay.
The town centers are those in between there, and the maximum, again, is 60 dwelling units to the acre. But in this particular area, it was 24 was the max.
Okay, so that, in my mind, that correlates to our NAC and RAC.
Okay.
Sorry, we don't have a TC.
What's the base in town center, you know?
It's actually in the plan, but
Let's take a look at that. Turn to exhibit number 11, tab number 11. Can you identify this document for me?
sure, this is the 2035 comprehensive plan for DeKalb County.
Is this the current comprehensive plan for the county?
It is.
Right. Were you involved in the creation of this particular plan?
I was.
What was your involvement in the creation of this plan?
The plan has to, of course, meet all the conditions of the Department of Community Affairs, follow the guidelines from the Atlanta Regional Commission. I have a staff that actually focuses on collecting all the data that's necessary to include it in terms of projections and so forth. But also part of any planning process really is to identify what the existing conditions are, as well as what are you projecting, what want the community to look like over the next 25 years. My involvement would have been supervising the work as being done, to review the document to make sure it complied with those requirements from the Department of Community Affairs, also to participate in some of those meetings with the public and hear their comments firsthand, and as time allowed, also to just drive around and look at the specific things that are on the ground to make sure we're going in the right direction.
How many public meetings do you have during the comprehensive planning process?
Numerous. And the reason for that is you start out through your cycle to, you have public participation, you want to have as much buy-in from the public before you get to the adoption stage. And then again, DeKalb has a lot of very vocal neighborhood associations as well as leaders in various communities that are going to come to the meetings and make sure that their opinions are heard. So we can go through a complete cycle for trying to adopt it through the community council, planning commission. Again, we're having public meetings before we get to that point. Once we feel we have consensus on it, then we'll go before the community council, planning commission, and the board of commissioners. If the residents come to those meetings, even at that point with their red shirts on, the commissioners are going to defer it again. So we're going to have to go back and have those same meetings with the community council, planning commission, and the BOC.
How often is this updated?
Sorry?
How often do you update this?
Every 5 years. That's correct. We're getting ready to update it again.
Maybe implicit in your previous testimony, are these meetings prior to the community councils well attended by the citizens?
And it all depends. The majority of the time, we work with the commissioners to make sure that we get as much participation as possible. So you do the traditional meetings, but you also try to do other meetings that are outreach as well. And so there are times that the meetings are very well attended.
Do the meetings in Commissioner Rader and Gannon's districts tend to be well attended?
Very well attended.
If you would, I would tender exhibit number 11, the 2035 comprehensive plan.
No objection.
Thank you. All right. If you will, turn over to page 64 of the comprehensive plan, which is exhibit number 11.
64?
64.
This is very well done, Mr. Baker.
Would you tell us we're going to take a look at basically 5 or 6 pages out of this entire document. On page 64, tell us what that is, or explain to the panel what that demonstrates.
Sure. Again, what we tried to do was to make sure we had a user-friendly document, and what we found is that people don't really understand unless you have a lot more graphics. So not only in our comp plan, but also in our zoning code, we tried to use graphics to illustrate and to explain and to help people understand. The page that, on 64 of our plan is talking about town center, which again, this one is the one that's a little bit smaller than larger than the one where the subject property is in. But what we tried to do is to show people the intent and what a town center means. So it's not the most intense, but it does mean that you try to have some open space, you try to have some retail on the first floor, and you try to have non-commercial, at least on the upper level. So you could do residential, or you could do office above the street level retail. And so it was just trying to give people a visual of what you could possibly have.
Is somewhere in these couple pages, is the base density for residential development in this area?
Is actually in the zoning code.
Oh, it is? Okay. All right. We'll go back and look at that, so it's specified. What is, if you will, turn over to page 67. All right, tell us, identify for us what pages 67, 68, and 69 are.
In mine, the page 67 is actually the neighborhood center. And so what we're trying to do is to demonstrate to you, again, graphically, what is the level of density or intensity that we expect in those particular districts. And so on this one, you just see a street level retail, because again, the purpose of it is to have people have a place to come that lives in the immediate neighborhood. It's not trying to attract people from across the county. But we wanted to reuse those existing areas of commercial, and so we said, well, we can build on top of that. So that first image is showing you how you can go back to something that is just strictly a commercial, strip commercial or something, and if you rezone it to one of the mixed-use categories, then you can actually build on top of that and therefore accommodate the people in that surrounding area.
All right, if you look at page 68, explain to us that the chart with the little blocks on it.
So again, what we're trying to do graphically was to just show you how the heights would work. And so the blocks are just saying over 12, up to 12 and a 4, and it's giving you the preferred heights in the neighborhood center. And you can see that in our neighborhood center, the preferred height is 1 to 3 stories. Not the higher ones, but the first one is the preferred height that we adopted in our comprehensive plan. And if I could touch the graphic above it.
I was going to ask about that.
Okay, because even though you have a neighborhood center that allows up to 24 dwelling units to the acre, what we have is we will have a preferred intensity graphic to show you that just because the character area allows 24 or the whole area allows 60, we want you to put the most intense at a specific location. And so as you can see on the graphic so the most intense will be in the center with a medium intensity there, and then you transition to less intense as you get on the end of that. The bottom chart graphic actually is giving you another demonstration of that. And if you can read that at the very bottom in the pink, it says residential district. All of our commercial areas pretty much abut up to residential. So what the county had done was to say that if you're going to be close to residential, we want you to transition. We don't want the tallest building right next to the residential neighborhoods. We want next to the neighborhood, we have a transitional height plane. And so we tried to illustrate it with a graphic to say, no, you can't do intensity on the whole neighborhood center. You have to put the most intensity in the core, and then you stair step down, and then maybe put townhouses on the fringe because they're next to the residential.
Right. In neighborhood center, are you able to obtain the entitlement to build higher than 3 stories?
The only way you can increase height above 3 stories in Dekalb, you have to ask for a special land use permit. So in other words, you have to go through a public hearing process. So Dekalb has put a cap on the height above that. So if you want to do, even if it's residential apartments at 5 stories, to go above 3, you have to go through the special land use permit.
Can you get a special land use permit in conjunction with getting the property rezoned?
They actually, you can do them simultaneously, but there's 2 separate applications in Dekalb.
Can you do the public hearings at the same time?
They are.
Consider a C1 to mixed use, is that a down zoning, do you think?
I would think of it as an upzone.
Really?
Yeah,
C1 is commercial and you're going to mixed use, you think that's an upzoning?
I would. Because
you allow residential as opposed to a mall or something?
Because on the commercial, you're only looking at a single use of the property. So if you just have retail, then you're looking at that. So for me, you're looking at retail traffic counts that are generated. Then you're looking at, I'm just going to say 25, 50, 100 residential trips being generated by the project. So to me, you've made the property more valuable by making it mixed use and getting not only retail revenue from it, but you're getting the residential revenue.
But the retail would be like like a mixed use with apartments above retail or something.
From our standpoint, the C1 just allows commercial.
Correct.
So that would be the retail component.
You consider commercial?
I don't consider it less valuable.
No, I don't say less valuable, but more zone. To me, they're more intense use than residential. I don't know, I'm just trying to understand.
Yeah, and again, my feeling on it again is that if a person has a single use of commercial, then that's one use. And if you allow the person to do mixed use, and they're able to do commercial, office, and then do apartments on that site, to me, you've increased the intensity of that site, and to me, that's a higher use and a more intense use than having a single use office depot on the site.
Sorry, I just...
No, you're fine. I mean, we're here for you. All right. When was the comprehensive plan redone entirely? Where you went from one comprehensive plan to the next?
The first one actually was 2007, and so the next one was about 2015.
So the 2 comprehensive plans, this one's the 2015 to 2035, correct? What was the previous comprehensive plan? You know what the...
I think it was 25.
And were there changes between what was allowed by the comprehensive plan on the subject property between those 2 comprehensive plans?
Have to look back at the 2025, but I think there was changes, but the changes would have been the result of the LCI.
Okay. All right, let's talk about that. They've heard the terminology. Obviously, these members are probably familiar with that process, but give us, for the purpose of the record, give us a brief description of what the LCI process is and what it means.
When DeKalb County adopts a comprehensive plan, we're just looking at the overall county and coming up with a general vision of what we want the county to look like. So we're just drawing, again, from our standpoint, we drew circles and say, okay, let's put the minimum amount of the density and intensity in this circle, then let's have this side circle and then this side circle. Once you, some neighborhoods start to complain about the amount of rezonings or the amount of development that is occurring in their particular area. So they will petition the county and say, we need a more detailed study. Comprehensive plan is the big picture of what you want. We need you to drill down at our particular neighborhood. So we will actually make out an application to the Atlanta Regional Commission for this LCI study. With the LCI study, we're able to drill down and have a target area that we're looking at. We can have specific meetings with the residents in that neighborhood association and the leaders of that community and go into detail, get in the weeds about what is it that you want to have happen over in this particular area. And so we go through that and we have public meetings and all of that, like you said, all over again. And so those residents say, You may have said that you wanted intense development over at this location. But now that we're drilling down on it, we don't want that. And so that's when you come up with the North Druid Hills LCI study, which actually downgraded that area from, for instance, a town center down to a neighborhood center because they said there was too much traffic congestion and too much being built in that particular area. So Dekalb listened to the residents of that community, and they adopted the North Druid Hills LCI, and they reduced it down to the NC that you see on the character area.
They did that in the comprehensive plan. They they correct any zoning that was already there?
Good question. The way Dekalb does it is they keep you with your underlying zoning because they don't do anticipatory zoning or anything like that and say, well, because this is an activity center, we're going to make it mixed use. No, they leave it still C1 so that at any time in the future you decide you want to change it to do something more intense, you have to go through the public hearing process.
The variance process.
And for them, the Board of Commissioners don't hear the variances, they let the Board of Zoning Appeals hear the variances, so they only hear the rezonings and the special land use permit.
Do you, at the end of, say, each calendar year, go back and look at any rezonings or special land use permits and change the comprehensive plan to match what was redone?
We try to track it. And at the end of the year, based on what's been going on, especially during an update, we may do a land use amendment to the comprehensive plan, or we may propose it. But we have to definitely have a meeting with what they call Planning and Economic Development Subcommittee of the Board of Commissioners, and we have to explain to them that this is what's been going on. We're looking at doing a text amendment or a map amendment over here because of that trend and so forth. So we have to have support from the district or super district commissioner.
Thank you.
Take a look, if you would, turn over to Exhibit 13 or tab 13. Can you identify for us what's previously been marked as tab or Exhibit 13?
Yes, this is the North Druid Hills LCI.
And did this document come at the beginning of the process or the end of the process?
It's at the end of the process.
Is this document, does the Board of Commissioners do anything with this particular document?
In order to give studies teeth, because a lot of people say plans just sit on the shelf and nothing happens with them, we started amending our comprehensive plan to add any type of small area study or LCI that has been that we've been through the process, and so we adopted as part. Now, this is part of our comprehensive plan.
Give me the date on this. I don't see a date. Maybe I'm missing it.
Was it 2012?
I think it was 2010. We will find that out and confirm it.
I mean, if it's 2010, that's 10 years ago, so it's time to be updated, I would say.
Let's talk about that. The proposal to update this particular, well, first of all, are these LCIs ever updated?
Yes, they are.
Okay. And has there been any discussion or proposal about updating this one?
We discussed it, and I think that because, again, as people were coming asking for rezoning in this particular area, some of the neighborhood association representatives were saying we need to take a look at this study again. And so what we can do is to go back to ARC and ask to do a supplemental or an update to an existing LCI. This was discussed verbally with some representatives from the city of Brookhaven. Our thought on it was that we could actually benefit from a joint application between Dekalb County and the city of Brookhaven and say that we're working together to update this particular area and this particular study. Because we saw the pressures that were going on with CHOA and stuff, and we said that we could work together and do an application. But we really can. I think that it requires you to do a match, like a 20%. So we were going to put in half of the match and allow the city to put in the other half. And we just didn't get together and traction to actually make the update happen.
What was their response?
There just seemed to be a lack of interest.
Doesn't the LCI allow you to get and receive funding and grants from ARC?
It does,
In order to get those, you have to have an LCI study.
and the matching funds.
Right. That's called the Livable Cities Initiative.
It is.
So you're really forming little cities.
Not
Not really, but it's livable areas, I guess.
It's, yeah, livable areas. So the major problem that was identified in this area was transportation issues and amount of development.
Very well done.
Thank you.
You made an allusion earlier to the fact that some folks think that plans just sit on the shelf and don't impact decision-making. Is that true in DeKalb County?
I think that it has been true in the past, but now with the amendments to the comprehensive plan to give it teeth, what we do is we go back when a person comes to rezone or even develop, we go back and look at the particular small area study of the LCI and implement those policies and those guidelines as part of the development.
Let me ask you this. If the property, subject property was 27 acres on the other side of the property, were not annexed into the city of Brookhaven, in your work position at DeKalb County, do you anticipate that this property is going to be redeveloped?
It was our goal that it would be redeveloped. That's correct.
And redeveloped in what way?
Again, because the underlying property has a zoning code of C1. For us, whatever a developer proposed would still have to go back in front of that neighborhood association and say, I'm looking at building such and such, and try to get the support from the neighborhood group. It would still have to be heard by our planning commission, community council, and our board of commissioners. So to think that anyone can get the maximum amount of any of our categories does not happen, because you have to get public support and input. And we would try to use our principle of the plan, which talks about the core, which talks about transitional heights, which talks about distance and separation from the single-family residential and protecting those with what is being proposed. So there will be a lot of public participation as part of our process.
Just to be clear, this North Druid Hills is the area we're talking about.
It is.
Okay.
Is there a map in the document that tells us what the area, the study area was?
Maybe on the front page here.
One that's larger.
Yeah. There is a...
You look at page 3. Page 3. Find another one.
There's one on, no, that's a particular concept plan. There's one on outline. Study area.
That one outlines the study area, but if you look at, to me, if you look at page 104, you'll see the recommendations.
When you say recommendations, what do you mean by that?
The concept that came out of the process, but I'm trying to make sure that I have one that has the densities on it as well. Keep going.
So this particular corridor is like, it just goes up North Druid Hills, is that what it is? It's long and skinny? If I'm looking at page 105, is that it?
It's long, but it has activity centers.
Correct, but it's not wide.
Correct.
It just goes up the road, is that what it is?
That's correct.
Looking at the map on any of the concept plan or the maps, do they include property that is currently in the city of Brookhaven?
On the concept map, yes.
Okay. What parcels, which part of on the concept plan are shown or that are there are currently in the city of Brookhaven?
If you look at specifically on the original concept at 85 in North Druid Hills, And now, south of 85, where the Children's Hospital and so forth is. So the area on north of Briarcliff Road actually is now in Brookhaven.
Are joint LCIs conducted any differently than a single entity LCI?
No.
Process is the same?
Yes.
At the time the livable centers initiative study was done, did the city of Brookhaven exist?
The city of Brookhaven, what, they came in 12?
Not as
2012?
After that was Peachtree Corners was 12, Brookhaven was after us. Anyway, I don't think, this plan looks to be circa 2010, 2011, so this is before.
Yes, it would be. If we included this particular area, that would be part of DeKalb County at the time of the study.
Yeah.
Have you recently driven the area around the intersection in South?
Yes.
Describe to the panel, if you would, what that area looks like. The area that I guess is that the area that on the land use map is identified as sub?
Okay. The area that's identified as suburban on the map actually, and that's it on the screen as well, just shows all the single-family neighborhoods where you would find single-family detached homes, but they're individual lots. And so you have those in and around the subject property, which is that NC over there. If you drive around and look at the specific site, you guys are aware that, again, the Target and different things are there. It's true that the Walgreens and neighborhood, what I would consider neighborhood commercial, if you cross Briarcliff, that includes things like a nail salon, Willie's, a Nuke sandwich shop, just different things like that. Lens Crafters is on the other side along with some other uses too. But if you look at the height of what is on the other side of Briarcliff, it's just a single story type of Willie's restaurant and different things that are on a smaller scale. So if you use our core concept, what DeKalb County would expect is that you have the most intense development at I-85, where the Children's Healthcare is. And then as you move away from that, that your height and your intensity would tend to go down. So as you cross, if right there at Briarcliff, you have one-story Willie's restaurant, a nail salon, and so forth, as you cross that, you would not expect to go back up. You'd actually have the transition to the single-family neighborhood that exists. The principle for unincorporated DeKalb, when we did the plan when I first got here, was to make sure that you protect single-family neighborhoods. And that was why they put in the transitional height planes, and that was why they wouldn't let us do any proactive rezoning of properties, because they wanted to hold the line and make sure they protected single-family.
What's the vintage of those neighborhoods in that area?
They probably are the 70s or something.
Or do they appear to be ripe for redevelopment as well, or are they well established?
No, the single-family neighborhoods in that area are actually stable and increasing in value.
Okay. All right, let's take a look at Exhibit 15, if you would, tab 15. 15. Can you identify the pages that are behind tab 15?
Okay, so the first graphic is a map or a site plan showing the possible proposed development on the smaller site, 6.7 acres, I think, of the proposed annex area.
What are the pages? What's the back of that page? In our notebooks, it's a 2-page document. What's on the back?
And the back page gives you an elevation of the proposed development. One is a hotel, and the other one is a residential development.
When you say the elevations, are they from a particular perspective?
I think it's from North Druid Hills.
that the top one or the bottom one?
The top one, I'm sorry, is from North Druid Hills, and the bottom one says Briarcliff Road elevation.
Okay. So if that's the elevation from Briarcliff, what, does that mean that's what you see if you're driving on Briarcliff if this were developed?
That's correct. So on the, Brookhaven, current Brookhaven side across the street, as I mentioned, it is actually basically a one-story with the Willie's restaurant and the nail salon and so forth. So now what this is showing us is that on the other side of Briarcliff, you're actually going to be going up, it looks like it may be 5 or 6, 7 stories across the street.
You say on the other side, you mean toward 85?
On the, toward 85 is, no, the one story.
That's what I'm saying, the one story is toward.
That's correct. That's correct. What they're proposing in the elevation there is what would be on the south side, on the unincorporated side currently.
Everybody must log on in school, huh?
They come back. On our free Zoom time.
Back?
They're here.
Did you catch any of it?
Mr. Ash, did you miss any of that?
I don't think so.
I think I heard it all.
We just got a screen that showed connecting, and it looked like maybe we had lost the Zoom connection.
No, the last thing I heard was him talking about how tall the Willie's is.
Okay.
That's it.
When Brookhaven Incorporated, do you know what they did for a zoning ordinance?
Most cities, when they, create themselves, actually adopt the DeKalb County zoning code as well as the comprehensive plan.
Assuming that occurred in 2012, does Brookhaven zoning ordinance look like DeKalb County zoning ordinance today?
No, it does not. Most of the time after they adopt it and once they get themselves up and going, they hire a consultant or they create their own zoning code.
You mentioned most counties adopt the county. Have you any evidence that the new adoption county created, they adapt the comprehensive plan?
I didn't hear the question, I'm sorry.
You said most counties, cities adopt the county comprehensive plan. We're not too sure if the city.
I'm confident that the city did, because most cities, when they start up, they haven't had time to get everybody in place, a planning staff, a zoning staff, and all of that. So the easiest thing to do is just adopt what's in place, because you usually don't make immediate changes to the zoning code then. You get your city up and running, and then you hire a planning director, a zoning staff, and so forth, and then you start having community meetings to rewrite the zoning code based on what your city wants to have.
They gave no evidence proving that takes place. Just assumption that there's a possibility that it takes place, right?
I would say that there's a 95% probability that all cities, new cities in DeKalb, actually adopt the county's zoning code and the county's comprehensive plan.
Do you have any documentation can prove that?
I wasn't asked to bring any.
Everybody hear that? The other parties hear all that?
I heard the last thing he said was I wasn't asked to bring it. So I think I heard the colloquy between the panel member and Mr. Baker.
So our video seems to be going out, but our audio is working okay, apparently.
Yes, so the audio and the video that we have here is definitely working. This one went out, but I'm getting it back up.
Okay.
We also are still seeing the screen. So, I mean, the video is coming through here.
So it was just what's displayed on our TV was the only thing that went down.
Yeah, we just don't see we don't see Mr. Baker or Mr. Mitchell. We see these elevations.
Okay, should be back up.
Okay.
All right.
Go ahead then.
Going back to the first page of Exhibit 15, what does it appear, based on this document, is the requested zoning for the 6.74 acre site?
From a DeKalb County standpoint, you could not do this development in unincorporated under C1.
What are they asking for in Brookhaven?
Well, according to this, they're asking for C1 with Buford Highway overlay.
Okay. Do you know, does DeKalb County have a Buford Highway overlay character area?
We do not.
Okay. Do you know what where that comes from?
When this was part of unincorporated county, the county's vision for Buford Highway was to benefit from the diversity of that corridor. And so we actually had considered it to be like a cultural village type of a thing, where if you wanted Asian, or if you wanted Mexican, if you wanted any type of Thai or Chinese, that it had all these types of restaurants, shops, and markets, and so forth that you could shop. So that was our vision of it, was more of take advantage of the opportunities that exist. From looking at the Brookhaven overlay district, I think it is to move from a suburban to a more urban, and to be pedestrian oriented, and to move away from automobile orientation. But in terms of a theme and vision of what it really was they want it to be, is just not clear from their intent.
Okay. Is Exhibit 15, is that part of the application for rezoning for the subject site?
It appears to be so.
Did that come into your department for review at some point?
I'm not aware of this ever coming to the planning department.
Now, if you would turn over to Exhibit 16. Is that a certified copy of the Brookhaven zoning ordinance or portions thereof?
It appears to be.
I would tender Exhibit 16.
I'm sorry, the tender is the entire code or just the excerpts? I'm not sure I understand the tender.
It's just the excerpts that were in our notebook.
Looks strikingly familiar.
Are you objecting?
I'm reviewing it to make sure I understand what it is you're tendering, Mr. Mitchell. Just give me a second, please. No objection.
In your review, have you identified any differences between Brookhaven C1 and DeKalb County C1 from a zoning perspective?
Again, it's my understanding that Brookhaven's C1 will automatically allow an applicant or a developer to go ahead and build any of the uses that are on their use table. So it could be retail, it can be apartments, it could be the hotel, and it's actually by right from the zoning district.
There's a note in the DeKalb County's zoning ordinance, C1, that live work is allowed. Describe for us what live work is, and tell us whether that's the same as well.
Live work would be allowing some flexibility for primarily a residential builder to be able to maybe use the first unit on the first level unit for something other than just residential. So I may be an artist and I want to display some of my artwork or work at home and live above. It goes back to the old time development that used to happen in the day, where you live above the place where you work. So it still looks residential and feels residential, but it has a little bit of flexibility to live work.
Are there any density caps or anything associated with that?
It would still be the same density that's a part of the multifamily or the residential development.
We'll take a look, if you would, at tab 17. It's in the second notebook. It's in this notebook over here. Volume 2. If you look at the first page of that, a certified copy of the Brookhaven comprehensive plan.
Yes.
Have you had the opportunity at some point to review the comprehensive plan for Brookhaven?
Only elements of it, yes. Some elements of it.
Does it appear to be identical to DeKalb County's comprehensive plan?
I would say it appears to include elements that all the city's jurisdictions within the Atlanta region has to have character areas and so forth. So from that standpoint, it's similar. It's not the same, no.
Character areas are different.
Correct.
Right. If you would go to at the top of the pages, there's like a base number. It says page 57 of 97. I would tender this certified copy of the comprehensive plan, Exhibit 17.
No objection.
What's set out on page 72? Or it's page 72 of the comp plan. It's page 57 of 97 of this exhibit.
Page 57 of 97 is the Buford Highway corridor character area.
Okay. What's the proximal relationship between this overlay and the subject property?
The overlay focuses on Buford Highway, and then if you look at the graphic, you will see the interstate, and as you cross that interstate at that interchange where it says North Druid Hills, and so the subject property is basically once you cross Briarcliff, right there at that apex.
Based on, if you would, take a look at the next page, flip over one page. Do they have similar drawings and charts like DeKalb County does with regard to their character area descriptions?
The drawing or a graphic that they show, again, if they're calling it higher intensity mixed use, again, I think that may be considered higher, but it's not as descriptive, I'm going to say, as the graphics that are inside the DeKalb County code.
The chart that's in the bottom right-hand corner of that table, what does that reflect?
The recommended residential densities and building heights. And so their high intensity is saying 100 to 150 and 10 plus stories. And their low intensity is saying 10 to 50 with building heights 1 to 5.
Okay. And then the medium is in between.
Right.
If you would, turn over to page, it's really small, but if you turn over to 75 of 97, then turn over to the next page, actually.
I'm sorry, could you say again what page you're directing him to? You cut out on me.
75 of 97 is a blank page, and then the back side of that, there's a number 76 of 97, but it's really tiny and you can't see it.
Thank you.
What is this? What does that reflect?
This appears to be the character area for the city of Brookhaven in this particular area.
Is there any other character area, Brookhaven, adjacent to the subject property, other than Buford Highway overlay?
There is not. If I could, though, I do want to point out one thing as it relates to the Buford Highway corridor, that on the page that you referenced on 57 of 97.
Yes.
But it says under community vision, it says that higher intensity land uses are appropriate in areas adjacent to I-85 with a step down in intensity near surrounding residential character areas. It said to the north. I would think that that same type of step down will be applicable to the residential on the south as well. Okay.
All right. Question. The map of all the character areas. So there's a reference to the area in red is referred to as the Buford Highway Corridor Character Area. Just wonder if this witness knows, is that the same boundaries of the Buford Highway Overlay District?
From my review of it, it appears to be the same.
So the entire Buford Highway Character Area
The red.
is covered by the Buford Highway Overlay District.
It appears to be.
Yeah, okay.
I'm assuming Buford Highway is in Brookhaven?
Yes.
Well, not all of it.
That's just the subject, yeah, this.
That's what I meant, yeah.
We have someone going to ask you. Buford Highway. Not the Buford Highway.
You got the other end, Buford Highway.
Yeah. I think Buford Highway goes all the way up to, Lake Lanier, I think. Yeah.
Talk a little bit about other developments, that the county has approved in unincorporated areas.
Excuse me, Mr. Mitchell, we talked about page 76. What are you trying to point out there? Is the subject property in there? I can't.
No, this, what I'm trying to point out is that this property is not on this character area map because it's not in Brookhaven yet. But the only character area that is adjacent to the subject property is the Brookwood, or the Buford Highway corridor character area.
Okay.
Therefore, do character areas tend to be larger than 27 acres?
Yes.
Okay. And when you are looking at a character area, do you usually look at them in relationship to the other properties around them?
You do, and so the intent would be to ensure that the land in all this particular area has the same characteristics, and you want them to grow in that same dynamics. So if they're included in the Buford character area, then these guidelines, principles that they have will be what they would utilize in terms of future development for that area.
All right. If you will, what are some of the other mixed-use developments that DeKalb County has approved in the last?
Decatur Crossing or Scott on Point, Point on Scott would be a couple that's over near Church, Decatur Road, Scott Boulevard, which was a Fuquay development.
Turn over to Exhibit 18, that's the first one you mentioned. Can you identify Exhibit 18 for us?
This is the area around Scott and Church and North Decatur Road, which would be one of the more recent developments that have been approved by the Board of Commissioners as a mixed-use development.
Okay, in looking at it, is this, like with regard to the other zoning map, is this a piece of the overall DeKalb County zoning map?
Yes, this is a piece or a portion thereof.
Right. And I would tender defendant to exhibit number 18, County Exhibit 18.
Objection based on relevance. Other than that, you've got a foundation for it, but I don't think it applies to anything related to this.
One of the things, panel members, that is indicated in the statute is whether or not DeKalb County has approved zonings, similar zonings to those requested in other areas in unincorporated counties. So we're going to spend a few minutes talking about other approvals by DeKalb County in other areas of unincorporated DeKalb, and hopefully it'll come to appear why it's relevant.
All right. Continue.
If you would, you talked about the development, or will you drill down and point us on this zoning map where that might be?
Okay, the intersection of Scott and North Decatur Road, where the O&I is, and the MU4, in terms of this is a zoning map. And the C2, all of that property would be part of what we're calling the Fuqua development.
Okay. So it basically sits in that triangle, or that point, Church Street in North Decatur.
That's correct.
Okay.
But if you would notice is that this is the underlying zoning that it was.
Character area for that property. I'm sorry.
Cotton Boulevard and North Decatur Road, and you're saying this is where the county has done new developments, right?
That's correct.
I go through that area quite a bit. There's a C1 there, north, C2. You all developed that or approved that area for
Yes.
development?
Yes.
You have housing there, which is what, 4 or 5 stories high?
That's correct.
Okay.
So if you look at the zoning map, you'll see originally this property was zoned O&I, MU4, C2. It had a multiple number of zonings. And so the applicant had to rezone it to mixed use in order to do the development that you see there today.
Okay.
If you'll turn over to the second page behind tab number 18, what is that?
That is the land use category. When I was talking originally about neighborhood center and town center and regional center, and I said there was one in between, this particular property is town center, which allows up to 60 dwelling units per acre.
What was actually approved on this town center character area site?
I'm sorry.
There's a whole.
Let me object to the question and object to the continued use of the exhibit, because I don't think that there's any evidence based on the description or the character area designation that the witness has just identified that this has got anything to do or is in any way similar to the subject property. So we renew our relevance objection.
Mr. Mitchell, is this one example or do you have more examples?
There's going to be this and then some general testimony about redevelopment in commercial corridors.
Okay. We'll stipulate that we understand what you're trying to do. Let's go on to the next one if you don't mind.
Okay. I need one more thing in the record on this one.
Sure.
What's the residential density on this town center development?
There's actually, if you split it, it was about 40 dwelling acres somewhere in it.
All right. Other areas that have been redeveloped in commercial corridors, give us a brief description of what those densities have been.
One of the things about DeKalb County is that because you have to rezone it from the underlying zoning, it goes through the public hearing process. The commissioners make a point of making sure that it doesn't have too much density. They put a lot of conditions on the property before it's approved. So when this one came through, there is a host of conditions that was placed on the property to ensure that it was compatible with the surrounding development. And for instance, the maximum height on this project in town center is only probably 7 or 6 or 5 stories, somewhere in there. They wouldn't let it go high even though it's in town center. The subject property that you guys are looking at is a neighborhood center. So therefore, if the commissioners would not allow town center to go more than 5 or 6, 7 stories, they would not allow the neighborhood center to go to a higher height.
I just want to clarify that that's the witness's opinion of what the elected officials may or may not do. That's you're saying they won't allow. That's his opinion of what the current elected body may not do.
That's why I was trying to elicit this testimony to establish what this Board of Commissioners had actually done in other areas.
Sure, but if they meet tomorrow, they could vote differently.
They could, but if I could, if you look at the Kensington Station over there where our MARTA station is, Carlos Arenas came through with his proposed development as well, and he was trying to do a mixed-use development right next to the Kensington Station. Commissioners followed the same process. Redan, someone came in with a mixed-use project. The commissioners followed the same process. At Covington Highway, the commissioners followed the same process. So based on their track record, I'm just saying that
they tend to try to minimize the height and the scale and the intensity of developments in DeKalb, and especially when they're next to a residential area.
So you're saying this was only 40 units per acre?
Correct. It goes up
If
to
I
60.
ever try to get 40 units per acre, they'd never find my body.
All right, one more area we need to cover now that we've talked about this town center. And I don't know that we have an exhibit yet that shows this. What's the next major intersection as you move away from 85 on North Druid Hills Road, away from the intersection of Briarcliff and North Druid? What's the next major crossroad?
The Claremont?
Yes. What's that area called? What's the, if you're going to a shopping center in that area, what do you call it?
Oh, something.
Toco Hills?
Toco.
Oh, you're going the wrong way, the other way then.
Yeah, I'm
Okay.
going away from 85.
Okay,
Yes,
Toco Hills, yes.
What's the character area on Toco Hills?
It's actually town center.
Okay. And why, because that particular area is further away from 85, why is it town center when this one is neighborhood?
When we were going through our public hearing process, and this is also in the North Druid Hills study area, so it was part of it. But as the residents came out in that particular community, they said that there was too much congestion already developing at close to 85. So they didn't want us to put any more density there. But they were willing to accept more density at the Toco Hills Shopping Center. So planning is a process where even though as a professional planner I might have ideas about what should happen where, you still have to go through the process of allowing the public to say, this, we live here, we're the ones that are impacted by the development, and this is what we want. So the elected officials actually listen to what the residents say, and sometimes what the professional says, but mostly it's what the residents say. And so when the people from the community came out and said, we'll take town center here, but we want neighborhood center here, that's what got adopted.
That's all the questions I have in this one.
Thank you. Mr. Ash, do you have any questions?
Mr. Chairman, it's Chris Balch. I got the cross. I don't know if the panel wants to take a break since you've been doing the better part of an hour and a half since lunch.
Hopefully you don't have too many. We're trying to move on to the next witness, so feel free to anybody need to. I'll let you ask questions and we'll see if the panel has any then.
All right, sir, fair enough. Mr. Baker, my name is Chris Balch. I am honored to serve as the city attorney in Brookhaven. How are you today?
Good, thank you.
We'll offer a go Vols back at you just because that's an appropriate thing to do as an alumnus. Let me ask a couple of questions. Lindsay, can you put up a copy of the zoning code from DeKalb 5.1.8, please? Now, Mr. Baker, in direct testimony, you said that with respect to C1, only one type of building that was allowed in C1 would be permitted under the code. Did I understand that correctly?
Under C1, you cannot do residential.
That was not my question, sir. Did you testify on direct that only one type of building that is permitted as a matter of right in C1 would be permitted on that parcel?
Maybe I'm misunderstanding your question. If you utilize the permitted use chart, you go across, there are multiple uses that could be developed in C1, not just for instance, not just a restaurant.
Okay, so if I put a restaurant and an office building on C1, that's allowed, is that right?
A restaurant inside a building can only be an accessory use, which means there's a minimum amount of square footage that can be. If the principal use of that building is an office, then that's what our code allows for it to be.
That's, again, not my question, Mr. Baker. If I put a building with a restaurant and a building with an office complex in it, that would be allowed in C1, is that correct?
I would have to look at that permitted use chart and read across for each one of the uses you're proposing on the left-hand side and then go across the top under the zoning district to see if what all the uses are that are allowed in C1.
All right, fair enough. If you look at page 6, please, of tab number 9.
In the black binder?
Referring to Mr. Mitchell's
Black.
exhibit.
White.
No,
Black.
black. No.
Black.
Apologize. 6 is behind that. It's the chart of allowed uses.
Right.
Sort of big the back of tab 9, page 6.
Yeah. Yeah.
So page 6, about a little better than halfway down, shows restaurant and food establishments. Do you see that category?
Yes.
All right. If you go across to C1, you see under restaurant and food that all of those are allowed as a matter of right, with the exception of a drive, right?
That's correct.
Okay, if we go back over, please, one page to page 4. At the bottom of the page, you see offices, correct?
That's correct.
And that section or the category actually extends over onto page 5. Is that also correct?
Correct.
All of those uses have Ps for permitted in C1, correct?
That is correct.
All right, enough. Now, with respect to the development at Scott and North Decatur, do you know how close the nearest residential property was to the area that you described would only be allowed for shorter buildings?
No, I do not.
Okay. Would you agree with me that the closest single-family residence to the related parcel that is to be redeveloped as part of this application is over 1,500 feet away from the related parcel?
I would not disagree.
Okay, so 5 football fields away, right?
Correct.
Okay. What?
I believe, Mr. Baker, excuse me one second, what you stated was no residential was allowed in your zoning for C1.
I did.
Nothing
correct.
else was.
And if I could, Mr. Chair, the commissioners or our zoning code actually says that these are the uses that are allowed. It doesn't say that you can do all these uses at the same
That
time.
would require approval, but I'm
That's
just
correct.
saying the only thing that is not allowed is residential.
That's
All
correct.
the other things are allowed.
That's correct.
Okay, I just want to make clear.
All right,
I
fair.
mean, I'm thinking you're not going to do all those, but,
Hey, please.
I'm sorry, go ahead.
I apologize for stepping in, Mr. Chairman. Lindsay, can you give me section 5.1.8? All right. This is section 5.1.8 of your zoning code as it was rewritten in 2019, correct?
Yes, it appears to be.
And it says that with respect to principal buildings on a lot, multiple principal buildings with non-residential uses, mixed uses, and mixed attached or multifamily residential uses may be established on a single unified lot, provided that all other provisions of Article 5 of this chapter are met. Did I read that correctly?
That is what it says.
All right. And that's your code, correct?
It appears to be so.
All right. Did you hear Mr. Ash's opening statement in this matter, or were you not where you could hear?
I did hear it.
Okay. And you heard him offer, as a matter of fact, that the city would not insist or not apply the Beaufort Highway Overlay District or character area to this parcel or any of the annexed property. Did you not?
I think I did hear that for a year.
Okay. And you've talked about the LSCI and the character area study, but you have not talked about the tax allocation district that's in this area. Is that right?
That's correct.
Okay. And there is still in effect a tax allocation district for this part of DeKalb County, right?
Yes.
All right. Now, I apologize, members of the panel, but we're going to need to go to the white binder because that's how I have my exhibits identified. And we're going to go to tab 9 in the white binder, please. Mr. Baker, if you'll let me know when you've got that exhibit.
Oh, I'm looking on the screen, actually. Okay, yes, I have it.
All right. If you look at section 3, which I think is about the 3rd or 4th page back.
I have it.
All right. In section 3 of
E4. Okay. Well, I was right, it was E4.
C4.
Just 1 minute.
Oh, I'm sorry, section 3 resolution?
Correct.
yes, section 3 of the resolution.
Thank you.
In the resolution, the county commission expressly adopts the redevelopment plan, which is attached as an exhibit to the resolution. Is that right?
Yes.
And in the redevelopment plan, there's also a map of where the tax allocation district is located. Is that also correct?
I think so, yes.
And there's no dispute in your mind that this area where the related parcel and the annexed, the to-be annexed areas are all included within the TAD. Is that right?
I feel pretty much sure that they were. I just don't see the exhibit A.
Yeah. So there is an attached plan? I don't see a map.
Mr. Balls, do you know what page the map is on?
It's included in the exhibit. Let me see if Lindsay, do we have the TAD map available on Trial Director?
Pretty certain it is, correct? I mean, can we just stipulate that?
Geographic boundaries A, page 6.
If you give us just a second,
Yeah.
I'm getting the map. I just may not have it in the notebook. I'm sorry.
Index A, which is not in the notebook.
I feel pretty sure that the subject property was in that tax allocation district area.
Well, I think we can stipulate to that without any objection, Mr. Mitchell. So-
Can.
All right, let's go ahead and move on, sir.
Yes, sir. Thank you. If we look at page 15 of the redevelopment plan, where it says plans, vision, and goals.
I have it.
The last sentence of that first paragraph reads, The county will make it possible for private developers to create a vibrant new mix of residential, retail, commercial, and recreational uses supported by infrastructure that safely connects key neighborhoods, old and new, and stimulates significant economic growth. Is that correct? Did I read that correctly?
Yes.
And then in addition to that, there were a number of proposed projects and things that were identified to be done as part of the TAD. Is that also correct?
Yes.
If you look at page 16, under the proposed redevelopment projects, there's a number of bullet points about 2/3 of the way down. Do you see that, sir?
Yes.
All right. And the TAD was adopted in 2007. Is that also correct?
Sounds right, yes.
And you were an employee of the planning department when this document was prepared and adopted by the Board of Commissioners. Is that also correct?
Yes.
All right. Since 2007 and before Brookhaven was incorporated, were there any plans executed or efforts made by DeKalb County to expand or construct new roads or a bridge over Interstate 85, or to facilitate intersection improvements and transit facilities at the North Druid Hills and Interstate 85 interchange?
Repeat the question for me.
Between 2007 and 2012, the end of 2012, the beginning of 2013, did DeKalb County undertake any efforts to create a new bridge across Interstate 85 to alleviate the traffic on North Druid Hills?
There were no concrete plans or construction activities that occurred. There had been discussions about how to fund it and how to make it happen.
Okay. And there's been no roads built in this area to alleviate traffic. Is that also correct?
That's correct.
And there's been no intersection improvements or transit facilities built in this area pursuant to the 2007 tax allocation district, correct?
That's correct.
And you've also not built any sidewalks in this area. Is that also true?
I believe that may be correct also.
All right. And you've not created or installed or constructed any improvements to allow for pedestrian and cycling activity at the North Druid Hills and Briarcliff intersection. Is that true?
That is correct.
Now, you're not supposed to ever ask a question that you don't know the answer to in this business, but I'm going to ask you a question that I think I know the answer to. You wouldn't want to cross the street at North Druid Hills and Briarcliff in its current configuration, would you?
If someone could do additional improvements to it, that would definitely make it better. But I just crossed it actually when I went and visited it prior to this meeting, prior to this hearing.
On foot or by car?
Foot.
Okay. You're a braver man than I, and I've spent 8 years in the Marine.
I was taking photos.
There's been no enlargement or enhancement of public parks and green spaces in this area. Is that correct?
That's correct.
And no provision for additional parking or improved streetscapes in this area by the county, correct?
That's correct.
And no provision for workforce housing?
The code, actually, our zoning code does allow for it, and it gives bonus increases or incentives for people that actually do affordable housing or workforce housing as part of their project.
Okay. But there's actually not been any construction or any plans of anything approved by DeKalb County since the TAD was instituted to provide for workforce housing. Is that right?
Correct.
All right. Now, in your resume, you describe your responsibility as having to manage and respond to the I'm sorry, I think you actually used the word balance the interests of your elected officials. Did I remember that correctly?
No, I don't think that's what I said, actually.
All right. Give me a second and I'll find it exactly. Forgive me. Last phrase of your introductory professional profile, balancing multiple interests, elected officials, comma, administration, comma, developer interest, comma, and public. Do you remember that language?
That sounds correct.
All right. Now,
When you first, go ahead, I'm sorry.
now, did you have any conversation with Commissioner Jeff Rader concerning this project since the annexation petition was communicated to the county?
I've had none.
Do you have any conversations with him before the annexation petition was communicated to the county?
I had none.
All right. Are you aware of the community investment agreements that Brookhaven negotiated with Children's Hospital of Atlanta or Emory University Health Centers?
I was not aware of it at all until I read your intent letter about this project in preparations for this meeting.
All right. Did you ever ask for or receive a copy of the CIAs?
I have not.
Do you have any idea what they provide or what additional transportation or connectivity improvements are required or by the CIAs?
No.
Now, you're aware of that the county has a service delivery strategy with the city of Brookhaven, is that right?
Yes.
And among the things that the county is to provide pursuant to this SDS is plan review for sewer and watershed.
Correct.
And if I read your resume correctly, I thought I understood it to be that your department is responsible for managing and reviewing sewer and watershed plans. Is that correct, or did I misunderstand?
You misunderstood that particular aspect.
Okay, tell me
Batch,
what.
I believe the next witness will testify to that, so she's watershed, so I think we need to hold that question if you don't mind.
All right, fair enough. Are you aware of any of the activities or projects that Brookhaven has instituted related to building out connectivity and making roads and streets safer for bicycles and pedestrians?
Minimal.
Okay. So, but you were responsible for the countywide mass transit plan that was done last year, right?
I was involved with it, yes.
Okay. I thought I understood it, your resume to say that you managed that process. Did I misunderstand again?
No, if you're talking about the 2014?
No, the most recent one. There's a mass transit plan that was adopted in 2019 related to the implementation of mass transit across the county, and it's all of it's a joint venture between the Dekalb Municipal Association and the county to figure out how we were going to use mass transit in the county. Do you remember that?
Yes. Yes.
All right. North Druid Hills is designated for arterial rapid transit. Do you agree and agree with that? I'm sorry, Mr. Baker, if you answered, I didn't hear you.
Yes.
Okay. in order to implement arterial rapid transit, there will be a need for transit centers along North Druid Hills. Is that correct?
Yes.
All right. Have you been aware of any efforts that Brookhaven has undertaken to provide those arterial rapid transit centers in order to be able to implement the mass transit plan?
I am not.
Is it also true? Well, would you agree with the idea that arterial rapid transit requires ridership and density in order to make it economically viable?
Yes.
And this property, obviously, and I don't mean to overstate the obvious, but the related project would provide that kind of residential density for the use of arterial rapid transit consistent with this county's mass transit plan, correct?
Yes.
All right. Now, DeKalb County does not have an impact fee ordinance, is that correct?
That is correct.
In talking about changes to density related to the various centers that you've described, you talked about the need for additional benefits to the community. Do I remember that correctly?
Yes.
And you said that workforce housing is one of the things that you consider a municipal or a community benefit that would allow bonuses and benefits to the developer for the purposes of instituting workforce housing, correct?
That is correct. And in the context that I was making that comment, I was basically saying that because a character area allows 24 dwelling units per acre, it's not automatic. That we start with a base density, and then based on your incentives or additional amenities you add, you can approach the 24 dwelling units per acre.
All right. And you also equated the area down where the Children's Hospital building and campus is going and the Emory University property is going. You called that as part of the neighborhood center property as well. Is that right?
I'd have to look back at the map again to see what was in the North Druid Hills study.
Okay. Well, my question is more specific than that. Isn't it true that after the LCI, the executive park and the area where the Children's Hospital campus is going was rezoned or redesignated in the comp plan as town center, not neighborhood center? Isn't that true?
That sounds to be correct.
Okay. So you were talking on direct about the property closest down to 85 being neighborhood center, and that would be the area where the highest density ought to be. That actually didn't have anything to do with that area because it's actually town center, not neighborhood center, correct?
Well, what I was stating was that the highest density should be at 85. And when I went by the property and walked it in preparations for this meeting, I noticed that right there at Briarcliff, that the development was Willie's, a nail salon, and so forth. And what I said was that those businesses was one story. So as you transition from I-85, from the Children's Hospital, it went down and did the proper transition. So what I was saying was as you cross Briarcliff, it would seem that you should continue that trend, not go up in terms of height and intensity.
Fact of the matter is the town center would be a completely different character area under the DeKalb comp plan from neighborhood center, correct?
That is correct.
And you would reevaluate the appropriate build out and appropriate development of neighborhood center based on its environs and not necessarily what's going on or in relationship to the town center character area. Isn't that also true?
Jed, I'm not following you directly, but let me take a stab at it. That if town center is on I-85, then we would support higher densities and densities and heights closer to I-85. If the character area is neighborhood center, which it is, across Briarcliff and on the subject property, the maximum density that is allowed is 24 dwelling units to the acre, 3 stories in height. You'd have to apply for a SLUP land use, I would say a SLUP process, a special land use permit, to go above that. And so for us in DeKalb County, you'd have to apply for a land use amendment and have public hearings if you wanted to change the subject property to a town center density.
Any more questions, Mr. Batch?
Just a couple, Mr. Chairman. I'm sorry, I'm having to look through my notes as well as my outline and go back and forth, so please forgive me for having to take a moment. With respect to the 30 acres that are, or the 27 and change acres that are being considered as part of this application and this annexation process, are you aware that the target is subject to a long-term lease with the property owner until 2051?
No, I was not aware.
All right. Are you aware that the Sherman-Williams and Firestone building just sold, and that property is now owned by the owner of the Sherman-Williams store? Did you know that?
No.
Are you aware that the Chick-fil-A was rebuilt last year and the traffic pattern around the Chick-fil-A at the corner was completely rerouted?
Yes.
Okay. So whatever happens on this property and whatever parade of horribles that we want to talk about, nothing in this annexation process is going to change the use of the Chick-fil-A. Would you agree?
I agree with that.
Would you agree that it won't change the use of the Lens Crafters that's right next door?
I can't. And the only reason why I say that is because the lens crafter actually is in poor condition. It actually needs to be upgraded, remodeled, and so forth. And the example you gave for Chick-fil-A showed that their business was very brisk and they needed to accommodate the increased demands, and so they made recent renovations. The lens crafter is not really in good shape.
Okay. But you're not aware of any redevelopment or development plans related to the Lens Crafters, is that right?
I am not aware.
Okay, and you're not aware of any plans to change the Arby's, which is the next road to the, or next building to the east, correct?
I am not aware.
Okay, and parcel D, which is way over in the far left-hand corner of the various maps we've looked at, that's not part of this annexation. Do you understand that to be true?
I will attest. I'll say yes.
Okay. Does your office currently have an application to change that wooded tract into some sort of storage facility?
I'm not aware.
Okay.
I'm not saying that's not the case, but my zoning administrator actually would receive those cases and at some point would discuss the most difficult cases with it.
All right. Now, are you aware of the project proposed at the intersection of Briarcliff and Claremont by Stein Investment Company?
I am aware.
All right. And that project would be 264 units on 3.8 acres, correct?
That's correct.
And it would also include 10,000 square feet of retail and restaurant?
It sounds right.
Okay. And that's at the other end of the stretch of road that we're talking about in this annexation proposal, right?
That's correct, over at Claremont.
All right. Has the county asked Stein Investment Company to pay for any improvements to Briarcliff?
Anytime a person comes in and asks for rezoning, it is the county's posture that they always require that the applicant actually make any necessary improvements during the rezoning process. So a transportation, or if it's a state road, if GDOT or whoever says you have to do decel lanes and so forth, then that's when we make that a requirement of the development. Also, as it relates to sidewalks, as new development occurs, it is a county requirement that you build the sidewalks, and that's since there hadn't been much development over on Druid Hills. Every time there is new development, there is the sidewalk requirements or the decel lanes and transportation improvements.
All right. last question. Are you aware of anywhere in Related's plan or application process where they have included some sort of drive-through restaurant on the 6.74 acres that they intend to redevelop if this annexation is approved?
I am not aware.
Okay. Mr. Chairman, if I can have just a second to check with my co-counsel to see if there's anything else they want me to cover, please.
Certainly. Just,
And I got about 5 minutes to redirect.
panel those questions.
Oh, yeah.
All right, I am not seeing any additional questions, so he's with the panel.
Thank you. All right, panel, have any questions for this witness, and then we'll have a few minutes of redirect, please.
I understand. Sure.
He's been sitting here all day. He needs to go.
Question. Lots of discussion about the Dekalb C1, general commercial, multiple uses, not mixed uses. That's something just for my benefit. If I have a 6-acre property zoned Dekalb C1, on that property, I can have multiple structures. I don't have to just have a single building on a 6-acre parcel.
Yes, you can have multiple structures.
And I could have a L-shaped retail strip center, and in the parking lot, I could have a standalone restaurant building?
As long as you meet the minimum requirements for the lot for that
Right.
independent one, yes.
Right. And I could have a retail structure and an office building behind.
No.
Could I have office above retail?
No.
No. Okay. But I cannot have any residential.
That's correct. It's not allowed, there isn't a P on our chart, it's not allowed at all. If you wanted to do the other uses that you mentioned, meaning the residential or office on top of the retail, you'd have to rezone it to a mixed-use development.
Okay, but I could have multiple office buildings.
Yes.
6-acre structure, right? So I could have multiple structures and some types of different commercial uses depending on, like you said, a retail center with a standalone restaurant occupying part of the parking area. Example.
Yes.
Thank you.
Any other questions? Mr. Mitchell, wrap us up so we can take a break for you.
Yes, sir. Yeah, multiple structures on a particular parcel of property. Do they have to meet certain density requirements and setbacks and things like that?
Yes, we will be looking at the parking ratios, the stormwater, the landscaping, all those standards for those uses.
That a multiple use parcel is not the same as a mixed use or under the DeKalb County zoning ordinance.
That is correct. They're not the same.
What was the year the TAD was done?
So, sound like it was 2007.
Was there one particular development that, based on the review of the document, tended to be motivating that TAD at the time?
It was the whole redevelopment of town something it was called, which was I think it was a similar project.
Is it mentioned in the TAD document?
It is.
Did that ever come to fruition?
It did not.
If that was done in 2007, everybody in this room knows what happened a year and a half later.
The recession hit and nothing was developed, and then in 2007, the development that has occurred there now, whether it's the Chick-fil-A's activities, the Walgreens, the Children's Health Center, none of that was there either.
Would you agree with me that a road like Briarcliff tends to be a boundary for character areas or zonings?
If you were to look at the comprehensive plan when it was adopted and you were to draw a circle around the intersection of 85 and North Druid Hills, you say, here's where we want the activity to occur. Briarcliff is a natural boundary line between what's going on at 85, and then as you cross that, then it should be less density as you move into the neighborhood.
The Stein proposed development, what's the status of that currently?
The applicant, staff has had heartburns about that project. It has been too intense and too dense. I've had conversations with that applicant and said that it is too dense and too intense. In order to do the density that that applicant wants, they need to do a land use amendment to change it from neighborhood center to town center, go through the public hearing process, and let the public and the residents for that neighborhood chime in as to whether or not they will be willing to accept that amount of density.
Is that in Mr. Rader and Ms. Gannon's district and super district?
It is.
What has been Mr. Rader's, in your experience with him in zonings and land use decisions, what's been his general attitude about what the public's involvement ought to be in these matters?
Both those commissioners think that public involvement is of the utmost importance and that we actually at times have to go back and have additional public meetings with the residents in that association to make sure that they're aware of what's being proposed and how the project will work so that we can make sure that there is enough public input into the process. Usually what happens with the DeKalb County elected officials is you would go through the cycle and the item may get deferred to go back through that process again to make sure that we have enough public input before a final decision is made.
Thank you, Mr. Baker. That's all I've got.
I have one quick question, if you don't mind. You may not know this answer, Mr. Baker, but the TAD that's in place, I'm assuming it's like the ones we have in Cobb, which is 25 years. And so the taxes are frozen, as I read, at 100 million assessed value, which is 0.95% of your revenue, et cetera, et cetera. Does that mean anyone that, since the subject property that it was designed for did not build there, does that mean anyone else that builds there gets the advantage of the TAD? Or does it have to be that subject property?
I would think so, but I'm going to yield and say since Economic Development Office took the lead on that, they would have been the more expert to talk about how the...
I don't know, because, all of ours, they built, and they got the advantage of it. So that means anybody that comes in here, taxes are frozen?
In that particular area, I think that is the way it would have worked.
That's the way a TAD usually works, so anyway, so maybe that's good, thank you.
We have a map of the TAD. It's got it shows some other areas if the panel is interested in having that introduced.
Perfect. All right, let's take a break till 3 o'clock if we can. That's about 8 minutes and or 8 or so, and then try to get your next witnesses. And thank you, Mr. Baker, for your
Thank you.
I anticipate, given the issues in this case, that this witness is going to take at least an hour and a half or 2 hours.
Right, that should be the last one.
Okay, so I can send Mr. Boutwell home and tell him to come back in the morning. He's here. He's been here since 3.
Is that the third one?
Yes.
Oh, I don't see how we're going to make do you?
I didn't want to release a witness today if we were and then waste time. So.
Yeah, I don't, is that all right, Mr. Batch? Are you there? Balch.
Chris, are you there?
I am.
Yes, sorry, although.
Is it okay? I mean, we're going to try to.
My jacket at the moment.
That's all right. We're going, we're going to listen to the one more witness from the county and then call it a day and then take their third one in the morning, and then you guys will take on after that. Is that okay with you?
So we're going to do Miss Otts next, and then Speedy will Speedy be quick in the morning?
If he's quick, I'll keep him tonight, but,
I'm not trying to hold you to that, Mr. Mitchell. We're fine with that, Your Honor. It's a bad habit.
Why don't we do
Mr.
that?
Chairman.
Yeah, we won't get through both.
Okay, so we'll do that. We're gonna take a break and then, bring the next witness in, and then after that witness and everything, we'll call it a day and come back in the morning.
All right.
We're in recess.
This is for you.
We need.
Sure. We cannot hear anything from the hearing room. I don't know if there's communication going on.
That was on purpose.
Can you hear now?
Yes.
Mr. Ash?
I believe everybody's back, except Mr. Elliott, and he'll be back in a minute.
Hey, Robbie?
Yeah.
That's a map that we created of the pad. It's got city limits on it, and it's got different colors for Choa, Executive Park, and then what still is unincorporated. Do you want to put this in the record for the TAD's attached panel?
Can someone email me a copy of whatever was printed to create that? Just so I can, I probably don't object, but this is a somewhat awkward way to review it.
I'm sure that I've got something I can email. I'll do it when we're done here. And then we can put one in that doesn't have all the bells and whistles if you want that. Because apparently the TAD map was in Appendix A to that exhibit to the ordinance, and it was not included in the book. So a map is supposed to be in there, it's just not.
Again, I'm happy to see the map, and I'm happy to have a map in the record. I have a hard time seeing what you're showing on when you hold it up to the camera. I'm not trying to be difficult. I'm just trying to know what I'm agreeing to.
I can barely see it when it's here in the room with you.
We can go ahead and start. I don't think I need any legal advice right now unless you're trying to pull something else.
Something else?
That's what lawyers always do.
Yes, I know you do.
That's why I wanted to make sure I knew what the map said before I agreed to it.
It's all right. I got Keanu on my side. I don't fear something.
Exhibit 14, the map.
Okay, all right.
Did Mr. Ash hear that?
And the black.
Did I hear, I'm sorry, Mr. Chairman, I heard you ask if I heard something, but I guess the answer is no, because I don't know what I was supposed to have heard.
Exhibit 14 in the black book is the TAD map, tax allocation district.
Yeah.
I'm not sure I'm just I'm curious about that, so I don't know if that's part of anybody's case. We should be in the second book, right?
We are in the second book.
Oh, bless you.
Everything's in the second book for this
I don't want you even thinking about the first book again, okay? All right, you ready? All right, we'll call this hearing back into order, and Mr. Mitchell, floor is yours, sir.
Thank you.
For the record, we have no objection to the admission of Exhibit 14 from the black binder into the record.
Okay. Thank you. Raise your right hand. Do you swear or affirm the testimony you'll give before this panel will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. All right. Introduce yourself to the panel. What's your name?
My name is Michelle Ott. My engineering license is under Michelle Jackham.
And what is your education background, Ms. Ott? You prefer Ms. Ott?
Yeah, that's fine. Graduate of Georgia Tech, 1995. Bachelor of Civil Engineering. And on to my career after.
Any postgraduate work?
No, sir.
Walk briefly through, if you would, your employment background.
When I graduated Georgia Tech, I joined a firm. Should I state the firm's name?
Yes.
Okay. Planning design group with Fred Fisher for 1 year. They were going to start an environmental group, but they didn't. I ended up leaving after a year and going to Watson Browning Engineer, where I was for 3 years as their senior civil designer. After 3 years, I went out on my own, and I worked for myself for 16 years, and then joined DeKalb County in 2014 as an engineer, a senior staff engineer of shortly after that was promoted to engineering manager and managing the planning and development division. And should I,
During the time of your self-employment, what types of things did you do?
okay, I was, for part of the time, I was a contract engineer for Jasper County because they are a very small county. County seat's Monticello, Georgia, so they didn't have a staff engineer, and so I was a contract engineer for them. I also helped to rewrite their zoning ordinance and their codes. While I was self-employed, I did development for residential, commercial, and industrial projects, land planning, everything from purchase of the land till buildings going vertical. I didn't have anything to do with architecturals, just the full land development until you closed out an LDP and final platted it. And
Now, you've had 2 stints with the CAB, correct?
yes, sir.
What happened, where were you between those 2 times with the CAB County?
In between the time I was with DeKalb County, I was gone for 13 months, and I went to the city of Sandy Springs to work for a company called The Collaborative, who was running their development division, and I was brought in.
Excuse me, who's ever rustling, I think it's, Mr. Chairman, you've got. It's making tons of noise and I can't hear the witness. I'm so sorry, I didn't mean to yell at you.
You can't hear somebody talk, but you hear my popcorn. All right, go ahead. If I drift away, it's your fault.
Sandy Springs.
Okay, so for 13 months I was there. My primary position was doing their transportation reviews and that, but I also helped Gilbert Quinones, who was the city engineer and the building official, and that with other things. I helped with the rewriting of the zoning ordinance and also the development standards while I was there.
And then you returned to DeKalb County. Tell us about the circumstances of that.
I was happy to actually get a phone call from the deputy COO of DeKalb County, who wanted to talk to me about watershed management, sewer capacity development, what I had done with the CAB before I left. And then I spoke with Darren Eastall, who is the assistant director for consent decree, and they wanted to know what it would take for me to come back and take over my former duties. And we discussed what it was, and I would happily return to DeKalb County.
So what's your title?
My title is engineer principal, but I'm manager of the planning and development division.
In what department?
Watershed management. I apologize.
All right. So there, in watershed management, there is a planning and development division.
Correct.
Separate and apart from any zoning or land use or comprehensive planning stuff.
Right. Okay.
Now, give us a brief overview of what you do as the manager of that division.
Just that division or everything?
Everything,
okay.
Yeah, what you do now.
Okay, I manage the engineers and the new construction inspectors, and that has to do with all reviews, because we have 13 cities within the limits of DeKalb County, and then we have unincorporated DeKalb. Watershed management is the only department that actually reviews every single city's projects. Doesn't matter what type it is, because we are the water and sewer owners. It's the fog, backflow, fire, land disturbance, buildings, sewer capacity assurance, trying to think what I've missed, water sewer design, final plats. We review all of that, but on top of that, I'm also the sewer capacity assurance engineer for DeKalb County. I am the one that reviews and certifies model runs for any and all requests that come in that are an increase into our system.
Okay. And one more question here, and then we'll talk about those models in a few minutes. Do you have any professional licenses or certifications that help you do what you do?
Yes, I'm a registered professional engineer in the state of Georgia. I obtained my license at the beginning of 2002. I'm GSWCC Level 2 Design Certified.
Tell us what that is.
It's for erosion control. It's has to make sure it's secondary to your PE to ensure that you're protecting the waterways in the environment. I also have a couple of my NIM certification for National Incident Management, and I have my MS4 CECI certification.
What is that?
MS4 has to do with stormwater, and it has to do with reporting with regards to stormwater issues for a jurisdiction specifically.
Are you responsible for DeKalb County's, let me ask the question this way. Do you oversee DeKalb County's compliance with the consent decree?
A section of it, not all of it. I mean, it is very in-depth. We have a lot of programs that fall under it, but I am part of a couple of the programs.
Including sewer access, those types of things?
Right, sewer access, infrastructure acquisition, which would meaning when a development goes in, once the sewer or the water is dedicated to us, it becomes part of our property per se. So that's part of the reporting. And so I'm the champion for the infrastructure acquisition, and I am the sewer capacity assurance engineer, certificate engineer.
I would tend to Ms. Ost as an expert witness in regard to design, sewer, and DeKalb County sewer.
So noted.
All right. I think you told us this in your introduction, but what entity provides sewer service in all of these?
That would be Department of Watershed Management.
Okay. Does that include, are there any cities that have their own wastewater treatment?
There is a portion of the city of Atlanta that we serve, but they have their own. That's the only one, because they cross into our border, but the city of Atlanta has their own watershed division.
Okay. I alluded to this earlier. Explain a little bit to the panel about DeKalb County's reputation with regard to their sewer system and what the actual facts are with regard to their sewer system.
I hear a lot. I get a lot of phone calls with regards to, I hear you're under a moratorium and that. But I believe, as everybody knows, that we are under consent decree. Is that where specifically? We're under consent decree, and we have out of sight, out of mind. And it has to do with maintenance and upgrades of the system over the years.
Your meeting will automatically end in a few moments. Please press any key to continue the meeting.
That sounded ominous.
Wasn't me.
Can we get our Veritex support individual in to check on that for us?
Your meeting will automatically end in a few moments. Please press any key to continue the meeting.
I hit a key and it didn't do any good.
Must be a key somewhere else.
It thinks because we haven't done anything in 6 hours that we're not here anymore.
But what it's telling you is you haven't done anything in 6 hours. That's what it thinks.
Your meeting will automatically end in a few moments. Please press any key to continue the meeting.
I lost my train of thought, so if you'll ask that question. Okay.
Oh, what was there?
I'm sorry.
Veritex has said they're on their way.
Yeah, could we wait until we get this cleared up, just so we have some testimony? Thank you.
Goodbye.
That was a court reporter said that.
I can still hear everybody.
Yeah, that was weird, because earlier we
That
had
was
like
this
whole
chair.
music, and then it joined us to a meeting. I wonder if we're dialed into yet another meeting that, now, Gail?
It could be on the school system, you know.
Chairman, now would be your time to get your popcorn in.
No, I'm afraid not. That woman, she's already got on my case. I'm not.
It's the oddest thing that phone with that phone.
Just 1 second, trying to get another bottle of water.
You got us.
Oh, pardon me.
All right.
All right.
I just want to make sure you're staying on the screen. Okay. With regard to the condition of the system, I was actually asking about the physical condition of the system, and especially with regard to the area that we're talking about here.
Okay, well, we have areas that have their concerns. We're broken up to several different basins which have multiple sewer sheds within it. Brookhaven is North Fort Peachtree Creek. Overall, the conditions of the lines are pretty good. With regards to other areas of the county. And, the situation that we're running into here is, the increase in the development is starting to cause capacity problems, or has caused capacity problems.
Okay. I'm sorry, go ahead.
This area was not defined as a priority area or a major problem area under the consent decree. So which was
entered when?
The consent decree was 2011.
Okay.
And the EPD actually came in and dictated areas that were too small had to be done in that, and this was not initially one of those areas.
Okay. Turn, if you would, in the book to tab number 28.
To tab what?
Tab 28.
28.
Jumping way down.
I like
that. Good.
Okay.
I'm just checking.
Can you identify what we've marked as defendant county 28?
Okay, this is a map that is showing the track that the flow for the proposed development of 2601.
What's the label at the top?
Brookhaven annexation.
Okay. Tell us, if you would, where does this map come from? What was it printed off of, or what generated it?
This was generated from our program for Dekalb County Watershed GIS.
And are those maps, is that GIS system maintained by Watershed Management?
Yes.
And do you regularly utilize this particular, these maps in the work you do each day?
Yes.
I would tender County 28.
Objection.
Okay. All right, let's kind of walk the panel through this. What is the yellow line on Exhibit 28?
That would be the city-county line.
Okay. And the white areas on the map, what do those represent?
Those are right-of-ways, whether it's state or county or local roads.
Okay. What is the red line?
The red line is the sewer path from the site, from the point that it enters our system, the manhole it enters, to the point, through every stick of pipe and manhole, to the point where it leaves our jurisdiction into another jurisdiction.
Okay.
Excuse me, is this sewer or storm sewer?
Sanitary sewer.
Okay.
All right. There's a legend there, just south of the intersection of 85 and North Druid Hills. What's the first item in the legend?
That's sanitary sewer spills.
What is that?
That is when sewer comes out of our system. A sewer system is supposed to be, a sanitary sewer system should be closed, but this is when it comes out of the manhole and hits the environment.
All right. And what is the next item on the legend? What is that?
That is an overflow. It's a type of spill.
What's the difference between a spill and an overflow?
One is that enters the state waters of Georgia, and one does not.
All right.
One is overland, and one can have problems in the waters.
The next item on the legend is a little yellow block. What does that indicate?
That indicates a plumbing backup, a building backup on private property.
Right. And then the red circles, what are those?
The red ones are specifically the manholes that are located within the track that this flow takes.
All right. Then there is, and it's going to be important when we look at a later document. Is there any way to identify or differentiate between the various manholes, sanitary sewer manholes in DeKalb County?
Well, you have unknown, because we may know that they're out in the field, but we don't have any records on them. You have private, which we dictate as purple, which is a lot of times the ones that are within apartment complex, and then the green ones are DeKalb County manholes,
okay.
County infrastructure.
Right. Are you able to, when you look at your system, is there any way to tell the difference between the manhole that is where the effluent drops in at the site, and the one where it turns to go up Cliff Valley Way? I'm trying to get their numbers.
Oh, yes, we have I apologize. Our manholes are numbered based on their district, their land lot, and then they have a number to them, and then they will also be stated as, the last part of the number will have an S or a P, and that means surveyed or private. So that they are identified individually by these numbers. I apologize.
Private, does that mean they have a lift station?
No. Private just means it's privately owned. It was never dedicated to the county. It's not county maintained.
At some point or another, it goes into your system.
Yes, at some point it enters our system, but the best way to probably show this
This is 28 on the blow up.
is like, this here is an apartment complex. That's typically what happens.
Yeah.
So they can see us, what I'm just suggesting.
How does she
They've got a bigger, they can see what
I don't know where she's pointing.
Oh, okay, you're right, yeah.
Let's see the best way. And if I go up there, it still doesn't make a difference.
I think there would be fine if you could hold up the map so that it's in camera where you're pointing.
If you want to pull it back.
That would be great if that works for the panel.
Okay. If everybody can look on their maps, you see where the yellow line is here? To the west of it, you will see purple manholes in this area. And when it's purple, that means this is all privately maintained. But part of it enters the system and becomes part of our property here. Part of it enters our system into this manhole, and part enters here. But what it is they wanted to use a different material at that time, or it doesn't meet our standards, so they maintain it privately. So if a spill occurs in here, it's a private spill, it's not a county spill.
Right.
Sorry, can Ms. Woodbury, will you take down the screen share so that we can actually see the witness pointing at the map, please?
All right.
So, and I'll tell the panel, the numbers I'm fixing to talk to her about, you probably cannot read on the 11 by 17. If you need an electronic version that you can blow up on your computer, we can provide that to you. It becomes somewhat important when we talk about the model runs because those show these manhole numbers. So I'm pointing right underneath where it says Briarcliff Road, right up from the manhole where it drops in. There's a little green circle there. What's the number next to that green circle?
18-152-S200.
Yeah, that's what I got.
But my point is that there is a similar designation for every manhole.
Yes. Yes, everything has its own ID code.
All right. Now, when a developer comes in some jurisdictions, developer can come in and just simply get the will serve letter from the department or something similar based on whatever the jurisdiction is. Is that what happens in the cab?
No.
All right. What controls your decision making with regard to those providing sewer connections in the cab county?
Per the consent decree, every single request has to be evaluated, whether it's an increase or a decrease. And when I say a decrease would mean a restaurant going to office or a duplex being demoed and a new home being put in. So,
if you would turn over to Exhibit 21. Yes. And we do not have a certified copy of the consent decree, but Mr. Ash and I agreed that the one that was printed from what's called PACER, Public Access to Court something records, electronic records. And so we've agreed that the one printed from PACER, the blue at the top that's got case number, that indicates that this came off PACER. So even though it's not certified, we're in agreement that it's Can you identify Exhibit 21, please?
Yes, this is the consent decree.
Okay. And for what you do, generally speaking, what does the consent decree require of you? Or your role?
The consent decree requires that I am ensuring that any additional flows into our sewer system do not exacerbate any downstream issues or cause potential future spills. It also dictates the processes on infrastructure acquisition for me.
Are there, every time you have to do this analysis, do you go to the consent decree, or are there other documents that you?
There's other documents that, this was the guiding force of a lot of SOPs or protocols that went into place.
Take a look, if you would, at Exhibit 23.
Okay.
23. I would tender County 21, the consent decree.
No objection.
What is, can you identify for us County 23?
Yeah, that's the interim sanitary sewer capacity evaluation program.
And what is this document?
This document is the process that any and all developments in DeKalb County must follow to be able to move forward to find out whether or not they can develop.
Is this a document you maintain in your office?
Yes.
You utilize it on a regular basis for the work that you do?
I utilize its contents, but not the document itself, because
So this is a copy of the protocol?
Yes.
Okay. I would tender County 23.
No objection.
Okay. Take a look at County 24, if you would, tab 24. Can you identify tab 24?
Yes, that's the interim SOP for the infrastructure acquisitions program that is for sewer capacity certification.
Okay. Same question. Is this procedure something that you maintain in your office?
Yes, it is.
Do you use it on a regular basis?
Yes.
The work that you do? Similar answer, I suppose it's not this document you use, but this is a copy of the one that you do.
Yes.
I would tender County 24.
No objection.
Let's back up and get a few more things in, and then we'll talk about the particulars. Are you involved, in addition to what you have to do on a day-to-day basis, are there reporting requirements under the consent decree?
Oh, yes, we have quarterly, semi-annual, annual, but then also I have to make sure that I'm tracking records correctly for surprise EPA audits, EPD audits.
Okay. Take a look, if you would, at County 22. Can you identify County 22?
It is, I've got to double check what you have in here. Okay, so this is the OSARP.
And what is that?
OSARP is the Ongoing Sewer Assessment and Rehabilitation Program. What it is our activities, whether it's quarterly, semi-annual, or annual activities on what we are doing to better our infrastructure, repairs, replacements, and that.
The exhibits 22, we've actually got certification from COO Zach Williams for Exhibit 22, the Ongoing Sewer Assessment and Rehabilitation Program, and the Exhibit County 26, which is Annual Report Number 8, and County 27, which is Semi-Annual Report Number 17. I would certify copies of all the records. I would tender those.
No objection.
Are you involved in the reporting at all?
Yes.
And how long? So you're telling us there's quarterly, semi-annual, and annual reports in addition to all this other reporting that happens?
Yes.
And is all that copied?
Yes.
All right. Now, when you receive an application, what happens? When it lands on your desk, what happens?
What type of application?
All right.
Permit application or sewer capacity?
Turn over to Exhibit 29.
Okay, sewer capacity evaluation report.
Yes.
This is the form that, what do you?
Are you familiar with this form?
Absolutely.
All right.
I use it every day.
All right. And which project is this? Can you?
This one here is 2601 Briarcliff Road, which was initially turned in under the project name Druid Hills Mixed Use. It has several other names, but that's what they initially turned it in under.
What's the company name that's the developer?
A Related Development LLC.
And this is the request for this particular project. I would tender County 29.
No objection.
Okay. All right. Having received this, what do you do?
When this request comes in, it comes into an email address so that we can keep track of it easily on where they come in. It is entered, reviewed, and determined to make sure that the numbers are correct, and then it is a modeling work order.
What numbers, when you say the numbers are correct, what do you
Okay. The engineer for the development for the site will calculate the numbers on the anticipated peak flow that will be added into our system from the development. And it will be either utilizing the numbers that we have as our standards or historical documentation.
So is what they calculate the entire flow that's going to come from that development, or do they back out what's already currently coming from the site?
What it is the increase in the flow. So what they will do is if there was documented flow that was leaving from there, they get a credit for that equal flow, and then the new development. So it is the net increase into our system that we are evaluating.
All right. You mentioned a couple times the model. Tell us what the modeling process is.
Okay, the model is actually another one of the programs within the consent decree, and it is a computer representation, a program representation of our systems. And this specifically dealing with Peachtree Creek Basin. And so what happens is this request is forwarded on, and the flow is entered into our system at a specific point. My modelers compute and produce a profile of the run from the point it enters our system, and then in this case to the point where it exits our jurisdiction. And then that profile is sent to me for review.
How long does it take to do one of those models?
From the point for my modeler to physically do one, or from the point of submittal to the initial analysis?
For your modeler to do one.
Typically, a model of this is about a day long worth of work once it's been added into the system.
And when you say that it's sent to you for review, what does that mean?
Our model software will generate a report that gives me a profile of the slopes, the sizes, the flows, the depths, and everything. And that is sent to me to evaluate to see if it will exacerbate any issues downstream from the site based on the added flow, or if it will create downstream problems.
Turn over to tab to County 31, if you would.
31.
31. All right. Can you generally identify the pages that are behind County 31 tab?
This is one of the generations of the reports for the flow requested from 2601 development.
Okay. Have the standards or criteria for evaluating these changed in the last year? In terms of the presumed flows for a single-family residential, and then what the multiplier is for peak rate?
Yes, that has. In January 1st of 2020, we have adopted, with the help of Jacobs Engineering and myself and some other team members, we reevaluated the area to determine average flows for different uses, i.e. a single-family home. And we also came up with a county peaking factor that would be representative of what was going on, so that we were ensuring that the flows that were added into our model were representative truly of what was going on, and we're not overestimated because overestimating just takes up volume. So we were able to bring those numbers down.
So both those criteria came down.
Yes. Well, majority of it. One type went up by 10 gallons per day, but everything else, like a home was 240 gallons per day, it went down to 185, and our peaking factor went from 4.0 to 2.5.
That was
which
for the
is,
whole county, not just this development. Right?
yes, for the entire county.
You reevaluated everything.
Yes.
When Related submitted their application, did they submit under the old criteria or the new criteria?
Old.
Have they resubmitted?
They submitted an SAP, a sewer action plan, I'll explain that later, showing those numbers, but they have never officially resubmitted under the 2020, which was a reduction, would be a reduction in their flow.
The run that is modeled in tab behind County 31 or tab 31, that's under the new flows, correct?
Yes, in preparing for this, we took it upon ourselves. I had my modeler prepare the run based on the applicable numbers because they turned in their original application in 2019, and it only helps them to go ahead and revise their numbers and utilize the 2020 SCR numbers.
Okay, turn over to the second page of County 31 and tell us what that is.
The second page, this is a very big overview of a portion of the basin, and it shows in the very bottom a small red tract, which is that tract where the flow enters our system.
What was Exhibit 28?
It is actually representative of this, that red tract, but it's showing you our sewer system, what flows through there, and then the red diamonds are spill locations that have actually occurred.
In the last
Unresolved is the best way I can say. They're unresolved SSOs because we have not been able to remove them as a potential problem. Let's say that it's a long-term project to get it done, so they are considered active but not actively releasing, if that makes sense. That's the terminology and the way we have to look at it per the EPA.
problem spots.
Problem spots, yes, that's probably the best way to say it.
All right, third page is just a...
For the problem spot, when was the last time? When was the last time anything occurred? Any spill?
Any spill? I would have to pull those records for it. But what happens every month, I think it's better now just to go ahead and let you know. What we do every month is I have what is called an SSO removal and addition meeting. So every single month I go through with other staff to remove or add spills in that are active and considered problem areas, so that every month when we reevaluate every outstanding request, we pull in a shapefile that shows exactly what is going on, a snapshot of the county for that month. We can't do it any further. So what this shows is everything that is considered until the next meeting that I will have the first week of September.
Okay.
So this shows you the August snapshot, basically.
I'm going toward the one you showed, the two diamonds right here. You mentioned that those two is a problem spot. But still yet, I'm trying to figure out, you haven't mentioned to me yet, from my understanding, that when did it occur? It could occur like 7 years ago, 5 years ago.
The ones that you would see in here, I can't give you the exact date. I don't have it with me, but it would have been within the last 2 years. Because I just know that because that's the longest age of any of our unresolved ones at this time. But I keep track. I have a tracking that I do, so I know exactly the dates. But that's a lot of detailed information, you know.
All right, the next several pages look the same. Generally describe for us what the next several pages show, and then we'll talk about some of the specifics.
Okay. Page 4 is a overview. It's the entire section, so it's squished down, of the entire track that this sewer flow takes.
So the red line on 28 is represented in that
profile there.
Okay.
So you take a look at that, and you can see the thousands of feet that it is on the bottom. Okay, so that gives a portion. And then, the next handful of pages are zoom ins of sections, because this is what I review,
Right.
what I'm looking at.
Let's take a minute and walk through this one so that the panel understands what all this data is.
Okay.
All right? What's the number on the actual graph itself? You've got numbers that are vertical and numbers that are horizontal. What are the vertical numbers? The ones on the left side of the graph.
If you're talking about 846 and those are the elevations.
Okay.
Okay. And then you have going horizontally is the physical distance, the length. And then you can also see where the little red lines are. Those are manholes. And then you can see in black written up is the manhole ID numbers.
Okay. So that's that number you were describing to us earlier.
Yes.
In the specifics on this line.
Yes.
Okay. Now, let's you picked the page of this drill-in that's the best one to give the panel the most information that we need to talk about today.
Okay, I think probably the best one would, we should have, it shows, all right, let's do page 6 of 14. So, this shows the pipe system from manhole, and basically almost a distance, my eyes are not well. Is that 13?
I see 13.
Or is that 1882?
1882
Okay.
to 3731.
Okay, so basically that shows roughly 2,000 linear feet of pipe, okay? And if you, the first line at the bottom of in the legend, that gives you the manhole ID number. Then it says height, that gives you the size of the pipe. So you can see in the highlighted 8-inch, 12-inch, 12-inch, 12-inch in the blue. Then I have the inverts in that. Then grade, well it says grad, but it's grade. That tells me the slope of the pipes. And then the next line tells me the MGD, the flow going through it, and then the next one gives me the surcharge of what's going on in my pipes. So this particular profile will show me a couple interesting facts.
Let's define a couple terms before you.
Okay.
What does surcharge mean, and what does that number that's on that line mean?
What that line is for a dry model run, which means this, we're looking at our peak flows in our system when it is not raining. So surcharge, what I'm looking at is depth over diameter. If it is in a dry run and it is greater than 80%, greater than 0.8, it is exceeding the allowance of the consent decree.
I'm confused. You said when it's not raining, so this is not sanitary sewer?
So this is a dry, we look at, I think I need to pull back.
Explain inflow and infiltration and why that matters.
So we have two things that we can look at. We can look at wet weather flow, which is our flow when we're looking at infiltration and inflow that happens into our sanitary sewer system, stormwater that gets into it.
How does it do that?
Because it's not a perfectly closed system. That's part of the reason we're under a consent decree. Correct.
Okay, because if water, never mind.
It's not supposed to end it.
We have a big issue.
It's not supposed to be there.
It's not supposed to be, but we have to take into account. So we have two things that we look in. We look at wet weather flow and we look at dry weather flow.
Sure, if you got water coming, what about your stormwater? You don't handle that, that's separate, correct?
Yeah, no, we do not have combined systems in DeKalb County, intentionally. So,
Combined
like,
departments?
no, combined, like the city of Atlanta has combined pipes that flow for both storm and sanitary.
I wasn't even talking about that.
Yeah, no.
I was just talking about.
Stormwater is handled by roads and drainage, even though we're called watershed management.
Right.
We don't handle flood, and when they reorganized some of the departments, flood and storm was taken out so that we could function and manage strictly sanitary sewer and
So
water.
they would handle impervious surfaces and all those kind of things to find out what this development would do to stormwater runoff. You're only handling, quote unquote, closed sewage system.
There may be an open manhole, there may be cracks in the pipe, there may be holes in the pipe.
Is there even a manhole for a sewage system? Okay.
What do you?
I mean, How is your system not, I mean, the manhole's what, a clean out spot or something?
Yeah, manhole is our access, because we've got to be able to maintain our lines, clean our lines and that. There's
Everywhere
turns.
like this, right?
Typical manhole is 4 feet.
Well, I know what a manhole is, but not sewer manholes, that'd be.
Yeah. The sanitary sewer manhole is typically 4 feet. Depending on the depth of it, it could get wider. Then you have your clean outs, which are 6-inch clean outs that are in the, so when you, that's what, like coming out of your home and then tying in. But you've got to remember, every time the pipe takes a bend or a move, we've got to have a point to turn it, because these are ductile iron pipes, most of them. So there's got to be a way to change the angle of flow.
Okay. Sorry.
That's fine.
So the surcharge is over 0.8.
If it's over 0.8 in a dry run, then we are exceeding the allowance that the EPA has given us, and we're also exceeding the number that we understand of the storm water that gets into our system. We've got to take into account that we don't have a perfect system, and that's why we're fixing it. So when we exceed 0.8, that's at a point where I've got to look at it and say, I don't know if I can approve this, because this tells me when it rains, the pipes are going to be more than full, and it's going to surcharge, it's going to go up the manhole, and it's going to cause a spill.
Okay, so that column that basically is there underneath the numbers 2496 and 2592. You see that? And the surcharge number is 0.91.
Yeah, guys, I have my contacts in, and I'm still having.
So is that one of these areas that you're talking about?
Yes.
Okay. On that same column, is there another issue?
Yes.
Okay, explain that.
Okay, two numbers above 0.91, you will see a negative number. Do you guys see a negative number underneath a yellow highlighted?
Yeah.
Negative
Okay.
0.65.
Okay, so when you're looking at that, that is the slope of our pipe. In other words, our pipe is going uphill. It's not going downhill. So that's another issue that we have to look at in our system. And we do, due to settling, due to age, when stuff was put in, you know, we may have that situation, or we may have perfectly flat pipes, and those do not carry flow well. That reduces the volume that the pipes can handle.
Is this a gravity line or a force line?
Gravity. This entire tract is a gravity. It does not go through a lift station or is not under a force main. It is solely gravity.
Okay, so with this particular model run, what does it indicate about this particular development?
What it's telling us is, at the point, the addition of this flow into our system has pushed our limits. We are exceeding the requirements that will allow me to certify for a full connection as it is. And it's basically, when I look at this, and based on my experience, based on the criteria set down by the EPA and the EPD, I cannot certify it, because the likelihood that there will be a downhill spill is great. And I can't take that responsibility on. So my only option is to talk to them about other ways to connect without being a full connection, without any regulations to it.
And this model run was done under the new criteria, not the old criteria?
Correct.
Okay. Take a look, if you would, at Exhibit County 30 on tab 30. Can you identify that for me?
Yes, this is the sewer action plan that the engineers turned in, Everly and Associates, for this development. And
is this sewer action plan based on the old criteria or the new criteria?
It looks like to me, because it's different, I think.
yes, this one's based on the new one.
Okay.
Okay.
Explain to us what a sewer action plan is.
Okay, we have areas in the county, and this has now become, because of proposed development, that we can't allow just a regular connection. And the reason being is it will cause a spill or something like that. So we have come up with alternatives that are sewer action plans, which is an on-site storage and restricted release of their daily flows. And what it allows it to do is to make sure that when their flows from the development enter our system, it's not hitting at a peak time. We're trying to get it at a lower period so that the pipes are smaller so that they can go ahead and do their development. It's not the best case scenario, but is the way that we can allow developers to continue to develop.
So the same thing as underground detention for stormwater,
In a little bit, yeah, yes.
except it stinks more.
It's not supposed to stink. We're supposed to have the.
That actually raises a good point. What else is involved in the sewer action? Well, in addition to odor control, what is the range for?
Right, well, they have range gauge, depending on what their reason for needing a sewer action plan is, because there are three major reasons that you get one. That means that there's an unresolved sewer spill downstream that if we add this flow, we're going to cause it to be an issue again. That we don't have enough capacity in the pipes when it's not raining, or that the pipes are flowing greater than full when it is raining. So we look at that. So what we're looking at is you're going to have a rain gauge on it. You could have a timing device that is going to only release during a specific time to make sure you're releasing at off-peak flow times, i.e. midnight to 5 a.m. It's a way to keep development moving forward, but it is a little extra to it.
So even under the new criteria, they still need a sewer action?
Absolutely.
Okay. Now, in preparation for this, did you do 2 additional model runs?
Yes, I was requested to take a look at 2 different ones, and please understand that these were just kind of assumptions based on areas, and that was looking at it for 24 units per acre of a density, and then at 56 units. And these were added because this request, the original request, the 2601 is a real request. It enters our system and it stays in our system. So all new requests after that are cumulative on top of that. So when these were put in, you got to remember this is in addition to the 2601 Briarcliff. And so we backed out the acreage of this one, of 2601, and did the calculations based on the remaining acreage at 24 units and 56 units.
At 20, if you take a look at Exhibit County 32, can you identify that for me?
Okay, this is let me look at it. I want to make sure I can. Yes, this is the model run for the addition at a 24 unit.
Which page did you look at to confirm that?
Being that I know, as I'm the only one that certifies it, I am able to look at 2 different things. I can look at page 2, where it says 2601 Briarcliff. It says with pending development peak flow. And then, so this would have been scenario 1. Page 2 of 14 of tab 31. And so that's how I can tell that. And then do you want me to go to 32?
Yes.
And then 32.
Well, let's take a look at page 6 of 15 and tab 32.
6.
15.
And I think it's important that we get and have them pull out page 6 of the original run. I think it will show them.
Is that 31?
Yes,
Tab
sir.
31?
Yes, sir.
.31. So I think it's important for you to look at. So if we look at 32, tab 32, page 6, you can see the lines. You can see that the pipes are completely blue now. And you can see a line that is above the top of the pipes. Do you see that?
The red line?
The red line there? What that's telling me is now these pipes are flowing more than full. That those pipes are flowing at 100%, and waste is actually going up into the manhole to hold the volume to be able to flow it. Now, if you take a look and keep that in your mind and look at page 6 of tab 31, you can see the difference that has occurred. Do you see the difference in the profile itself and how full the pipes are?
It doesn't appear to me that it's the same one, because on tab 31, you've got a drop down in the elevation at 3731, and over here you do not, so it's not the same one, is it?
Yes, it is. Because what happens is when we do runs, the program itself does its own zoom. What's very important for you to look at is down at the bottom, okay? If you take a look at 18157 S103 on the bottom.
Which tab? I'm sorry.
Either one.
Okay.
If you look, S103, that is the manhole ID number, very bottom line.
Okay.
Okay? So then if you go back over, you can find that exact same manhole, 18157 S003. It's just that the program, when it prints the stuff, that's why it's so important. You've got to look at the profiles themselves. Are you seeing how the same manhole is identified?
I do. So you're not really looking at the same profile on both of these. You got a snapshot.
It overlaps.
Yeah, it overlaps, but it's just the way that the program breaks them out. They may not line up A to A, but they're the same profile, and they show you the same. It's important that they're showing you the same manholes.
Okay, now I see. So this is 2 pages. Now I see it. 3731 I was looking at is over on page 7 of 15 on 32. That's what you were trying to.
That first page, right after the maps, that was the entire runs on one page. The following pages
are the zooms.
Break it out so you can actually see the data.
So the big thing for me, when I'm looking at these, and I understand that I do this on a daily basis, and I can look at it and go, oh, I see these 2 manholes who are close together. I see. And I can quickly look at it. But what I'm showing you here is that addition of that 24 units per acre shows that our system is overloaded already at the 24 units.
All right, what happens if look at tab County 33, what happens if the entire site was developed at 56 units per the acre?
Okay, if you go and look at page 6 again, just remember, now look at the comparison between the 24 units and the 56. But you see, I can't. That very first manhole that's shown on page 6, that's showing me it's going to spill. It's all the way up the top of the manhole. It's coming out. There's no way to approve it. So to do this, it would be a very large sewer action plan that would be required for the 24 acres or the 56 acres, which would be a large tank of at least 200,000 gallons.
I'm sorry, what's 56
24
acres?
units or 56 units?
You said acres, I'm sorry.
Units per acre.
Okay, got it.
So, because I was looking at the 24 units per acre and the 56 units per acre for the remaining property, okay? So no matter what, any development that they do here, they will be required to do a sewer action plan, but with the knowledge that I have right now, I can't guarantee that I'll be able to approve that action plan until we get further down, because of each one is individual, it's site specific, and I've got to make sure that it won't cause any other problems.
But the plan that we looked at earlier that said if you do 100,000 gallon tank, then it would work.
For the original 2601, yes.
I don't know what 2601.
The original submittal that they put in, which was for a much smaller acreage.
6.74 acres.
6.74. They can move forward with that. They have a conditional approval, which means they will privately install about 100,000 gallon tank. They'll have the timers and the rain gauges.
So what else are we looking at? This is already developed here, so this will be this way already.
Yeah, in a sense. So you modeled it based on all 27 acres having 25 units.
No, okay, okay, I think do you want to explain that?
The first model, the first thing, tab 32, was modeling the development of the remaining acreage beyond the 6.74.
The other 21 acres.
Yes.
Right. Okay.
But
The other 21 acres is already developed.
This would be if it were redeveloped at the densities.
Oh, that's
neighborhood.
woulda, coulda, shoulda. But right now, it's flowing fine. Is it's developed now in the county, correct?
That's true.
Yeah, as it sits right now, yes, it's.
And so what I want to concentrate on is the 6.7 that they're going to develop. And you're saying that would work if they put in a 100,000?
100,000 gallon tank, it would be privately monitored, they would have, it would be, and these, I want to make sure everybody understands, these sewer action plans are meant to be temporary situations. The problem that we have going on here is what's happened in this area is this is developer-driven upgrades. So we have a lot of pipes that for them to come off an action plan, that would have to be upsized and relayed.
But surely that's part of your long-term plan to do all that, correct?
At this time, this area was not designated as that. We have other priority areas that we have to take care of first. So these are because of the redevelopment that's been occurring in this area and down this part of the basin, it is strictly the flows that added to our system from the developments in the last couple of years that are dictating this, or the ones that are coming. Because you've got to remember that some people have already turned in their stuff, and they may not start building for a year and a half, but they're holding that volume in our pipes.
You refer to these holding tanks as temporary. Are they ever going to be pulled out of the ground?
Once capacity is available in the pipes, a regular connection will occur, and they can be abandoned in place or removed from the system.
Is that the best way to handle sewer, though, is these temporary holding tanks?
In my opinion, no, it's not the best, but it's the best option that we have to allow development to continue within the county and within the cities of the county, so that development can move forward while we do our repairs and do the upgrades to the system that need to happen. It is something that you're walking a fine line, and I have to look at each one individually. I can't just say, oh, we're capacity restricted in the county and you can do SAP. You can do a sewer action plan. I've got to look at where you are, what basin are you in, what sewer shed are you in, what are the issues, because you can't compare, Brookhaven down to Stonecrest. They're completely different. They don't do the same things. So there's a lot to it. And so I don't want to just throw out that they're all approved, because they're not all approved.
You said this would be a temporary sewer action plan, but yet you don't have this area anywhere in your long-range plan.
And that's what we.
So that doesn't sound too temporary to me. It's 5 years, 10 years, 20 years.
Our goal is that it's not 10 years. Our goal is a handful of years for something to happen. But you've got to understand, in any jurisdiction, when we have upgrades that we have planned, we have them planned because of what's going on. When there is a development that goes in, and their development dictates upsizing a storm drain or adding that's a developer cost. That's not a county cost.
Right.
They're utilizing our system, and they need it to be bigger because of what they want to do, and that is exactly what's happened. This has been the development that pushed us over the threshold.
So my understanding is you don't have any impact fees for sewer here.
No, the county does not have impact fees. We have something called a singular access fee, and that's it.
Because I know Dekalb, they don't call it that, but they charge so much per seat in the Brave Stadium and all these other kind of things. So, and that's to repay the infrastructure that's already in place.
Correct.
Of course, ours isn't leaking or anything. So.
Nah, be careful. If it's in, it's
we have
leaking.
overflow, but we don't have the infrastructure.
Yeah, but yeah, we have access fees, but that's too, because you've got to remember, our system is built by our ratepayers. Our ratepayers, that's who's built our system. We're our own enterprise. The funding of our system does not come out of the general fund. It is paid by our ratepayers. So.
Did you make some determination as to what, if the sewer line that's shown on 28, the red line, we're going to be able to accommodate a larger development at the site? Did you make some determination as to what would be required with regard to sewer lines?
Oh, yes. There's quite a good section, several thousand feet that would need to be upgraded from 8-inch to 12-inch. At the end of our run, there's 96-inch pipes, and if you take a look, just so you can understand what I'm talking about, On page 9 of tab 32, I kind of call it the roller coaster area in that, and that area right there would have to be relayed because we have a lot of pipes that are going the wrong direction. Now, mind you, this is functioning at this time, but the addition of these flows will dictate that it needs to be redone, and we have a section that would have to be upgraded from a 12-inch to a 16-inch pipe. And then the next thing that is really bad to let them know is that part of the upgrade that their development is driving is an upgrade up underneath 85. And I did a little bit of research because CHOA their flows cross over because from under 85, and they did a plan out 25 years, of which I was a part of, and they had to replace the existing line that went under 85 with an 18-inch pipe to be able to make sure that we could accommodate the flows and the redevelopment due to that going in.
What did that cost?
When I spoke with the engineer earlier this week, the final pay on the construction for the upgrade for just the section up underneath I-85 was $2.6 million.
All right, there is, opposing counsel in his opening talked about an email. Do you know who Antonio Samples is?
Mm-hmm.
Who is that?
He's an engineer with Everly & Associates. I deal with him on a regular basis, and I deal with him on multiple projects. He has quite a few, or has had quite a few over the years with me.
There's an email, and I think I've shown this to you, where in all capital letters you respond to him and say, no holding tank required. Are you familiar with the email that I'm talking about?
Yeah, because Antonio and I had been on the phone, and we were talking about another project that we had, but we were doing an email chain, and you have a tendency to go back and forth even though it's not the subject of it. And he had called specifically to ask me about another project, and he had recently turned in the sewer action plan on it, and I got the model run. And I was able to review it, and out of my excitement, I emailed him, and it was for another project that I said no holding tanks are required. The SAP is void, which means you can do a regular collection. But it was in the email chain that had been talking primarily about this project, but about the 2601 Briarcliff, but it was in relations to 1580, another project.
When you say 1580, do you know the name of the street? The email's not in our books.
1580 Peachtree Industrial, I believe it is. I remember, or Peachtree Street. But it was another one of his projects, and he had literally called me about it, and then I was so excited when he had turned in the SAP, and I got the SAP, and then I got the model run, and it worked. And we had been able to resolve the downstream SSO that had been holding it, so.
Is there anything more to be done with regard to the 6.74 acres in terms of the approval of the SAP?
Yes. During this time while we've been remoting, and that I have been allowed to clear conditionally and let development continue forward, but the generation of the official letter has not. Well, the letter has been generated. It is in my files, but it hasn't been sent because typically I'm the one that signs off on it. I send a memo, and then it is signed off. The official approval letter is signed off by our assistant director of consent decree, and then I take it to the COO for signature, so that it is represented by the county as a whole for the approval letter or the conditional approval letter. We have not been able to get together, so we still have to generate that, but they have the conditional approval based on my review.
Which would be the 100,000 gallon tank.
Yes.
Are there any other projects where that's true?
Yes.
Conditional approval? This is not the only.
No.
If I could take a minute to talk to co-counsel who's been listening.
Say again?
If I could take a minute to talk to co-counsel who's been listening, I may be done.
I'll be right
back during the next room. Just want to make sure that I've tendered exhibits 32 and 33. I have no further questions. Our county attorney is inquiring about the site visit, so that if that's something you all want to do.
I'm not certain yet. I mean, is there a way we can, when you finish tomorrow, decide to do that?
Let me let them know.
All right, is it okay if Ms. Ash or Ms. Peterson?
I can text them. Go ahead. They can go ahead and I'll just
Ms.
check.
Peterson, are you doing it or Mr. Ash? You got your cross on
Was there a question from the panel? I'm sorry.
No, I just wanted, it's your turn if you have any questions of this witness.
Thank you. Yes. Hi, Ms. Otts. My name is Jennifer Peterson. I'm one of the lawyers for the city of Brookhaven. It seems like the tech is working pretty well, but if I cut out and you're not able to understand my question or something, please let me know. I'm happy to repeat myself, and I'll try not to talk over you as well. So if this property is annexed into the city of Brookhaven, the city's not going to take over sewer service for it, correct?
Correct.
Because the city of Brookhaven doesn't have a sewer department.
Correct.
Because there's a service delivery strategy between the city of Brookhaven and DeKalb County.
Correct.
And that service delivery agreement provides that DeKalb is going to provide water and sewer services to Brookhaven residents and businesses, correct?
Yes, as long as it doesn't go against the consent decree.
All of Brookhaven.
Because yes.
Okay. And in fact, you provide the same level of service to residents of Brookhaven that you do to residents of unincorporated DeKalb, correct?
Correct.
You provide both the preliminary reviews and the building plan reviews to citizens and businesses in Brookhaven as well as DeKalb, correct?
And land development, yes.
So you talked about that process a little bit. We're here at the rezoning and very preliminary stage. Is that your understanding?
Mm-hmm.
Your department reviews rezoning applications as part of your process?
Yes.
And at that stage, you just have a very preliminary concept plan of what the proposal is. Is that right?
Yes.
They're not final detailed building plans at that stage. And I believe we saw the ones submitted for this project. They're based on square footage and projected use of the certain square footage.
Yeah.
But this is not the final word from your department when something is going to be redeveloped, correct?
Correct.
In fact, when someone wants to build something, when they actually go to pull a building permit, they have to come back through your department.
Correct.
Is that true if someone is building something in one of DeKalb's cities?
Yes.
Including Brookhaven?
Yes.
And it's the same for someone looking to build something in unincorporated DeKalb?
Correct.
Because that's just what the SDS requires, right?
Yes.
All right, let's talk for a minute about this actual project at its preliminary approval stage. I did get a little bit confused. So could you confirm for me that we saw you pulled up an exhibit that was a March 2nd, 2020 submission of a sewer action plan? Do you recall that?
Yeah. Yeah.
Because that was submitted in 2020, did that use the new 2020 numbers?
Yes, they changed that. Their original submittal was 2019, but I told them when they turned in their SCR that it would behoove them to use the 2020 numbers because it would make the requirements smaller.
Because it would make them more likely to be approved.
No, it has nothing to do. I can't say whether or not something will be approved. What it is it makes the design smaller. The flow requirement was less. So the tank size would be less, so it would be cost effective for the developer.
And so at this stage, just to confirm, we have got preliminary approval for this project with a $100,000 holding tank, gallon holding tank.
Yes, it's a preliminary approval.
Okay, and so when we go later on the process, I'm sorry, would you repeat that?
Preliminary conditional approval. When it's an SAP, we call it a conditional approval. When it's regular, it's just a preliminary approval, you know. So there's a stipulation to there's a condition to their approval.
Understood. Thank you for explaining that. So if this project goes forward, you will hear from them again, correct?
Correct.
You will get final building plans that are a lot more detailed and specific?
Well, first I will get the land disturbance plans, and that's what will show what's going on. Then we will get the building permit plans. And then what I ask them to do is a couple of months before they need to install the sewer action plan is to ensure they let me know they're doing it so that we can reevaluate to see if the situation has gotten better, and if their requirement of their condition has reduced or gone away altogether.
I'm glad you mentioned that. The model you showed us showed that there was, I believe we called it a problem spot down the line, correct? An overflow historically that had happened there?
Yeah, we have two locations. One's where there's a backup that has shown problems in the past from a line where that comes into it. There's two of them, and then there's another one very close to the flow at the beginning of the line.
So you said in your direct that you didn't know offhand the exact date that those had actually overflowed?
No, but and at this point, the reason for it doesn't matter whether that is there or not, because that is an incident. Our problem is the size of our pipes. So that's just an extra, because you can have to have that for a sewer spill. You can have it for pipes being too small for wet weather or pipes being small for dry weather. And they have a more restricted area. It's not the SSO that is their problem.
Well,
because they have a bigger.
Let me finish my line of questions about the SSO, because I think the panel members were curious. Am I correct to assume that we don't know when exactly these particular problem spots are going to be cleared up?
I can't speak to that today, no. I know when they occurred, and I know I have a spreadsheet on what's the plan of attack, but no, I don't know.
So we don't know that they won't be resolved by the time we finally get around to permitting this build?
Correct.
Okay. So it's true that the city of Brookhaven, if this property is annexed, cannot issue a building permit until you have gone through your entire process with this property, right?
Correct.
So if this annexation goes forward, and it's annexed and everything goes as the developer hopes it will, the developer still has to submit final plans to you. Is that correct?
To my division, yes.
And your division still has the ability to approve or deny or conditionally approve the actual building plans?
Yes.
Okay. All right. I'd like to switch gears here for a minute and look at some exhibits in our white binder. If you've got that white binder from the city handy, hopefully we'll be able to put them up on the screen as well.
Is it that one?
Oh, right here, I got it.
Oh.
As well.
Can I use that one? Thank you.
Yours?
All right, yes, ma'am, I've got it.
Let's take a look at tab 4, if you would. Maybe we can get that up on the screen if that's easier for anyone to look at that way. Tab 4 is an email thread. Let me ask you first, is this your work email address, mlotts@dekalbcountyga.gov?
Yes, ma'am.
Do you recognize these emails?
Yes, ma'am.
Is this an email thread that you received at your work address?
Yes.
And part of your regular work duties involve sending and receiving emails about sewer applications?
This isn't a sewer application. This is a rezoning application.
Is that part of your regular work responsibilities?
Yes.
Okay. I would tender this exhibit at tab 4 if there's no objection.
No objection.
All right, let's flip to the end of the thread. It's a very short thread, actually. I'm sorry. So this email below is on December 12th, 2019.
Mm-hmm.
And it looks like you're receiving a rezoning request from the related group. Is that correct?
Yeah, it's for zoning, it's annexation and, land use permit.
And this is something that you routinely review as part of your duties?
Yes, myself or one of my specific staff members, yes.
And you replied the next day, no issues with either, if we look above that.
Mm-hmm.
You also say sewer capacity evaluation will be required for the new construction. Did I read that right?
Correct.
Okay. You can take that down, Lindsay. Because sewer capacity evaluation would have been required even if this was going to be built in Dekalb, right?
Correct, but I make sure every time I get something from the cities that I remind them sewer capacity is first and foremost. That's why I always put it in my emails.
But it's not because it's a city, it's just you're being helpful.
Yeah, I do the exact same thing for the rezonings within the county. I mean, I just did them last week, and it's the same thing. Every single one of them has sewer capacity evaluation required.
Understood.
Just so that they know the issues.
All right, well, let's move forward in time to that sewer capacity process for this project. Tab 24 in the white binder, which is quite a few pages down, is another email thread I'd like to go through. Do you have it there? Don't need to give you a minute. Okay.
That's the email that we spoke about earlier.
That's right. It's mlots@DeKalbCountyGA.gov again. That's you?
Mm-hmm.
Do you recognize these emails that you sent and received at work? All right. I would also tender this exhibit at tab 24. If there's no objection.
Okay. None.
All right. What is the subject line of this email thread?
The subject is Druid Hills mixed use.
Okay. Let's flip to the back of tab 24 so we can kind of work through in time, you know, how emails reverse time. The oldest email here is at the bottom. So this is an email to you from Antonio Sample, who you mentioned before. And what is the property address that he is referring to in this table below that he's cut and pasted?
It's 2601 Briarcliff.
Is that the property that we've been talking about today?
Yep. Yep.
And this is his sewer capacity approval, correct?
No, what he was asking me is what's the status, and so I sent him a summary of what's going on. If you take a look at that, it tells you right there, downstream SSO, yes.
Okay.
So, but this is cut off because it doesn't show it doesn't show the remainder of from my Excel spreadsheet.
Let's move forward in time a couple pages. Lindsay, if we could go to the email that it's a fairly long thread. There's an email on March 3rd. That's a couple pages back in the binder, Ms. Otts. So if you could blow up that March 3rd email from Mr. Sample.
Page 6.
Yeah, five, starting from the bottom.
Oh, I see it, yes.
Page 6. Page 6.
Okay.
I'm sorry, I've lost my place too. All right, so on March 3rd, Mr. Sample is sending you a revised sewer capacity evaluation and sewer action plan. Is that right?
Mm-hmm.
Is that
Yes.
the document we saw in your direct?
Yes.
But he's also introducing another topic in this email, and you mentioned this too. There's another project at 5180 Peachtree Industrial, is that right?
Correct.
Okay. All right, let's
So
move forward.
he was just asking me about the status.
Understood. Let's move forward in time, maybe one more page, Lindsay, to April 8th. On April 8th, Antonio writes, just wanted to make sure it's not going back in the queue. So he's just checking in at this point in April, is that right?
Mm-hmm.
Okay. Let's continue on in time a little bit to May 1st. That's another page or so. There's a very short email on May 1st in which Mr. Sample just writes, Michelle, any update? Your reply is in the email just above that, if you're still with me. And you reply about this other project at 5180 Peachtree Industrial, is that right?
Mm-hmm.
That's an address in, looks like Chambly from this table, is that right?
Yes.
For the folks today who don't live in town, like me, is Chambly near this North Druid Hills area that we've been talking about?
This is just a completely different property that he's doing engineering for.
And my
It's
question
just a multi.
is it near this one we've been talking about?
I don't know the proximity exactly.
Is Chambly near Brookhaven? Do you know?
Well, not really. I mean, it's in Dekalb County, so to me, everything's near. So, but it's not in the, it has nothing to do with this other project. 5180 and Peachtree Industrial and the other one have absolutely nothing to do with each other. We just happen to be talking about multiple topics under a single subject.
Okay. So your reply here on May 1st had to do with the 5180 Peachtree Industrial. Let's go up to Antonio's reply to that on also May 1st. He seems confused. He says, I sent the sewer action plan already. How soon can we expect the approval letter? Also, isn't CHOA doing sewer improvements in this basin? Do we go into this basin? If you know, Ms. Otts, which basin is it that CHOA was doing improvements in?
Northward Peachtree Creek.
Is that near the North Druid Hills property or near the Chambly property?
It kind of between.
Okay. Let's go back to the emails and go to the next one up. These are the ones that get a little exciting. On May 1st, still May 1st, you write back, I have, just a little bit below that, I have unbelievable news. Just received the model run. You are full approved.
Okay, right.
So he's changing this, in the previous email, he's changed the subject back to CHOA and the North Druid Hills project, right?
Yes, and when I responded, he had sent this. I hadn't seen it, but I jumped in and sent an email to him before I read this one. So, yes.
So are you testifying that this approval notice does not correspond to the North Druid Hills project?
Yes, I made that clear earlier. Okay. If you take a look at the emails at 9:26 a.m., I sent him still showing dry and wet capacity restrictions, SAP required for 5180. That's on my first. You look at it at 10:01, okay? 30 minutes later, 35 minutes later, I have unbelievable news. Just received the model run. So I was responding back to let him know that the SAP was not required for 5180.
Well, except isn't he writing you in the 9:30 email that he sent the sewer action plan already? Doesn't he think you're talking about something else?
He submitted a sewer action plan for 5180 because he had dry and wet restrictions. I'm letting him know that, yes, he sent it in, but it is no longer necessary. He's got full approval.
Okay, let's get to the end of this. I just have a couple more questions. Your response on May 1st writes, the official approval letter will not be sent until we return to the office. Did I read that correctly?
Yes.
All right, and then let's continue forward in time. Mr. Sample replies for some clarification. He says, does this mean a holding tank is no longer required? Let's go up to the next reply from you. You respond, all caps, no holding tank required, full approval. Did I read that right?
Mm-hmm.
All right, let's keep going forward in time. We're nearly to the end of this thread, as you can see from the binder. Mr. Sample writes back to you, what is the date on this email that Lindsay's just blown up?
The 14th of July.
And he says, our owner has requested a letter similar to attached that you provided for their other project. This is for the Druid Hills mixed use project. Is this something you can provide? Did I read that correctly?
Yes.
And Lindsay, does this email make it sound like there's an attachment? I'm sorry, Ms. Otts, does this email make it sound like there's an attachment here?
Yeah, he's asking for, what it was specifically was the memo that I gave him for the other project that ended up with full approval. Since we're not giving official letters, we haven't been sending them out. Sometimes developers need it for closing or stuff like that, so I offer a memo to let them know that the approval is forthcoming versus an email chain.
Lindsay, can we take a quick look at that attachment?
It's the last page on this tab.
That's right. And so and indeed, this is an approval, a temporary approval letter for the project at 5180 Peachtree Industrial. Is that right?
Mm-hmm.
And so Mr. Sample in that July 14th email was asking for a similar letter for North Druid Hills, correct?
Yeah, he was asking for a memo with regards to the conditional approval for the other one.
And if we could just close this out by going back to that email thread to see your reply, and then we'll move on. You reply on the same day. Yes, but it may be tomorrow morning before I get it completed. Did I read that right?
Yeah, I told him it would be the next morning before I could complete the memo for him.
Okay. All right. Well, let's move on to one last subject. I know everybody's been here all day, and we appreciate y'all's service and continued attention today. I do want to talk just for a couple minutes about these models that you have run and that we have looked at. So am I correct that your conditional approval of the present project comes from a model analysis based on the calculated figures for this actual proposed redevelopment?
Mm-hmm. When we're specifically the 6 acres.
6.7 acres. So your alternative scenarios, they involve 27 acres of redevelopment, correct?
Yes, what they were was the 6.7 acres that was already in the model, that flow, and then we added the cumulative flow at 24 units per acre of the remaining 21 acres, and then came up with that model run. That volume was then pulled out, and then we put at 56 units per acre in. Because those were assumptions. I can't leave them in the model because they'll hold other projects up. They weren't official submittals. It was just analysis.
So these assumptions, there's not some application that actually has those figures on them somewhere?
No, I have an email that says to my modeler, I need you to do 21.5 acres at 24 units per acre at times 2.5 of peaking factor. Here's the flow I need you to model so we can look at this, and then the same thing.
So these are numbers that you just made up?
No, I didn't make them up. I did it based on the densities, using my engineering judgment as a professional engineer. Let's get a rough idea of what the peak flows would be and what would the system be. How would the system be affected by those flows based on those densities based on zoning?
But you would agree that these are hypothetical redevelopments?
Absolutely hypothetical.
So your conclusion that this 8-inch line needs to be upgraded to 12 inches, that's a conclusion based on the assumption of 27 acres of redevelopment. Is that correct?
Yes.
All right, if you give me just 1 second, that may be it. Actually, I do have just one more question. Going back to your emails with Antonio. On July 14th, you mentioned that you would send that approval memo that he had requested. Have you sent it?
No, I did not. I told him that I didn't get a chance to do it. I got caught up. I'm going to say I'm sorry. My brother's in the hospital. He almost died. He's waiting on a heart transplant. So he did not get the memo. He said it was no big deal in a phone call.
I'm sorry to hear that. When is he going to get it?
I can write the memo at any time because it's a memo just stating what's in this. So I haven't gotten it to him.
Okay, that's all the questions I have.
But I had a phone conversation and there was no rush on it. So,
Any other questions, Ms. Peterson?
That's all the questions I have. Thank you, Ms. Otts.
Thank you.
All right, I'm gonna make a statement, to see if the panel has any other questions. Is two things. Number one, the 8-inch to 12-inch upgrade, you said that would be required. I just heard that for 27 acres, not the 6.7.
We know for certain the 8 to 12 will be happening for the 27 acres. The size of the upgrade of the 8-inch that we have the problems with, maybe only a 10-inch for the smaller development. I can't speak to that until we physically put the numbers in the model. We change those pipes and see if it fits. Because if this development, only this part of this development, it may not have to go to a 12-inch. It may only go to a 10-inch that they have to replace for themselves. But if that whole thing gets developed, based on my engineering, I would expect it to at least be a 12-inch.
But it may not even have to be upgraded for the 6.7.
No, it will. No matter what, that will happen. But
we're talking about the 6.7, not what if the 27, because it's already developed. And you're going to plan on upgrading that anyway as your future plan eventually, correct?
I can't speak to that.
Well, if nothing happens, you're stating your professional opinion that it's going to be needed to be upgraded as it exists today.
As it exists today, no. It can accept the flows that are in there, that are going on, the type of density that's in it. What is tipping the scale is this development now. That's maxing out, and the ones that are coming, yes.
Okay, well,
that's tipping the scale.
I understand that.
Yeah, okay.
But I thought I heard you say that you would have to upgrade that for the redevelopment of the 27 acres. The 27 acres aren't being redeveloped, only the 6.7.
Correct. But if the 27 is, there's a significant upgrade that would be developer-driven requirement.
It's already developed.
I understand, but if it gets redeveloped at the higher density, a higher flow will enter our system.
Oh,
just because it's developed in
right?
that doesn't matter, because the density is going to go up, so the peak flow is going to go up into our system, which is going to, be more than what these pipes can handle.
But you would agree that's a what if.
That's a what if.
The net change is the 6.7 acres. That's the only change that's occurring if it annexed into the city.
And it right now it's pushing it over. So either they would have to do the sewer action plan, or they could upgrade the system.
I'm clear on that. I'd rather focus on that rather than a what if on the 27 acres.
Okay.
Could be redeveloped in the next 20 years or whatever.
Okay.
I don't think that's appropriate, to be honest.
Okay.
But I will state, that you're a professional engineer, you're a very professional person, and you have stated on the record and under oath that this email is regarding Peachtree Industrial as opposed to this, and I, for one, appreciate that and believe you. So I don't think that should be addressed any further, in my opinion. But.
Yeah, I just want to state that, when Antonio changed the subject within the email and asked me, in addition, can I, it probably would have behooved me as a professional to start another email chain. So I apologize for that, but I was responding to his question. Yes.
Okay, thank you. Anybody from the panel have any questions?
Sure. So your department does this type of analysis and certification for the entire county, regardless of if the property is in unincorporated DeKalb or inside the municipal limits of any of the 13
Correct.
cities. And when I'm looking at the sewer capacity evaluation request, I actually don't even see a place where you indicate if the project is in unincorporated Gwinnett.
It doesn't matter.
Check, sorry, DeKalb. Nor do you check what city it's in. You do put obviously the address is listed, but from your staff perspective, it does not matter if it's in a city or in unincorporated, as long as it's inside the limits of DeKalb County.
They're our customers.
They're your customer, and you take care of it. So I think we've heard several times today, if a property is inside a city are also bound by this. They can't issue building permits. They can't issue LDPs without without a certification from your team being on file. The other thing, back to the two models. Let's say, so the 6.75 acres. Right now, they have conditional approval.
Yes.
Regardless of if it's an unincorporated city, they have conditional approval if they have a 100,000 gallon holding tank. That can be accommodated. So then you ran two additional models, and this, one was that if the other 21 acres were redeveloped with
24 units per acre.
and then the second
56 units.
56, 24 and 56. And so Ms. Peterson asked you where those numbers came from, and you said, I didn't make them up, they're my, I think what I heard her asking, what I'm interested in is, where did the 24 and the 56, what prompted you to run those models with those
Because
numbers?
in discussion for this, it has to do with the zoning densities of DeKalb versus the allowable zoning densities of Brookhaven.
Okay, so it's not
willy-nilly.
It's not, well, I know, but it's not from the city of Brookhaven, it's not from related development, it's not from any applicant. It was purely as part of preparing for today's testimony that internal to DeKalb discussing or helping you prepare the testimony, let's model it if the entire site was developed at 24 and 56. That's where those numbers came from.
Yeah, I was looking at worst-case scenarios based on the allowed max densities.
Right. And if hypothetically these properties were to be annexed into Brookhaven, and at some point in the future a application was filed to redevelop those 21 acres, you would then run the models in details, and you would say yes or no.
Right, an official request would be put in,
right,
and then into the system and then tracked.
And if the answer came back, you'd have to put in, I don't know, a 400,000 gallon holding tank or something, or you can't proceed would be
that could be the possibility, yes, or upgrade the design itself, or what the options are.
That type of analysis and that answer from your team is regardless of where it is.
Correct.
Inside the city or outside of the city. As long as it's inside DeKalb County, you have, and the consent decree, of course, applies. That's it, I guess. The consent decree is with DeKalb County, not with the cities. The cities aren't signatories to the consent decree, but you provide sewer services as the county through the SDS to the cities, so you are bound by the consent decree, and since they get their sewer services from you,
they are also in essence bound.
Limited, because you're limited. Right?
Well, the big thing, and when I've met, because I have to meet with the different cities and that, and it's very important for them to understand that if they knowingly issue a permit without getting that approval, because my division, I have met with them personally, with my city liaison, who is one of my staff members, to make it very, very clear. If you go and you do this, you're going against the consent decree, and not only will DeKalb County be in trouble, the city is just as responsible for the environment as we are. So they are bound, even though they're not part of the legal document.
You've trained the city staff to be very careful, make sure you don't issue, because you're going to get people either in big trouble, or they're going to have...
Or they're going to have a development that they can't connect.
Right, a developer who's built something, and you're not going to allow them to connect into the system.
Yes, sir.
Yeah, thank you.
Mitchell?
No, I'm good.
Doctor? I'm good. Chairman?
I think mine's maybe answered here. What I think I'm hearing is it doesn't matter whether this is annexed or not. If this development was proposed, whether it was part of the city or the county, your analysis is still going to be the same.
Same answer.
Result in the same action plan or not action plan, whatever the model shows. Okay.
Yeah, it doesn't matter who you are. It doesn't matter. I mean, DeKalb County parks,
The only effect of the
businesses,
annexation
schools.
on this is the potential higher density.
Right, and because my concern is the cost, and I can't make any guarantees in 5 years that a sewer action plan will be allowed. So the big thing is it's either upgrading all the failing areas. So that's the big thing for me, is I want the limitation known of what we have.
All right. Thank you, ma'am.
Thank you.
Let's recess until tomorrow morning at 9 a.m. and you'll call your final witness. And then Ms. Peterson, you'll be ready to go after that with your witnesses, and hopefully we'll get done before dark 30 tomorrow. Anybody else have anything for the good of the order? Ms. Peterson?
Thank you, Mr. Chairman.
Mr. Ack.
No, I was waving you goodbye. We'll see you at 9
Oh,
a.m.
were you? Okay. Thank you all for your attendance, and we'll see you tomorrow morning at 9 a.m. Dr. Mitchell knows where it is now.
Sorry about that.
Thanks, everybody.
Let me check on my email.
I think this facility is locked and it's only open because we're.
Well, they can steal these binders if they want to.
I was trying to make sure we're at the same conference room tomorrow.
Should I hang this up?
I'll get the very pieces of plumbing.
We can leave stuff.
My book you were using, that was mine. Can I
This
get it?
one.
Thank you.
Sorry, I was just trying to stack. I'm stealing your info.
Gee.
You got to carry stuff? No. They were just checking that, that we're in the same room.
Miss West, can I eat my popcorn now? Not there. Okay.
Not laughing.
Round with fun.
All right.